Good morning, everyone.
Good morning.
How are you?
Good. How are you, Russ?
I felt like I was at a really cool spot with that music in the background. I didn't know if I wanted to sit down on the couch and relax or get up and start dancing around.
Don't even need my coffee this morning.
Good morning, Sandra. Nice to meet you.
Oh, good morning. Very nice to meet you as well.
Good
And good
morning,
morning,
Sandra.
Shannon. I think you're the DJ this morning, Shannon. Was that your pick?
No, actually, I've given up the reins of DJ and passed things over to my colleague Daphne.
You
So
know what? So
we
that
have her
makes
to thank for the good beats this morning.
Daphne, does that make Shannon the OG?
Yes, it does.
I am.
We're gonna have to get you a crown or something. Tiara.
The family law now OG.
That's right.
It's been well, this is our third summit that we're doing today. But our virtual event series, guess it's coming up on 4 years.
I know. This is
Oh, that's,
incredible. We were
that's
just talking
amazing.
about this yesterday, Shannon. We were saying, you built this from scratch. We said, let's start doing this, and look what it evolved into.
I know it's amazing and it's really great. So for those who are on the call now, we'll get started in a couple minutes, but I just want to just quickly introduce Sandra, who's joining us from the Denise house. And our event today will be supporting the initiatives. I don't want to steal your thunder, Sandra, so I'm going to leave it there for now. But looking forward to hearing from you, and it's really great to see that we've been able to do this and it's going to a great cause. So looking forward to hearing from you.
Yeah. Thank you so much for participating today, Sandra.
Oh, this is my pleasure. Really, thank you for having me.
All right.
And
And sorry,
sorry,
go
you go
ahead.
ahead, Russ.
We've got a few housekeeping announcements that we'll do at 9, but I want to thank everybody who's joining us live on YouTube as well. Streaming. Just for the lawyers watching live on YouTube, if you want to qualify for the CPD credits, we need you to register on Zoom. So we have a record of everybody who signed up and participated. Just a pro tip there, just in case you weren't too sure, but I'm sure you found us here today, and we can certainly put a link into the Zoom if you want to join us on Zoom. So we have, last time I checked this morning, 750 people registered for combined for day 1 and day 2. So is that close to a record for us, Shannon?
Yeah, it's close to last year's, but it's definitely beat it. And yeah, we're really looking forward to hosting everyone again. It's amazing that it's already been a year. It feels like we were just doing this a few weeks ago.
I know. It's time just seems to fly. And when we do these presentations, I know Daphne's experienced this. They're 1 hour long, but when you're done, it feels like 5 minutes, right, Daphne?
Oh yeah, they fly by.
Yeah.
Time passes in a different way when you're doing a presentation. It just speeds on by.
Yeah. 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 So I think, yeah, it just feels like 3 weeks ago, Shannon, you're right, that we're back here for the second annual summit.
Yep, and another great lineup of speakers that we have over the next couple of days that I'm really looking forward to hearing from. Some that have been on our program several times, and then we also have some new faces joining us. So I'm very excited.
And we have the OG, Aaron Franks,
We
coming back,
do, yes.
coming back with Adam. This is a fan favorite, the 2024 case law update.
Yeah, we had a lot of really great feedback last year from Adam's presentation on the case law updates. It'll be nice to hear from him again and have Aaron join him. So they'll actually be coming up just after Sandra shares a bit about the Denise house.
Yeah, so we're minutes away. And I think I haven't read it yet, but they usually put together an excellent annotation of all the cases they talk about. So that's going to be a super valuable resource to share with the audience as well. Well, we got 9 o'clock. I want to thank everybody who's joined us, and like everybody who's live streaming on YouTube. Really appreciate you joining us today. Early bird draw will be at the end of today. So if you've registered early, we have a $250 Amazon gift card that we're going to draw. So stay tuned for that. Thank our sponsors, Supio and Bridgepoint North. You'll be hearing from both of them throughout the 2 days. What we decided to do is they're supporting the conference. We simply turned around and redonated that money to the Denise House. So there's no, all proceeds are going to the Denise House today. Super excited that they have agreed to support this. Just on that note, I know that when I attend these conferences to get CPD hours, they're usually $250 to $500 just for the registration fees. This is virtual, so we have very low overhead, but I'm going to ask everybody to consider donating 1 hour of their time, whatever the value of that is, to the Denise House. There will be a link that will go into the chat that you can click on. We've already had people donate so far. I think we're just, last time I checked, Shannon, were we just over $5,300, I think?
Yes, we are actually just over 5,400. So
Perfect.
yes, thank you so much for everyone's generosity so far. And we're looking forward to seeing how much we can do to increase that and support, increase our support for the Denise House over the next couple of days.
And our goal over 2 days is get to 10,000. And I know we'll hit it with the support of our colleagues. So what do you think, Shannon? Is that realistic? We're going to hit it. We're going to surpass it. What are your predictions?
I mean,
Last year was 7,500, right?
pardon me?
Last year we came in at around 7,500.
Yes, we did. And we're going to surpass it. I have full confidence.
All right. Okay. So let's, what's next, Shannon? We want to talk about our speakers for a minute.
Yeah, so we have quite a lineup of speakers over today. So I want to be mindful and give Sandra some time to speak about the Denise House. So I'll take a minute to introduce Sandra in just a moment. But before I do, I'll just let you know that we have several presentations today. There'll be several 1 hour presentations. There'll be 15-minute breaks in between each of the sessions. We'll also have a 1 hour lunch break. I'll drop a link in the chat so you can see the full agenda for the day, so you can know what to expect over today as well as tomorrow. It is one live link for the day. So if you're able to attend certain presentations but have to hop off for other things, you can log back onto the link, or you can stay on the link all day. We'll be here. So on that note, I think that takes care of the housekeeping for now. I'll get to some more once we finish the Denise House presentation. So I'll get started. For those who are just joining the call now, I just want to introduce Sandra McCormack of the Denise House. We're so grateful to have you here today, Sandra, to have you share about all the great initiatives that you're doing at the Denise House. Like I said, I don't want to steal your thunder, so I'm going to let you speak to all the great things that you're doing for our community there. But I would like to take a moment to introduce Sandra. So Sandra has been working with Sedna Women's Shelter and Support Services Incorporated, also known as the Denise House, since February 1985. Coming from an administrative and nursing background, she started her career with Sedna as administrative support and program development and was promoted to executive director in 1989. Sandra has been working to support abused women and their children for more than 39 years. She has extensive experience and knowledge, as well as a strong commitment to develop and sustain community partnerships to create a supportive continuum of services in Durham region. So thank you so much for being here, Sandra. Again, I know there's just some people jumping on the call now, but our event today will be, we've already had our generous sponsors support us in the form of a donation to the Denise House. We also have the option for attendees to also donate. So I dropped the link in the chat. But on that note, I'm going to pass things over to you, Sandra, to take the floor.
Wow, thank you very much, Shannon, for that lovely introduction. And again, it's a real pleasure, and I'm very grateful for the invitation today to talk a bit about the Denise House. And yeah, so as mentioned, I've been here for close to 40 years, but that says that the Denise House, we've been providing services to women and children in our community for 40 years, which is a long time. So you can imagine that we've not only have we seen a lot of change in the landscape of providing support services to women and children, but we've also undergone a lot of changes ourselves as an organization. One of the things I just wanted to touch on initially is the issue of violence against women, intimate partner violence, gender-based violence. You've heard perhaps all of those terms, and what it really means is that women are indeed being harmed, and in all too many cases are being murdered, quite frankly. Our provincial association many years ago started compiling statistics around the tragedies of women being murdered in Ontario. And to this point today, from November of 2023, 49 women have been murdered in the province of Ontario. In the month of August alone, 7 women were murdered by their intimate partner violence. So that's why it's important for support services like the Denise House and others, I'm sure, in all of your communities, to continue to provide those support services that are so desperately needed by women. One of the big initiatives that is happening in the landscape is the declaration of intimate partner violence as an epidemic. And certainly the province of Ontario has now signed on to that. And we are participating in trying to move that agenda forward so that we can continue to build resources for women in every community within this province of Ontario to help keep them safe, help themselves keep themselves safe, and to provide a better way of life for themselves and for their children. So that's one of the initiatives that we do in terms of advocacy and believe strongly in that. But on our day-to-day, we do provide safe crisis beds for women, both without and with children. So all are welcome. We currently have 27 beds that we have in our residence, and we're staffed 24/7 by very wonderful, well-knowledged and skilled staff that provide those support services to women and to children when they arrive to us at the shelter. Essentially, the shelter is about assisting a woman on her journey from the time she arrives at the shelter to the time she leaves. Our role really is to support in any way. One of the very first things that we do is safety planning. It's very important for women and children as well. And then, we talk about what are your goals? What can we support you with in the next 2 to 3 months? That's essentially the length of time families are with us. So what can we support you with? How can we help you through on this journey that you're now on, you chose to be on? And what other community supports can indeed help you as well? And let's get you referred there. Let's get you connected. One of the other roles we play in that whole piece is case management. As women are reaching out to other community supports, it's really important that we as organizations manage that same client in a way that's helpful and not chaotic for her. Sometimes having a lot of people involved can be very confusing. So case management is also important so that any one of those connections, certainly with the shelter and other services like mental health or addictions or health services, certainly helping children through the school system, is managed in a way that is helpful and not frustrating for that client. While women are in the shelter, we certainly provide all necessities in terms of personal items, and oftentimes women leave with next to nothing for themselves and for their children. So we do our best to help provide all of those necessities for them. And then also assist in helping them recover or retrieve some of the things that they were forced to leave behind when they first arrived at the shelter. So as I mentioned, families stay approximately 2 to 3 months. That's longer than typically some years ago because of, as I'm sure you all know, that the housing situation, I'm sure, is critical in all of your communities. Certainly here in Durham Region, it is. Women have a very difficult time moving on to something that's safe and affordable for them. So that's a big piece of work that our housing support workers assist and follow that journey with women on. Shelter is one part of our service. We have community outreach and support services as well. Women that leave the shelter often stay, mostly do stay in connection with us as they move back into the community and try to rebuild their lives. They continue to connect with our outreach staff for support and perhaps other referrals, going over their goal plans. Things change for them, how things are working for them as they work with other system supports. So that's a very critical piece of our work as well. As I mentioned, we have 27 beds in the shelter, so we see as many as about 225 women and children each year. In our community support services, we see as many as 500 women on any given year that come through the shelter, but also women in the community that don't have the need for the shelter beds, but have the need for that kind of support service as they make their journey through their life. So we do see on average 7, 8 plus women in different ways on any given year, as well as children. So that particular part of our program evolved only about 20 years ago. So it's become a very, very critical part of our service. The other area is children. Children have very, very specific needs over and above their mums. And so we've actually developed quite a comprehensive in-shelter children's program, as well as an outreach program for kids. And what we find is children need that special attention to their emotions, their feelings, their how they feel about what's happened to them, where they are, and how they need to go forward, and how they can continue to work as a family with their moms. So that's another piece of critical support services that certainly has evolved over the years as well. I mentioned housing, and it's really has become an incredible challenge for women. As I mentioned, I'm sure you're aware of the critical shortages, but for our women who, for the most part, at least about 85% are on assistance, trying to make that money stretch to pay rent and groceries and other necessities of life is near impossible. So I don't know how that's going to play out over the next few years, but I certainly do know that it is becoming more and more of a challenge for women. And quite frankly, more and more women are choosing to not make a move because of what oftentimes they're facing in terms of financial restraints and where do they go? How do they put a roof over their head? How do they, feed themselves and their children? So there's many complexities around women staying, women leaving. Why don't they leave? Why do they leave? The challenges that they're facing, all of those things. So those are some of the counseling pieces that we do speak to women about as well. So those are our current programs running. And as Jenna mentioned earlier, we are on the move very, very shortly. In about 6 weeks, actually, our new shelter build will be ready to take occupancy. We have been on that journey for, nearly 12 years now, looking for property, looking for capital funding from both the federal government and the provincial government. It's been a long, oftentimes disappointing journey, but eventually we got there. And about 2.5 years ago, we were awarded $15 million capital grant from the federal government, Capital or Canada Mortgage and Housing. And we began construction in April of 2023. And as I mentioned, we're looking forward to moving in about 6 weeks' time. So what this does for the Denise House, certainly, but for women and children in our community, is this new location, we've increased our bed capacity to about 35. And the building is fully accessible, which is something that we have long known that is needed both for our clients, for our staff, for our volunteers. So we're very looking forward to having that accessibility. We also have pet accommodations there for larger breed dogs. We've always welcomed family pets. We've had to restrict the larger dogs because we just simply don't have space, but now we will. And any of you out there that are pet owners, you know how important family members they are, and it's important that they always accompany women to our services. So we'll be able to offer a greater ability very shortly. So we're looking forward to that. I think what this means, though, for our community, quite honestly, is, as I mentioned, the numbers of women and children that we see over the course of every year. Equally, though, we've had to turn women away because we don't have the space, we don't have the beds, we don't have the capacity. So I think with this move that we're about to make, we've opened up additional beds. We have very much increased our capacity to respond to the women's needs in our community, and we're very much looking forward to that. So it sets up a new chapter, certainly in a journey for the Denise House, but I think equally, but probably more important, it offers the opportunity for greater services to women in our community that we know is needed there based on the number of calls that we get. So the other piece, though, too, is our partners, our community partnerships that we have. Critically important that we continue with that and invite them into our new space so that we can collaborate on some service for our women and kids, and because that's the most effective way that we can truly help the women in our community. So I think on that note, I think I've perhaps talked about the Denise House and perhaps given you some information.
Yes, thank you so much, Sandra. We really appreciate it. No, it's not easy work, but it's very important work. So thank you so much for what you do in our community. And we're very honored to have you here and hear from you and understand what the donations will go towards and how it will be supporting the women and children that your organization continues to support. So thank you so much.
You're very welcome. And one of the things, it's incredibly surprising to us how generous the community is. Not so surprising. We know we have a very generous community. It's unfortunate that we do have to rely on that community generosity, but I also think that it's important to engage our community to make them aware of things that are happening around them as well. We are ever so grateful for every dollar or any donation of any kind. There is always a place for it. There's always a purpose, and there's always a woman to support. So we are very, very grateful and honored that you have chosen the Denise House to support. So thank you all for certainly your presence and also for your support. We appreciate it.
Yeah, thank you for the great work you're doing in the community. It's just shocking how many women died in August. I had no idea the number was that high. You hear about it occasionally in the news.
Yeah.
But that's just a staggering statistic from a month or two ago.
It is. And I think that that's why there's such a strong advocacy going forward now to really talk about this declaration of an epidemic, because I don't know how else you describe that, right? And we now look coming into the fall to the provincial government in terms of now what? How are we going to increase capacity of all services to try and help and provide support and stop this, keep women safe.
Yeah.
Yeah.
Thank you so much. I really appreciate you telling us about your services and putting a face to the program. So that's really insightful.
Thank you very much. I wish everyone just a really wonderful day, 2 days, and it sounds like really wonderful time. Kudos to the organizers. It's yeah, incredible what you've done.
Yeah, we got a very, very great team of support, not just on the screen, but behind the screen, doing tech techs and marketing and get the word out there. So thank you for that.
Okay, wonderful. Have a good day.
So much, Sandra. You too. Take care.
Bye.
And just on that note, I checked quickly, Jonathan Painter, thank you for the sponsorship. And Shannon, you even made a sponsorship too. So thank you, Shannon.
Yeah, of course. It's it's like I said, it's really good to hear. I mean, obviously it's not great to hear what's happening, but appreciate Sandra being here to help, like you said, put a face to it and really understand what's happening and how this will help those women and children. So
we got the OG Aaron Franks coming up on deck. A couple more announcements, I think, before we bring him on.
yeah, so before we have them come on, so we'll have a quick 5-minute break, almost 10-minute break before they come on. They'll be back on at 9:30. And really looking forward to it. I know back by popular demand. I know this is one of the favorites from last year, so really exciting to hear these cases from this year and the updates and insights they have. But before that, I just want to mention that you will probably notice that the Q&A has been, the chat has been disabled. However, you can send in any questions you have through the chat. And I will also just drop one of my colleagues' emails into the chat as well for now, in case you have any general questions or need any support throughout the presentation. My colleague Nicole will be on standby. Like you said, we have a lot of people behind the scenes too who are supporting this.
We did get a question in. What can we do for, oh, sorry. Did somebody answer the first question? Are we able to get a hard copy of the presentation, or will there be information provided post-presentation? So there's show notes, right? We're going to follow up afterwards, Shannon?
Yes, exactly. So we will have show notes that will go out after the event, so that they will be available to you following that if you want to do any deeper dives into any of the topic areas. But we will also have some of the speakers have provided resources that I'll also be sharing throughout the day as well. For example, Aaron and Adam's case law update coming up. They've put together a great paper with resources on the cases they'll be discussing. So I'll share that with all of you as well. And the Q&A. So you can send in questions through there throughout any of the presentations, and the speakers will do their best to answer your questions throughout. Myself and my colleague Daphne, who was on the call earlier, will be behind the scenes during the presentations if you have any general questions about the event for us too. And I will put our agenda that you can expect to see over the presentations that you can see over the next couple of days in the chat as well. And you can see there what programs have been accredited by the LSO and how much they count towards for the CPD hours for all of our lawyers joining out there. And I think on that note, we'll go to break. But before I do, I will just mention too that we really appreciate everyone being here today and logging in. It's really great to see such a great turnout again this year for our third summit. But we would love to know who's in our audience today. I know our speakers always like to understand that and know where everyone, what field or profession they're in. So I'm going to launch our first poll, and then maybe we can go to a quick break before we have Aaron and Adam come back.
You can take, let's launch a poll. Grab a coffee now quick if you need to grab a coffee for our audience members. But we can also go through today's lineup as well, right, Shannon? And let everybody know what we have coming up.
Yeah,
so
absolutely.
The first poll is, tell us a little bit about yourself. You have a lot of choices there. If there's an other, or if they don't apply, put your answer in the Q&A box, and we'll certainly share that with the audience. You also want to state whereabouts from the province or the country or the world you're coming in from. You can put that in the Q&A box too. It's nice to see. Oftentimes we have colleagues coming in from the United States, Europe, Far East, so let us know where you're coming in from. So lineup, we have case law update, and what's next, Shannon?
So following that, we have Brian Galbraith, as well as a couple of,
Another OG, right?
he is an OG as well.
Yeah, all
Yes.
the veterans are coming in for today.
Yeah, we've had Brian on our program several times, and it's always really great to hear his insights. And today will be no different. He'll be talking about how to become a super communicator. I love all of his presentations. I know he's very much a collaborative professional and always has some really great insights there. So him and his colleagues, Alex and Christina, have a two-part presentation. So very excited to hear from them. And then we'll have a lunch break following their presentation from 12:30 to 1:30. And then we'll be back with Carrie Heinzel and Jonathan, who are also OGs, have been on our program many times. And I know that you have done this presentation with Carrie and Jonathan many times and have had a lot of great feedback. So I'm excited to hear. I know you're always kind of updating it and sharing new insights.
Impasse, lawyer's guide, how to get through impasse. So oftentimes when you're negotiating, you hit an impasse. A lot of cases fail at that point, especially collaborative practice cases. They run off to court. So we're going to talk about some tips and tricks to get through impasse. We did this presentation at the AFCC in Boston this summer. It was a lot of fun. The audience was super interactive. We just did it recently in September for the Durham Region Collaborative Practice Group. So we're super excited to be presenting that again today. I think you're going to find it very interesting. And then the art and magic of option generation up after that. What's that all about, Shannon?
Yeah, so I'm excited to hear this. This is a new presentation from Carrie and Jonathan, as far as I'm aware, anyway, new to me. But again, very focused on collaborative practice techniques from what I understand. Really looking forward to that. And then following their presentations, we're going to finish off the day with ethics and strategy, best practices for navigating divorce and separation. And we have a couple of our colleagues, Stephanie Brooks and Golan Euron, who will be joining us, and then another family law lawyer in our community, Abby Adusi, which I'm looking forward to hearing from her as well. This is the first time that she's been on, I believe she's been on a podcast with you before, right, Russ? But not on our virtual event series yet. So
super excited to have Abby back. We're going to be looking at the rules of professional responsibility. A lot of traps and problems that family lawyers get involved in with respect to conflicts of interest and the rules and their clients. So we're going to talk about the ethics surrounding your legal strategy and give you some tips and tricks in terms of best practices and looking at some case studies as well. Also, we'll talk about if the Law Society comes knocking on your door, how do you respond, and give you some tips to work with with the Law Society if they should have any questions regarding your practice. Not something that everybody likes to talk about, but very important topic, I think, for our audience today.
absolutely.
And then we forgot the early bird draw, right? And somehow we'll wrap up with some tips for day 2.
Yes, so following that presentation, we will be doing our early bird draw. So we had an early bird promotion. So anyone who signed up prior to September 1st was entered into the draw. So we'll be drawing the name today, and our winner will receive a $250 Amazon gift card. So exciting stuff today.
Let's see what our poll results are. See, 5 minutes goes by quick, right? Oh my
It
God,
does.
it's time to get started. So tell us a little bit about ourselves. Let's find out who our audience is. 66% lawyer, family lawyer, 19% lawyer practicing in another area, 7% family professional, law clerk. A lot of law clerks here today. It's great to see law clerks. 7% professional in other field, 4%. So we've got an audience full of professionals today. That's super great because we've got some interesting topics tomorrow. Some very advanced topics we're going to be talking about, but we'll get into that at the end of today.
Yeah, you put together a great lineup, Russ.
Me? That was you.
Yeah. No, we definitely have a dream team here today. So very excited. Want to thank everyone again for being here, and we're looking forward to, like you said, a few minutes goes by fast. We should have Adam and Aaron joining us in
It's
just a
off.
moment.
It's 9:30 and here they come. Look at
Oh,
that.
there they are. Magic.
Asking you shall receive. It's the dream team. Thanks, guys, for showing up today.
Thanks for having us.
Good to have
Welcome.
you back, Adam.
Always happy to be here.
I actually got to meet Adam for the first time in person this year, so it was great meeting you. Like we had done some stuff virtually, but it's nice to see everybody back again.
He's very tall,
I realized that. What, 6'5"?
6'7", but who's counting?
6'7". Oh, okay. That is tall.
Hard to tell on the Zoom box. I wouldn't have known. All right, well, now we know Adam's height, but I'm going to tell you a little bit more about our speakers who we have joining us. As I know, a lot of our attendees on the call are lawyers, so I'm sure a lot of you are familiar, but for those who aren't, I'm going to take a moment to introduce Adam and Aaron before they get into their case law update. So Adam is a partner at Epstein Cole LLP and has worked there in some form or another since 2013. Adam was called to the bar in 2013 after completing his clerkship for the Senior Family Justice, the Associate Chief Justice, and the judges of the Ontario Superior Court of Justice. Adam has authored and co-authored numerous papers. He has presented for the Halton County Law Association, ILCO, the OBA, and the LSO, and some other places with acronyms. Adam is an adjunct professor at York University. Adam co-authored Unpacking Family Law for Practitioners with Justice Melanie Kraft. Thank you so much for being back here, Adam. Looking forward to hearing from you again. And next we have Aaron Franks, who was called to the bar in 1998. Since his call to the bar, he has practiced exclusively in the areas of family law and in the defense of solicitors' negligence claims. He's an adjunct professor at the University of Toronto Law School and was previously an adjunct professor at Osgoode Hall Law School. He was formerly an instructor with the family law section of the bar admission course, and he is a dispute resolution officer for the Superior Court of Justice in Toronto. He has co-authored This Week in Family Law since January 2020. He is presently the editor-in-chief of the Reports of Family Law and was associate editor since 2005. Aaron is a regular contributor and speaker at continuing legal education programs, and he's authored papers and chapters in several publications on family law issues. He is also listed in Lexpert and Best Lawyers directories ranked in Chambers and Partners Global High Net Worth Guide and Family Matrimonial, and is a fellow of the International Academy of Family Lawyers and American College of Trial Lawyers. He is a member of the planning committee for the biannual National Family Law Program run by the Federation of Canada Law Societies, and was previously co-chair of the 6-Minute Family Lawyer for 8 years and on the board of Advocates Society. So thank you so much, both of you, for
And
being here.
everybody knows who Aaron is. Come on.
I figured, but
There's nothing worse than listening to somebody read your resume. I can't stand it. But if you have your mother write your resume, you too can have a resume.
If you don't know who Aaron is by now, you must just be starting off in family law, but great resume.
well, on that note, Aaron and Adam, I will let you take it away.
Okie dokie. Well, again, thanks very much for having us. We appreciate it. We are going to go through some of the, not necessarily the most important cases of the last year, but certainly some of the most interesting cases. We will sort of go back and forth as we go through them. If there's any that are of particular interest, we can get the list of sites to Shannon and Russell to pass them out. So the first one I want to deal with is a case from Justice Kraft in Toronto called Gerisimopoulos and Sambursky, which is actually, despite what I said before, quite an important case. It deals with parenting and mental health. Mental illness historically is very, very misunderstood. There is a fair amount of stigma attached to mental health, and it's very hard for sort of people to understand that, you know, when somebody suffers with mental illness, when they are unwell, but when they are well, they are completely and totally fine. It's very different from someone that suffers with a broken arm. Broken arm, you can see, you can understand it, but there is a stigma attached with mental health. And we hear words like depression or OCD or borderline personality disorder. There's a very significant stigma attached to these words, and Justice Kraft in her decision goes a fair distance, if not all the way, in trying to destigmatize people with mental health issues. So briefly, what happened in Garistomopolis, it was a fight over a parenting schedule with respect to kids that were aged 9 and 6. Father did have a history of suffering with mental illness, but he had successfully managed his condition with medication and seeing his psychiatrist. He had a good job. He earned a 6-figure income. Things sort of unraveled in 2019 and into 2020. First, the father lost his job, and then COVID hit. And it's shocking how many people decompressed during COVID, but he was one of the COVID victims. At the same time, his marriage started to unravel, and that forced on a manic episode in sort of the middle of 2020. He was arrested by the police. He was admitted to St. Joe's for 9 days. During that time, the mother took the children from the home, and that was the official end of the marriage. Father was released from the hospital. Mother, in the meantime, brought an ex parte motion for sole decision-making and a temporary restraining order and for temporary primary residence, which she was successful on a very short basis. At a case conference subsequently, the father agreed that he would stay 250 meters away from where the mother was living, but also agreed that the father would have some limited parenting time, 3 days a week, supervised by the mother's brother, for a total of 8 hours per week. So a fairly restrictive parenting regime. Over the course of the next several months, the father's life significantly stabilized. He followed his treatment plan. He found new employment. He remained under the care of his psychiatrist, Dr. Duff, and followed Dr. Duff's treatment recommendations. He moved out of the matrimonial home to live with his mother in Niagara Falls, and to show his commitment to the kids, he actually commuted from Niagara Falls to Toronto 3 days each week in order to have his supervised parenting time. Despite the improvements in his mental health, and in fact that his manic episode was long past him, all of his requests for additional parenting time were completely refused by the mother. In fact, he was only finally allowed to have his first unsupervised visit about 16 months after his original 2020 episode. In 2022, the parties attended parenting mediation. They agreed into a phased-in sort of shared parenting schedule. Father first started with 5 out of 14 nights and then increased to 6 out of 14 nights. And then in the final phase was going to be returned to mediation to figure out whether or not it could actually be a full-on equal schedule. Father continued to see Dr. Duff, was doing well, agreed he would continue taking his medication, agreed to refrain from smoking, drinking, and to keep away from all of his triggers. All of it went reasonably well until, unfortunately, the father experienced another manic episode in June of 2023, and even more unfortunately, it was witnessed by the children. The father's father became concerned because he canceled a visit that was supposed to happen. The father's father called the police to do a wellness check. Father wouldn't let the police in the door in the midst of his manic episode. The police had to break down the door in front of the children. The father had prepared a last will and testament while he was holed up in his home and had his 8-year-old witness his signature. It was just bad. Just generally a bad scene. The children later reported that they were scared. They just wanted to be able to feel safe with their father. This, of course, made the entire parenting plan that was reached in mediation completely unravel. Eventually, father regained his mental health. This time, the mother was not at all cooperative and actually took several steps to try to thwart the father's ability to try to set up another parenting schedule with the kids. Justice Kraft granted the father unsupervised parenting time, starting with 4 to 14 nights, increasing to 5 out of 14 nights at the start of the 24-25 school year. She also granted him sole decision-making over the children's sports and extracurricular activities. But the most important part is what Justice Kraft had to say about parents that suffer with mental health. And it's a roadmap for counsel with clients with mental health issues as to exactly how they should set themselves up to present to a judge to show that they actually can handle their children. They can be effective parents, even though they have mental health issues. Keep in mind, this may not work for children that are very young, infants, but once kids are old enough to sort of handle and to notice signs themselves, as I say, this regime will work. Justice Kraft noticed that the First of all, the mother had been asking for supervised access, so Justice Kraft goes on to supervise the conditions necessary for supervised access and notes that it's really just a Band-Aid. Supervised access isn't meant to be a long-term solution. She did find that continued supervision was not necessary, especially because of the regime that the father had agreed to enter into, and the fact that he was actually taking accountability for his mental health, and the fact that he did suffer with this mental illness and wasn't sweeping it under the rug. He also agreed to what Justice Kraft called a 6-part safety plan that was developed by Dr. Duff, his psychiatrist, including that the father was to contact the mother upon him sort of experiencing the aura or the feelings he would usually have before a manic episode. He gave permission for his treating psychiatrist to have open conversations with the mother. He gave the mother the freedom to contact the psychiatrist if there were any problems. Father agreed to maintain his medication. Father agreed to full release of his clinical records. And the children were also taught the signs of what to look for so that they could be on the lookout for things as well. Justice Kraft rejected the mother's concern that the safety plan required the father to self-report, and because of some of the mother's conduct, she actually came to the conclusion that the mother was not actually trying to help the father regain his parenting status, but was actually working against it. What Justice Kraft says, she basically repeats what Dr. Duff has to say, and that bipolar 1, which is what the father had, is a manageable condition, and if properly managed, people with bipolar can be very high functioning. That said, people are afraid of it. It's a difficult disorder to understand that someone can be unwell when they are unwell, but perfectly well when they are healthy. Dr. Duff specifically testified that the stigma of bipolar is that people still don't trust the person with bipolar or misjudge the person or blame things on them. So Justice Kraft really does a good job of sort of looking at this historically and undoing or a fair amount of the stigma that's attached with not only bipolar disorder, but with any sort of mental health illness. And while she notes that while no one can guarantee that the father won't have future manic episodes, the father is showing that he's prepared to bend over backwards to do everything in his power to prevent an episode. So it's a very important judgment to read. Mental health is sort of, I don't want to call it a cause celeb these days, but there's been a lot of attention paid to it. Justice Myers has written about it. Our former Chief Justice has spoken about it. And now Justice Kraft has written a very sensitive and nuanced decision about it. So it's an important decision for all to read, not only because of what it has to say about supervised access, but this is the first real judgment in a long time that deals with these issues sort of head on. So I commend it to you. Mr. Prewer.
So just off the top, there was a question. There's a paper that will be circulated that has all of the sites and the summaries that we're talking about today. So you don't have to worry about sort of rushing to write them down. So the case I'm going to be speaking about is JFR and KLL. It's a case from the Ontario Court of Appeal. And this deals with actually a very interesting and important question about how do you approach a parenting order for an adult child, which is always sort of a troubling term, but in this case, an adult child with a disability. The appeal involved M, who was a 26-year-old man living with Down syndrome. He could not live independently and had always lived with his parents. He was financially dependent on them. Initially, the parties separated in 2012, and M was a minor at that point. He has a younger sibling as well, who was also a minor, and the parties agreed to an equal timeshare arrangement. Everything was fine, and then COVID-19 hit. During the pandemic, the parties agreed that M would temporarily live with his mother to minimize the risk of exposure to the virus. Then in October 2020, the father sought to return to the shared parenting schedule that had previously been in place. The mother refused, and the father commenced an application. He brought a motion for an interim order returning the parties to the shared schedule. And it's very important, but M was not named as a party to the proceeding or formally served with notice of the proceeding or the motion. And he had no opportunity to make submissions. At the time of that motion, he was 24. The motion judge first determined that she had jurisdiction to make the temporary parenting order because M met the definition of a child of the marriage under the Divorce Act. Specifically, child of the marriage is someone who is under 21B, over the age of majority, and under the charge of their parents, but unable by reason of illness, disability, or other cause to withdraw from their charge or to obtain the necessaries of life. So here, the judge determined that M was still a child of the marriage because he couldn't leave his parents' charge due to disability. That followed that the court then had jurisdiction to make an interim order. What's interesting is the judge first made an order that there had been no evidence, aside from the mother's own assertions, that the shared parenting schedule was detrimental to M, either in a physical, emotional, or psychological sense, and ordered that the parties restore the full parenting schedule. Then the judge takes another intriguing step, which is that they ordered that the parties retain a social worker or psychologist to interview M, attempt to elicit his views and preferences within 6 months, and after that period, the order would, quote, become final. First issue that the Court of Appeal deals with, which is very interesting, is that this is to the Court of Appeal. And the reason why it's to the Court of Appeal is because the motions judge made a determination of jurisdiction. If it's an issue of jurisdiction, that goes to the Court of Appeal rather than where the normal path for a motion is, which is to the Div Court. The mother argued that M should have been named a party and had the opportunity to provide submissions at the motion. M was independently represented by counsel at the appeal, which the Court of Appeal had ordered. And as we will see, that was very important to the Court of Appeal. While the motion judge was alive to the issue of M's views and preferences, the Court of Appeal determined that having a psychologist interview them was no substitute for M's participation. And M was presumed to be a capable adult in the proceedings. The fact that he was not able to participate wouldn't be remedied by simply ascertaining his views and preferences prior to making a final order. And this case gets into the right to be heard, which is in Latin, the audi alterum partum, which is a fun Latin maxim, so rarely do we get to break those out. And it is in fact a rule of natural justice. And if you are in a court proceeding or a court proceeding is being made about you, you have a right to be heard and to have counsel. And the Court of Appeal really emphasizes the right to be heard is particularly important in cases like this that involve persons living with a disability. And as a result of that disability, they may be dependent on others. That doesn't mean they don't have a right to ensure that their interests are protected and their views are made known to the court. Dependence on others or incapacity in some areas doesn't mean that there is incapacity in all areas, and it certainly doesn't eliminate the right to be heard. Court of Appeal goes through a number of great summaries as to how the right to retain independent counsel works, how it protects the presumption of capacity and the right to make one's own decisions. It sets out that the presumption of capacity is only rebuttable under precise conditions with clear evidence. And those stringent requirements are necessary to protect the autonomy of people whose capacity is at issue. Court of Appeal set out that there are varying levels of capacity. So a person might be capable of making a basic decision, but not a complex one, or maybe they can make decisions about personal matters, but not financial matters. Capacity is, in the words of the Court of Appeal, a spectrum, and it is not an all or nothing proposition. In many cases, the rights, the capacity, and the voice of adults with disabilities can be lost, and the Court of Appeal is very concerned about that. The Court of Appeal talks about that not only is capacity a context-specific analysis, but the phrase withdrawal from parental charge in section 21B, or say 21B of the Divorce Act, is also context-specific. So an adult child may be able to withdraw from parental charge for one purpose, but not another purpose. And the court's focus should be on whether they're able to withdraw from parental charge in relation to the particular order sought. In this case, M couldn't withdraw from his parents' charge. He was dependent on them financially, but that didn't mean he didn't have a voice as to where he wanted to live, where he wanted to spend his time, and who would be his caregiver during that period. What is very interesting is the Court of Appeal set out that an adult who is presumed to be capable, including in cases where you're dealing with an order sought under the Divorce Act, and is potentially affected by the order in question, should be served with the notice of proceeding and afforded the opportunity to obtain separate legal representation and to participate fully. including in the adjudication of any capacity issue. So that is certainly very important for these sorts of cases. And the Court of Appeal doesn't deal directly with it, but you can sort of analogize here. If you're making a claim for child support for an adult child, all of those conditions would seem to apply. They're certainly adults, they're presumed to be capable, and they will be potentially affected by the order. So it may be good practice to actually serve adult children when we are dealing with child support related claims, which are not infrequent in our courts dealing with post-secondary expenses in particular. Oftentimes there are also situations where people are making orders that may infringe on the autonomy of a child. And again, it's when those children are adults, adult children, a difficult term, they need to have the opportunity to participate. The next case I'm going to talk about.
Just before you go on to your next case,
Yeah,
just in our continuing efforts to bring you the latest and uppest to datest, in Saskatchewan, a very similar case, and it looks like the Ontario case and Saskatchewan case were sort of proceeding in parallel, but the Saskatchewan Court of Appeal, just like literally at the end of August, released a very similar decision in a case called Albers, Aalbers. It's actually not in our paper, but a very similar sort of idea that an adult child with a disability may still have capacity in order to make decisions. So sorry for the interruption. On with
Watch
it.
the newsletter. I'm sure it'll be there.
Exactly.
The next one is a case called KMN and SZM. It's from the British Columbia Court of Appeal. Very important case for Ontario and indeed any province. This deals with what a court must and must not do when faced with allegations of family violence that are relevant to the best interests of a child. So there is a lot of really good writing here about how to deal with this. And while the Court of Appeal talks about this under the British Columbia Family Law Act, which is a little strange because it was a divorce, so it should have been under the Divorce Act, the language in the Ontario legislation, the Divorce Act, and the British Columbia legislation is strikingly similar. So this is definitely on all fours in terms of the things we have to consider as well. So when a court is faced with allegations of family violence, a court must meaningfully engage with those allegations. It has to analyze the evidence, needs to make finding of facts, and consider how this will affect the best interest of the child. The court must not limit its analysis to alleged violence against the child. A court must consider alleged violence against a parent and how that impacts the other parent's ability to care for the child. And this is really important. A court must not engage in myth-based reasoning about family violence. And the big myth that goes through the trial judge's decision in this case is that a myth that mothers will regularly allege violence against fathers to gain a tactical advantage in a family law case. This case involved very serious allegations of family violence. They spanned 3 years, so the entirety of the 3-year-old child's life when they separated. It included things as the father headbutting the mother, may have struck the child at one point as well. At one point at a exchange, the father grabbed his mother's cell phone and broke it. And at one point, after the father had headbutted the mother for the second time, she ended the relationship and she moved. The father then started a claim and got an order that she had to return back to the jurisdiction she was in. She had moved within BC, but 3 or 4 hours away. There was an interim order for parenting where the judge acknowledged that there were significant concerns about the father's violence and ordered that he had 1 overnight every weekend. And then this was expanded to 2 overnights per week. And that's really where the father's time stayed at, that 2 overnight a week level. At one point, it dipped down again after there was an exchange and the father assaulted the mother during an exchange and was subsequently charged. His time was then restricted and then sort of expanded again. There was a parenting assessment completed by Dr. Elterman. Interestingly, the assessment doesn't seem to actually make any recommendations for what the schedule should be, but instead recommended that both parties engage in counseling and other therapeutic programming, and to obtain an updated report to consider what further changes should be made so the child can, quote, again, have 2 parents in her life, end quote. No update was obtained before the trial. It was an 8-day trial. The mother, who was self-represented at the time of trial, sought a continuation of the supervised parenting schedule, and the father was looking for an equal share. The trial judge ultimately sided with the father and ordered a 12-week step-up schedule, resulting in the father having the child from Friday afternoon and 6 out of 14 nights, and none of the father's time was supervised. And the trial judge stated essentially that there was no valid reason that the father should not have longer periods of parenting time, eventually equal parenting time, and having, quote, considered all of the evidence, equal parenting time is in the best interest of the child. No danger to the child has been found in the evidence called by the mother in the dealings with the essentially equivalent of Children's Aid Society, or in the opinion expressed by Dr. Elterman. This was appealed, and the mother argued that the trial judge failed to actually analyze the children's best interest in accordance with the analytical framework mandated under BC's Family Law Act, which is similar to the Divorce Act and similar to the Children's Law Reform Act. Courts have to consider allegations of family violence, have to consider family violence. In this case, the real issue that the trial judge fell into is that he didn't make any findings about the allegations of family violence, but he did seem to indicate that he actually said, I agree with the father that the mother had made these allegations for tactical or strategic purposes. However, to make that finding, the trial judge needed to actually analyze the mother's testimony, analyze the alleged acts of physical violence and threats towards her, and he had to determine that they were false and that they were done for strategic purposes. The BC Court of Appeal sets out very clearly that this is the trial judge falling into the myth that people make up these allegations in order to gain a strategic advantage. It is a very concerning, very insidious myth that is thrown around a lot. It is particularly difficult for clients to rebut these sorts of things because family violence happens behind closed doors. This was set out by the Supreme Court of Canada in Barendrecht, a 2022 case. Domestic violence allegations are very difficult to prove, and they often lack corroborating evidence because it's just the two people in the room, the aggressor and the victim. The failure to prove on a balance of probabilities that an act of domestic violence did not occur does not mean it didn't happen, and certainly doesn't mean that it was falsely alleged. And the BC Court of Appeal is very, very clear about that. In fact, the disposition of this was that the entire thing was sent back for a new trial, with the Court of Appeal cautioning the new trier effect to carefully assess the merits of the family violence allegations and not fall prey to myths and stereotypes. And in the meantime, the Court of Appeal ordered that the father's parenting time be supervised, which demonstrates the concern that they had about the evidence that the mother had brought forward. This is a very challenging issue, a very important case to read, whether you are dealing with a client that is claiming that the other side is, quote, making it up, or whether you are indeed dealing with a case where your client has experienced family violence, some of the most difficult cases that we will deal with. There was another case in 2023, Friesen from Saskatchewan, which sets out some great principles as well to guide us. And at the end of the day, these are the things we need to think about. These are the things we need to be sensitive to. We do acknowledge that weaponizing these claims can happen. We're not saying it never happens. However, it is much less pervasive and much less widespread as people would sort of try and make one believe. And as Aaron and Michael said, what's a trial judge to do? Listen to the evidence, consider the evidence, apply the burden of proof, and make factual findings on these important allegations.
My next two cases are both about alienation, and they're from late 2023. And the reason we've included them and the reason they're important is because one being from Justice Kraft, one being from Justice Finlayson, they both offer examples of how these cases are to be handled. We have all seen trial judgments that talk about the fact that this case has been going on for 7 years and has been in court 57 times and takes up 32 banker's boxes, and there were 45 interim orders. Those cases are the death knell for an alienated parent in a true alienation situation. in both YHP, which is Justice Kraft's case, and GRG, which is Justice Finlayson's case, both of them deal with alienation the way it should be, which is swiftly and then with continued case management from the court. Allowing these cases to fester, allowing them to go on forever, allowing one party to simply string the thing out and drag the puck simply is enigmal to the whole idea of trying to fix a situation to the extent it can be fixed. And the really interesting thing about both these cases are that there were custody reversals, and in one case, use of the Family Bridges program on an interim motion. So these weren't final judgments. These were two cases where two judges, two very experienced family judges, recognized the signs, recognized the problems, and said, enough, we are going to deal with this right now. And in fact, in GRG, a sidebar, I can't stand the fact that all these cases are initialized now because I can't remember them. But in GRG, Justice Finlayson actually takes the Children's Aid Society to task for not actually involving themselves and allowing the parties to duke this out themselves privately in court, when he said at least in the case before him, it was clearly a situation where there were children in need of protection, and actually ordered the CAS to become involved and ordered somebody from the CAS to show up at the next return date in order to explain what exactly they were doing. So it's not the facts that are as important as the actual process, but very high level. In YHP, Justice Kraft was met with a situation, again, where one parent behaving badly. Parties were married for about a 6-year marriage, had one child, daughter. Daughter was 12 years old by the time that this motion showed up before Justice Kraft. Parties separated in 2014, whereupon the mother alleged the father had sexually abused the daughter. The allegations were invested by the police, found nothing. Children's Aid Society found nothing. The scan team at Sick Kids found nothing. Office of the Children's Lawyer found nothing. Other various medical professionals, including the child's doctor, all of whom found nothing. But the mother persisted in her allegations and refused to allow the father to have unsupervised parenting time. At some point, the OCL did a report in 2016, said the child was actually quite comfortable with the father. In 2017, the mother seemingly saw the light and allowed the father to have time with the daughter again. Unfortunately, the light went out fairly quickly, and upon COVID happening and other sort of cases, the victim of COVID, mother retreated to her old ways and made it virtually impossible for the child to see the father, claiming the child didn't want to see the father, reinvigorated her allegations of inappropriate sexual contact vis-a-vis the daughter, reported to all the agencies again, actually interfered with counseling and barged into one of the counseling sessions between the therapist and the daughter to suggest that the father was dangerous. Father brought an interim motion to actually vary what was then a final order, to ask that custody be switched and to ask that the daughter be engaged in the Family Bridges program along with him. Justice Kraft goes through a very detailed consideration of all the case law about, first of all, making interim changes to a final order, which is a whole area of law unto itself, but she goes through it really quite well. And then talks about the fact that given the mother's egregious behavior, she really had only 4 choices. She could do nothing and just leave the child with the mother. She could reverse custody and place the child with the father. She could leave the child with the mother and order therapy, or she could provide some sort of transitional placement with a third party. She said, well, in fact, only A and B were left as options because the other therapy hadn't worked and no one had really asked for, and there wasn't really a third party that could take interim custody. So the options were to do nothing or to reverse custody and place the child with the father under some conditions. And Justice Kraft said doing nothing is simply not an answer, as should be the answer in many of these cases. So Justice Kraft ordered again, this is an interim motion, ordered a custody reversal, child to live with father. Child's, I think it was 12 years old at this point, as I said. Ordered a 120-day blackout period, meaning that the mother could have no contact with the daughter for that 120 days. But Justice Kraft also cleverly put in place, and also ordered the participation in the Family Bridges program. Also, however, set up an immediate case management judge to manage the case so that the case could be regularly reported on back to the court to determine whether or not the 120-day blackout period was just right, too long, not long enough, and to determine how the Family Bridges counseling was actually working. It's a very well-written decision about this area, and again, exactly how I suggest courts should deal with these issues to avoid than being those, 15 bankers box, 45 attendance cases. Secondly is Justice Finlayson's decision in GRG and SG, a very similar flavor to it. Justice Finlayson's decision, however, is an interim variation of an interim order, which is a separate text unto itself. But very similar situation. One parent behaving badly, allegations of inappropriate sexual conduct that had not been verified. By this time, there had already been 20 orders or endorsements. 5 other judges had been involved, and Justice Finlayson said, enough. And he actually also, on an interim basis, did something about it, and again ordered that the Children's Aid Society show up and explain why they hadn't done anything, which I'm sure did make the Children's Aid Society all too happy. But I mean, it's pretty clear in a case of whether or not one calls it parental alienation syndrome or just parental alienation or unjustified estrangement, something had to be done, and Justice Finlayson, just like Justice Straff, went ahead and did it. If you are dealing with a case or if you're representing a client who is in that sort of situation, I will say that these 2 cases are must reads because they deal with both situations, interim variations of final orders and interim variations of interim orders. But these are, it's too early to tell whether or not these 2 cases are just sort of blips, and these 2 cases happen to land up before very experienced family law judges who had been very experienced family law lawyers, or whether or not this is actually going to be an ongoing trend, because for all sorts of reasons, including, being careful with our sort of scarce court resources, this is exactly the way these cases should be dealt with. Very quickly, as it's amazing how quickly time flies, there were 2 grandparent access cases that we will include in the paper. One is again an initial case, FS and NG and TS. Good luck remembering that. That's a case by Justice Scher. And the reason that's a good case for grandparent access is in typical Justice Scher fashion, he sets out the playbook. He says, here is the way that you deal with these cases. Here are the 2 sort of streams that the cases have sort of developed, or the 2 roads the cases take. One being sort of the parental autonomy model. Think Chapman from the Ontario Court of Appeal. Unless a parent is behaving badly or acting capriciously, a parent gets to decide who their children spend time with, as opposed to the other model, which is the sort of pro-contact model, which is that contact should be assumed unless there's a contact with a grandparent should be assumed unless there's a reason not to. But he sets out sort of the whole guidebook, as I say. It's a good synthesis of all the current principles, and of course, Justice Scher numbers all his principles. Just makes life very easy for lawyers. And then in the second case, Kirschenblatt, Justice Himmel in Newmarket takes Justice Scher's decision in again, I have to go back to the name of it because I can't remember the initials, in FS and NJ, and actually applies it to the case before her, which was a case arguably of both parents and grandparents behaving badly. And in this case before Justice Himmel, things are a little bit different because while one child did have a history of some contact with the grandparent, the other child didn't. So Justice Himmel had to grapple with the idea of what do we do here? Unfortunately, Justice Himmel was given a bit of an easier task because the parents had agreed that the grandparents could continue time with the older child who they had time with, not the amount of time the grandparents wanted, but some hours a month. She said based on that, it would be incongruous to say one child can have contact but the other cannot. But nonetheless, she still goes through the test and considers what is to be done in situations where there's a history of perhaps one parent never having had contact, or also considers the situation, even though it was over during this decision, as to what happens in a situation whereby one of the parents dies and it's the dead parents that are actually the ones that are looking for access as grandparents to the kids. So 2 very good recent grandparent access cases that, if you're dealing with grandparent access, are both must reads.
So I'm going to move away from parenting now. Next 2 cases.
Because Adam hates children.
Infamously. This is what everyone knows about me now. I hate kids and I'm very tall. Great. Perfect. So Anthony from Nova Scotia and Frost from Ontario. These are the 2 cases you go to when you get a massive disclosure request from the other side and you do not want to provide all of it. Anthony is from Nova Scotia, but a fantastic case. It sets out all of the things that you need to be considering, whether you're responding to a disclosure motion or bringing one. it sets out really some of the most important things that people forget, which is you need to establish relevance, and you need to do more than just rely on your pleadings. So you need to actually provide evidence as to why something is relevant. And the threshold for establishing relevance is low, but it is there. And the need for evidence is essential. I am looking at you, my friends, who have sent in disclosure motions where you have just attached a letter from your expert. Thank you. That doesn't explain the relevance of the requests. That's not enough. There are a number of really great factors that Justice Fogeran sets out in Anthony, what are called the Loshway factors in Nova Scotia. And it sets out whether something should be provided. There are 10 of them. You consider connection, proximity, discoverability, reliability, proportionality, important, alternative measures, privacy concerns, balancing, objectivity, and limits. So those are the 10 factors, 10 considerations that a court needs to consider when it's ordering disclosure. And even though they come from Nova Scotia, they are equally applicable here in Ontario or anywhere else. Frost and Frost focuses on the concept of proportionality in disclosure, and it is a really great case by Justice Jane. Well written, well reasoned on an important point. Too often, I think we can sort of get lost in disclosure fights. In this case, the husband prepared a 15-page chart that listed the many hundreds of disclosure requests he had made over time, and all of the ones he claimed were outstanding. However, he had not provided any evidence as to why these disclosure requests were relevant, why he needed them, and why it was proportionate for the wife to provide them. The wife, on the other hand, provided very clear evidence showing that she'd actually really tried to comply with those disclosure requests, and had answered undertakings and provided a lot of relevant disclosure, thereby leaving her in good stead with the court. There is a great summary of a decision by Justice Mesberg called Crescent, which sets out factors when you're considering proportionality, specifically that the parties in the court need to consider the time required to produce the information, the expense associated with the production, whether there is any prejudice that would be caused through production, i.e. whether there's confidential information there, and whether production would interfere with the orderly progress of litigation, and whether the requested document is in fact available. Does it exist? Slightly different than the Loshway factors, but still important. Here, husband had not even come close to establishing that the extensive disclosure he was seeking was relevant and proportionate. Didn't even bother making a shot at it. Justice Jane provides a really important sentence in paragraph 8, where she states no procedural decisions should be made without specifically addressing the principle of proportionality and without first considering whether the request is a deviation from the requirements of Rule 13 in the family law rules. Very important case when it comes to disclosure. If you are making a disclosure motion, you need to be in line with Anthony and Frost. If you are resisting a disclosure motion, you should be citing these cases in your factum as well.
Sase 2?
Sase 2, trying to speed it up.
I'm going to spend a little bit talking about foreign divorce and a couple interesting things that have happened in that area over the last couple months. I have actually spoken about this case before, Biazemskaya and Safin. Ironically, even though there's a name for it, Biazemskaya and Safin, I know it is V&S, back to the initials that I actually don't like. This is a case about recognition of foreign divorce. The setup is essentially that parties lived in Russia, parties had a child in Russia, parties were Russian citizens, parties came to Canada. Not long after they came to Canada, they decided, you know, this whole marriage thing, we don't like it. They separated. Father went to Russia, got a divorce in Russia, based on the fact that he was a citizen. Mother participated in the divorce in Russia to the extent that she contested she contested the issuance of it. As I say, it was still issued. Parties came back to Canada, case returned to Canada. Mother claimed the usual panoply of family law relief in Canada, to which father said, hang on a second, mom can't claim spouse support because we're divorced. So I will remind you all about the Rothfuser problem because of the division of powers in our Constitution. The federal government in the Divorce Act only has power to legislate about spousal support if the parties are subject to a party to a Canadian divorce. So that's why the Divorce Act can't be used if you're not married, because if you're not married, you can't get divorced. And if you can't get divorced, the federal government has no jurisdiction to order corollary relief in the form of spousal support. And for the same reason, if you're divorced in a foreign jurisdiction like Russia, because you're not party to a Canadian divorce, according to the case of Rothgieser in Ontario and some other cases in Ontario and elsewhere, you can't claim spousal support under the Divorce Act. That leads to a further problem because once you are no longer spouses because you're divorced, you are former spouses, and under our act in Ontario, former spouses can't claim spousal support, which leaves a spouse that is subject to a recognized foreign divorce screwed is the word, completely screwed. Because they can't claim spousal support anywhere. And if you're in a jurisdiction like Russia or Texas, where spousal support isn't so generous, you got some problems. So a wife tried to set aside the divorce. Well, not try to set aside, try to suggest that Ontario shouldn't recognize it under Section 22 of the Divorce Act. First, she claimed she didn't have notice of it. Therefore, that's one of the foundational principles. If you don't have notice of it, Ontario will not recognize it. The difficulty was, having contested the divorce, it was hard for the wife to suggest she didn't have notice of it. So that wasn't going to work. Other problem for the wife was that in that decision, in that very first decision, the court had noted that the parties did have a real and substantial connection to Russia, which is a really important phrase because that means that Russia has jurisdiction simpliciter in order to deal with something like a divorce. But that attempt by the wife to have the divorce not recognized failed. So she tried again, based on the idea that the Russian divorce, strike one. Now she went for, pitch number two. She tried to suggest that the Russian divorce should not be recognized because of public policy, which is, according to the Supreme Court of Canada in Beals and Saldana, a basis to not recognize a foreign order. However, when you look at Beals and Saldana talks about repugnancy of foreign laws, not repugnancy of conduct. So say what you will about the husband. Say the husband was a schnook. Say the husband did this on purpose. Say the husband set out to specifically try to not have to pay spousal support. It's not the behavior that matters. It's the law in Russia. There's nothing wrong with the divorce law in Russia. Russia allows parties that are citizens to get divorced. Divorces there may happen more quickly than in Canada, but as the Court of Appeal ultimately says, you can't impugn the entire Russian legal system because of the way they decide to deal with divorces. So, however, the court below on the second attempt does say, yes, you know what, there is something wrong with this. We are not going to recognize the foreign divorce. Off they go to the Court of Appeal. The Court of Appeal sort of recognizes the problem here with Beals and Saldana, but seizes onto this one line from Beals and Saldana that talks about unfair forum shopping. So they say this is actually another basis to not recognize a foreign order. We have public policy, we have fraud going to jurisdiction, and we have unfair forum shopping. Well, here the husband engaged in unfair forum shopping, therefore we should not recognize the foreign divorce. The problem with that, and I realize pretty much every member of the Court of Appeal is far smarter than I am, but in my simple mind, I don't understand how you can be found to have engaged in unfair forum shopping, asking for relief in a jurisdiction where you are found to have a real and substantial connection. That is a bit of a problem to me. However, they do develop this new basis to not recognize a foreign divorce or any foreign order for that matter, because we're not only talking about divorces, of unfair forum shopping. The other problem with that is that it suggests that you can have fair forum shopping, which is something I never understood that you could do. Forum shopping is generally something that courts don't look favorably upon. So there's now forum shopping and unfair forum shopping. And of course, the problem here is that, bad facts and intransigent governments make bad law. In many provinces, BC, Alberta, eastern provinces, Manitoba, they have specifically legislated that former spouses can claim spousal support, which makes a great deal of sense. Why Ontario has been so stubborn, not entirely sure. However, something has been done about it. Last week, over the course of 2 days, in a case called Marillion and Dunmore, there is a constitutional challenge suggesting that Section 33 of the Family Law Act that limits the right to claim support to spouses, not former spouses, is unconstitutional, unfairly differentiating between foreign spouses subject to a divorce and Canadian spouses subject to a divorce. I did not argue it. I know about the arguments, and anecdotally, the court seemed very receptive to the idea that there was a problem here. That doesn't mean a thing. It just means the argument went in well. Don't know ultimately what's going to happen. I do know that whatever side wins, this is ultimately going to land up at the Ontario Court of Appeal. So this issue is being dealt with. Interestingly enough, this was litigation that proceeded pursuant to notice of constitutional challenge. And for reasons that I really can't understand, the government intervened on the side of the father here, technically, saying, yeah, the law shouldn't be changed. Former spouses should not be allowed to claim spouse support, which is something I just don't understand. You would think the government would be all over the idea of foreign spouses subject to a divorce not having to be on the social welfare rolls because they can claim support from their former spouse. So I just don't understand it. Maybe somebody was concentrating on selling alcohol in corner stores rather than on, the unfairness that, happens sometimes in these situations. But we will have an answer to this, although it may take some time because, as I say, it's going to go to the Ontario Court of Appeal. As long as we're talking about Moreland and Dunmore, a separate chunk of that case is also now going to the Supreme Court of Canada, for those of you that want to keep tabs on these things. And the issue that the Supreme Court of Canada is going to be dealing with is the parenting part of Moreland and Dunmore. And the question they're going to answer is whether or not, you all remember FNN that dealt with the return of a child in a non-Hague situation. The Supreme Court is now going to deal with whether or not provincial statutes, like the Children's Law Reform Act, all of which are based on a model code, that most of which, if not all of which, actually have their own baked-in definition of habitual residence, whether or not bailiff and office of children's lawyer and the definition of habitual residence from the Supreme Court of Canada in that case actually infect and change the definition of habitual residence in the provincial statutes. And I use the word infect advisedly because I am not a fan of what the Supreme Court of Canada did to habitual residence and the notion of it in bailiff. But again, just my personal opinion. And finally, we all know, with respect to the Supreme Court of Canada, Alawilia has been granted leave. People are in the process of filing their stuff and interveners are getting involved. I think it's going to be argued in December, I want to say. I could be wrong, but certainly very soon. So we'll have sort of an answer to that. But that is sort of the uppest to datest on recognition of foreign divorces.
So I'm not going to go into detail on my next case, Pan and Zhao. It's a decision by Justice Vela. It is I think the most up-to-date family law case dealing with anti-suit injunctions. It sets out a number of useful pieces of information, a very good analysis on when a court can take jurisdiction over a matter, when a person can be found to have attorned to a jurisdiction, the test for forum non-conveniens, that's in there as well. And Justice Vela does all of that work before she then gets to an analysis of how anti-suit injunctions work and a specific application in family law. Essentially, in this case, the husband had attorned to Ontario's jurisdiction about everything, but he had started an action in China and wanted his action in China to continue because he was claiming a tort in China against the mother for mental damages caused by her infidelity. That does not work very well for him. There's an important process point here. One of the reasons it doesn't work well for him is that the husband provides no evidence as to the law in China concerning as to whether or not he could actually make this claim. It's something that a lot of people ignore, but is important. Foreign law, you have to prove it as a piece of evidence. You can't just say, this is the law of X country. In addition, Justice Vela stated that not being able to pursue a claim for compensation based on alleged adultery wasn't something that was going to justify holding up the wife's claim. That's not a claim we have here in Ontario for good reason. And the anti-suit injunction that the wife sought was indeed successful. So an important case for anti-suit injunctions, very important. I guess the other case that I have, Eldridge and Eldridge from the British Columbia Court of Appeal, a fantastic case when it comes to the issue of reviews. It's got a lot of language about what does a de novo review mean and what is the effect of a de novo review. A great case for that. It also is very, very well written in terms of dealing with whether something that you think is going to happen in the future is a reason to review support. In this case, a husband essentially wanted to reduce support because he thought he would probably sell his business in the near future. I'm being a bit facetious there. He was in his mid-60s. It was pretty reasonably on the horizon, but the court set out that you actually can't do that because it is not a certain event. It is one thing that may happen in the future. There's a bit of discussion in our summary about exceptions to that. Cases in both Alberta and Ontario, where courts have seen an impending retirement as a material change and a reason to alter support. However, in those cases, it was very clear as to when it was going to happen and what the effect would be. Also, I love this case because it involves two archaeologists that get married. So anything that reminds me of Indiana Jones is just great for me.
I'm going to talk very quickly about White and White. And very quickly about Nom-Chom and Green. White and White is interesting because case from the Ontario Court of Appeal. Interesting for two reasons. A number of years ago, the Ontario Court of Appeal decided a case called Levy and Levy, L-A-V-I-E, which suggested that a court really, when imputing, if you're imputing income to one spouse, you should really seriously consider whether or not you should be imputing income to another spouse. In White and White, they impute income only to the wife and not at all to the husband. The situation was the parties are separated, signed a separation agreement saying that that the wife, that if the wife earned more than $35,000, for every dollar above $35,000 she earned, her support would be reduced. Wife had sort of mused about going to Mexico and starting a travel business in Mexico. Oh, but we all could go to Mexico and start a travel business in Mexico. And anyways, perhaps unsurprising, she never actually earned more than the threshold. In the meantime, father lost his job, had been earning about $189,000, showed up in court earning about $80,000. The court thought it to be quite legitimate. He hadn't done anything on purpose. He lost his job and got another job earning what he could earn. Father showed up for a variation. Court said, yep, we're going to vary because there'd been a couple changes. Number one, father's income had reduced. Number two, the children had sort of moved around a little bit. But most importantly, the court said, yeah, there's really no reason that the wife isn't earning income. Importantly, in the separation agreement, everybody knows that in the Divorce Act, one of the factors and objectives, or one of the objectives of spouse support is to encourage one spouse to do what they can to become self-sufficient. That has time and time again been described as not a duty, but just one of the considerations. Here in the separation agreement, the wife had actually obligated herself, basically just parroting the words of the Divorce Act, to make reasonable efforts to support herself. That, so said the lower court and the Court of Appeal, transposed the, call it wishy-washy duty in the Divorce Act, or the Statement of Principles in the Divorce Act, to actually an obligation. So she actually created the obligation to actually go and earn some income, and having not done so, the court thought it unacceptable and imputed her with $35,000, and did not impute income to the husband, even though he had been earning $189,000 and showed up in court earning $80,000 because they were convinced that he, in fact, had not been engaged in anything nefarious, wasn't artificially under or unemployed. So interesting to read that in comparison with, as I say, Levy and Levy. Lastly, Chom and Green, just an interesting comment from our Court of Appeal on occupation rent. We've all read Fafano and Green. And we've read Griffiths and Zambasco. All of them are fairly old cases, both from the Court of Appeal. So we all lawyers in Ontario sort of feel that occupation rent is sort of an irregular thing to have ordered. It can be ordered, but it's an exceptional remedy. Court should be slow to order it, should be ordered cautiously. When it was ordered, it was sort of just used, to even things up a little bit. Things perhaps are tipped, too far in favor of one side. They could use occupation rent to fix it a little bit. In Nom-Chom and Green, the court says, while it is settled law in Ontario that an order for occupation rent need be reasonable, it need not be exceptional. So this really has sort of opened the door to occupation rent. All you have to do is basically prove that your claim is reasonable, be that because sometimes there's ouster, but you don't need to have ouster. Sometimes somebody refuses to cooperate in a sale. Sometimes somebody delays in a sale. It could simply be that one party does the good thing in a separation, agrees to move out, and then get stuck outside the house for a long time. So occupation rent awards are no longer exceptional. They just have to be reasonable. And when you combine that with a recent case from from actually the Newfoundland Court of Appeal, called Soros and Goss. In Soros and Goss, the Newfoundland Court of Appeal actually said that you'd have to show exceptional circumstances for an award of occupation rent not to be made. So, you know, it is a new day for claims for occupation rent. So go forth and claim.
So we are right at the edge of our time. I will just say this: if you want to have a case that will break your brain, read Falsetto and Falsetto. It is essentially you are allowed to claim a resulting trust, even though you told the government for Planning Act purposes that you were absolutely not an owner. You can then claim in the next thing that you can, despite the fact that in Ontario Court of Appeal case called Holtby and Draper explicitly said you couldn't do that. So Falsetto and Holtby don't sit together very well. And I highly recommend reading Moran and Moran. It's a decision by Justice Kraft. It is a very good description of what it means to hack into someone's computer. There, the person who did it had very little tech, didn't really guess a password, didn't have to do anything fancy, but got access to privileged information. And Justice Kraft walks you through how to deal with it. A very important point, but it doesn't, you know, hacking doesn't mean you need to be breaking in or having some sort of tech skills.
Great job, Adam and Aaron. I'm now up as to datus. I'm going to have occupation rent in all my claims as the item number 1. And beer in the corner stores, liquor in the corner stores, we're moving towards a free and democratic society. So
That's right. Section 7 all the way, baby.
Inspired me. Tell me what's going on with the Superior Court downtown. They get these alienation cases, and do they have a bullhorn? Do they just say Justice Kraft clean up on aisle 5, and they just send it down to her courtroom?
Yeah,
or?
I realize, as Adam mentioned this is a little bit turned into the Justice Kraft show, which wasn't meant to be. But you know, she's written some really good, she writes well, and she's written some really good decisions as of late. And as far as alienation cases go, I think what you really need is someone who is a judge that practiced family law for a long time, that sort of smells it, and knows that if we don't do something now, eventually it's going to become too late, and it's going to become one of those cases. So I think that's and Justice Kraft, Justice Finlayson, you know, anybody at the UFC in Newmarket, you know, they all have experience in the vineyards of, you know, matrimonial discord.
Too late to go back, right? If you wait too long. And that's the frustration for a lot of practitioners. The courts are not prepared.
Yeah.
Or traditionally, we're not prepared to do anything until 2 years later. And then
it's too late, right?
Yeah.
Then the kid is 14 or 15, and then you have cases that say, well, we're not going to make an order, the kid isn't going to follow. So like, you need to strike while the iron is hot. I mean, obviously it's not going to happen on the first attendance, but it also should, you know, you shouldn't have 13 attendances with nothing happening.
It's refreshing to see the court take a more active role in these cases much earlier on.
Agreed.
Yeah. Well, that was a fantastic presentation. Thank you so much. I took a quick look at your paper. It's excellent. Shannon, any feedback?
I just want to thank you both again for being here. We really appreciate it, and very insightful. We also appreciate you sharing the citations. Just for anyone who hasn't had a chance to look yet, it is in the chat, but we'll send those out after. So you can keep an eye out there. But yeah, it was great having you back, Adam, and really grateful that Aaron, you're here with us as well. And I know that you know, originally we were waiting for the stars align for it all to work out. So we really appreciate you squeezing it into your schedule.
Our pleasure. It looks like a great lineup. Good conference. Hope it goes well.
Thanks so much.
Talk to you soon. Have a good day, everybody.
You too.
That's good.
Bye.
Bye.
So just want to thank everyone who's tuning in so far. As I mentioned, the paper is available in the chat there for you. We're going to have it's about 10-minute or just over 10 minutes until our next presentation at 10:45. We'll have Brian Galbraith along with his team, Alex Beadie and Christina Garisto, who will be doing a two-part presentation, on how to become a super communicator. So really looking forward to that. Very focused on collaborative practice. I know I always have some great insights. So we'll
10 minutes health break, grab your coffee, check your emails, come back for the next presentation. That's the plan. 10:45.
that's the plan. 10:45.
We'll see everybody soon. Thanks for tuning in. Hello, Daphne.
Hello.
How's the morning going on the back end with the tech?
Fantastic. Yeah, it's going great. Excellent couple of presentations so far from Denise House and case laws, always popular.
Yeah, it was really great to hear from Sandra and all the great work they're doing. And Adam and Aaron, they just knock it out of the park. They're fantastic every time.
Yeah, absolutely.
And I want to thank everybody who's taken the time to go to the GoFundMe page to make a contribution to the Denise House. It's deeply appreciated. I think Shannon put a link into the chat if you want to learn more. And up next, how to become a super communicator.
Yeah, and just like that magic, here we have Brian Galbraith. Welcome.
Hey, Brian.
Hi, how are you, everybody?
Good. Christina,
Hey.
nice to meet you.
Morning, nice to meet you.
Brian, did you get some sun or did you put some makeup on today? I can't tell.
It's the end of summer, so I've been doing lots of canoeing and stuff in the sun.
Awesome. Do you canoe on Simcoe, or it could be like get a little choppy there, wouldn't it?
Not much canoeing, but I did go for a 1 hour motorboat ride in the lake this morning. Got on the boat at 8 o'clock with my son, and he has a friend. He's doing an exchange, so he has a kid here from Nunavut. So he's been here for a week, and then my son goes to Nunavut in next April.
Did you go up to the Narrows this morning?
No, just to Barrie and around this end of the lake.
Awesome. Beautiful morning for it.
Yeah.
That's fantastic. Well, let's jump right in. Welcome everyone welcome back to our new session is how to become a super communicator. And this is a 2-part session. So part 1 is from now until 11:30, and then we'll take about a 15-minute break and get started with part 2 at 11:45. So I'm going to go ahead and introduce our speakers. So welcome back, Brian Galbraith. Always nice to see you. Brian is the owner of Galbraith Family Law and has been practicing since 1990. His firm has 19 lawyers and 4 offices, all specializing in family law. He is the past president of the International Academy of Collaborative Professionals and a leader in the collaborative community. Brian is an international trainer and keynote speaker, and he lives on Lake Simcoe near Barrie with his wife and 5 children. So thanks so much again, Brian, for joining us. We are also joined by Christina. Hi, Christina. Christina Garisto is a lawyer at Galbraith Family Law. She's been practicing law since 2014. Christina is on the board of the Elizabeth Fry Society, and she does many ICs at the firm and enjoys doing peacemaking work, especially on collaborative cases. Christina lives with her husband in Oro, which is a rural community between Barrie and Orillia. Thanks so much. We're so happy to have you. And we're also joined by Alex. Hi, Alex. Great to see you again.
Morning.
Alexander Beadie is also a lawyer at Galbraith Family Law. He's been practicing since 1986 and is focused solely on family law since 2015. Prior to joining Galbraith Family Law, he worked as a criminal defense lawyer and was corporate counsel for Honda. Alex enjoys doing collaborative cases and does many of the initial consultations for the firm, and he lives in Toronto with his wife. So without further ado, I will pass it over to you, Brian, to get started with your presentation.
I think you're muted, Brian.
All right, so you have our slideshow, I hope. Can you see that?
Yeah, it looks
Everybody?
fantastic.
Okay, great. Great. Well, in 2024, news about AI dominated the news cycle. It's been heralded as being possibly a bigger change than the Industrial Revolution, right? And even greater than the advent of electricity, maybe even the internet or the smartphone. But it's also generated a lot of fear. The fear is that AI will replace lawyers, financial professionals, and family professionals. Professionals around the world are worried about AI. So the question is, will lawyers have a job in the future? Will we be relevant going forward, having regard to AI? Now, the worry about ChatGPT was elevated when it was revealed that ChatGPT passed the American bar exam with the score in the 90th percentile. I mean, that's kind of the score Russell Alexander might get, right? So, I mean, it's incredible. And it had completed the test in just 6 minutes. So that's probably faster than Russ. So ChatGPT is fast, smart, and a real threat. But you know what? I don't see it as a threat. I don't see it as a threat. The fear reminds me of the situation when accountants started to have spreadsheets on computers. That was a revolution in the accounting world. And the accountants were worried that their jobs would completely disappear. And it had a huge impact. No doubt it did. But they didn't disappear, did they? They became more efficient, more productive and accurate in their data collection and analysis. And they continued to provide good value to their clients by offering advice, projections, and so on. And I believe that AI is going to do the same for us. It's a tool we can leverage to do our jobs better, faster, more accurately, and will lead to efficiencies. Goldman Sachs believes that 37% of tasks conducted by lawyers will be improved by AI. So how are we going to use it? Well, it's going to be used for improved communications, using chatbots and so on to give updates on cases. It's going to be used for document analysis and summary. AI is really good at creating summaries of documents. It's going to be used for drafting documents. Obviously, it can look at all of your pool of documents and create documents in the same voice and in the same way that you create documents. I use it almost every day when creating emails and correspondence. It helps improve the tone and accuracy of my communications. And of course, it can be used in research and e-discovery. We're seeing a lot of the major players in the legal research realm starting to develop AI components to their programs. So this is great, I think, and it'll lead to increased efficiency, which means increased productivity. But there's some bad news. Yeah, that means we're going to be so much more efficient. We're going to have decreased billable hours and costs. So what does that mean? It means to respond to decreased billable hours. You know, if we could produce a document in 20 minutes that used to take us 3 hours, then we're going to have the afternoon is going to be free. What are we going to do with our time? And we can't bill, for 3 hours of time if we're only spending 20 minutes creating a document. So the answer, I think, is that we need to increase the number of clients that we have. And we'll be able to do that because we're going to be more affordable. And so I think that results in a greater access to justice. More people will be able to avail our services as professionals. And I think that's a really good thing. My prediction is that we'll be serving more people for less cost, thus increasing our access to justice. According to the World Justice Project, 77% of people with legal issues do not get professional help. So that's a vast untapped market of people who would benefit from our services. AI will make it possible for us to provide services to more and more people as we become more and more efficient and effective. But what does all this mean to legal professions? I believe this is a golden opportunity we have with AI. But let's all remember that humans crave human connection, right? Humans crave human connection, and we're all human, except maybe Russ. I don't know. He's kind of robotic. But we all need to learn to develop our skills at connecting with our clients. We need to provide the human connection clients crave. So I'm on a journey. I've been on a journey for a long time to get better at connecting with clients and, well, in fact, with all human beings, to get better and have a deeper connection. And so let me share with you what I've learned so far. When I was a teenager, I read a book called I'm Okay, You're Okay. And it really started me thinking about the psychology of human beings. It was a tremendous book for me as a kid, as a teenager. My father gave me a book that I read, and it's still relevant today. It's called by Dale Carnegie, How to Win Friends and Influence People. How to Win Friends and Influence People. It was written many years ago. Still, the themes of it are really relevant and helpful. But the most important book I ever read, and that's the one you're seeing on the screen, is Getting to Yes. It's just a seminal book by Harvard professors Roger Fisher and William Ury. It was first published back in 1981. Seems like many years ago now, but it outlines how interest-based negotiations work. And hundreds of studies have since confirmed that interest-based negotiation really works well for people. So when I read this book, it blew my mind and changed every conversation and every negotiation going forward. My most recent discovery, the next mind-blowing book for me, is Charles Duhigg's book called Super Communicators. And Alex and Christina and I have all read it and digested it. I've read it 3 times and I could read it again. It's an incredible book, and I encourage you to read it. We're going to talk about super communicators because I think that's the key to us as a profession getting through this whole AI thing, is honing in on what we do as human beings to create connection. And of course, that is being a good communicator. We do surveys of our clients all the time, and survey after survey after survey, when clients are happy, it's because of our communication. And when clients are unhappy, it's because of our communication. Communication is key to providing good service. So, Shannon, maybe you can ask the first survey question. I'll stop sharing. The first 2 questions, please. So, how to become a super have you read the book Getting to Yes? So just click on your screen if you've read it or not yet, but I will put it on my list to read. I don't read books. I'm already too smart. That might be Russ's answer. I'm not sure. I love coming to these seminars so I can get the mic and just tease Russ all the time. Okay, maybe are we ready to show the results? Of course, well, 23% have read it, 74% not yet, and 3% are just already too smart. I get it. Okay, yeah, I really encourage you to read it. So let's go to the next question. Have you read the book Super Communicators by Charles Duhigg? Yes, no, not yet. It's in a pile of books beside my bed. I don't read. I listen to books, and it's on my list to do. Yeah, I listen to books. That's how I consume most books for sure. We'll wait a little bit more. Is that good, Shannon? Shall we post the results? No, 85% have not yet. Well, no, 96% have not. Wait, 100% have not read this book. Well, you know what? That's okay. This will be good new information for you. And I'm not surprised because you can close the results there, Shannon. Because this book was published this year in 2024. So if you haven't read the book, that makes sense. That's okay. But put it on your list of things to read. Okay, I'll go back to the slideshow. And okay. Yeah, it was published in 2024. And let me tell you a little bit about Charles Duhigg, the author. He's published a couple of other great books, The Power of Habit and Smarter, Faster, Better. He worked as a journalist and then did an MBA at Harvard. Pretty smart guy. But then he was put in charge of a complicated project at work where he had to supervise a lot of people. And he realized he was not very good at his job because of his lack of communication skills. So he started doing research on communication, and he spoke to many experts and read research papers. And 3 years later, he published this book. The thing I like about this book is it's so full of references to academic research on the various topics. It's not just one man's rambling about the thought about communication. It's based on scientific research. So I really think it's credible and worth us taking our time to read it and consume it. So one of the first things he says of super communicators is our goal is to have a learning conversation. So we understand each other. It's not about persuading or manipulating others. Those lessons are taught in other workshops in this. No, we're not going to teach that at all. The goal is to truly understand each other. This doesn't mean you have to agree with each other, just understand each other. And if a client feels that that you understand them, they will trust you and retain you and to help them through their divorce. When tough decisions have to be made, they'll seek your advice. They'll be happier with your services. It'll lead to more referrals. It'll lead to Google reviews. You're going to make more money. Your sex life will improve. It's going to change your life. Okay, well, maybe not, but it's really a good book and will help. I think it's improved my skills as a communicator, and I hope you learned from our discussion. Christina and Alex have certainly become even better communicators because of this book. The first lesson is he talks about working to get deep connection on a deeper level. True alignment, he calls, or the science calls, neurological synchronization. And that means our bodies actually become aligned. Everything from how fast we breathe to our brain waves all become synchronized. Duhigg references some research on musicians, and when they started playing duets, the musicians' brain waves actually synchronized through the music. They became one. Now, my wife and her sisters do this all the time. When they're together, their conversations speed up, their eyes sparkle, they start to finish each other's sentences. It's something to see. Me and my two brothers, when we get together, it's more like three monologues in a room. You know, we're not super communicators. We don't sync with one another like my wife and her two sisters. So how do you do that? How do you deliberately learn the skills? Well, Duhigg says you can deliberately learn the skills to be a super communicator. First, he said super communicators ask 10 to 20 times more questions. 10 to 20 times more questions than regular communicators. Not just questions to seek a fact, but rather questions that ask about others' values and their beliefs and and to get at what we always call interests, right? What's important, what's motivating people. So you think about your best friend who you're having a really bad day and you call them up. I bet you call that person up because they ask you questions. They want to know more. They want to hear from you. They want to understand what's going on in your life. You don't call the guy who's all focused on themselves, your narcissistic friend. No, you don't call them. You call the friend who wants to ask questions. Second, super communicators constantly adjust how they communicate to match the other person. So I know you know about questions. That's not new. But this is interesting. Well, I thought this was an interesting thing that Duhigg talks about, is that we need to work to match the other person. If the other person's mood or attitude shifts, super communicators follow suit. I continue to work on developing my skills. I did a consultation with a man the other day. He recently discovered that his husband had been cheating on him. A part of him was devastated, and another part was deeply hurt. But there was also this overwhelming love that he had for his husband. He said he was just sad. It was a really difficult conversation for this gentleman, but I practiced my skills. And when he laughed, I matched his laugh. And I just kept trying to understand him, his pain and what he was experiencing. When he said he was sad, I repeated back to him exactly what I heard him say, matching his slow tone and moving my voice deeper like he did. You are just sad. When I said that, my client's eyes teared up because we were really connecting on a deeper level because I was matching him in what he was saying. He could hear in my voice that I genuinely wanted to understand him. We were two human beings connecting. It was really cool. And I knew that if we were connecting in this conversation, he would trust me and retain me and allow me to help him resolve the issues from his marriage. But you can't mimic it. You know, you got to be really genuine about it. Duhigg says that there's studies where people are giving recordings of laughs, and some are genuine laughs, some are fake laughs, and people can distinguish one from the other within 5 seconds. So you got to be genuine about it and really sincere in your effort to match with your client. Laughing. That's a really important part of this book. Duhigg discusses laughing extensively. Did you know that 80% of the time when people laugh, it's not because of a joke or someone intentionally trying to get someone to laugh? Laughing is a signal by one person to another that they want to connect. It's a signal. Back to my wife, Nicole. She laughs all the time. And I definitely not at my jokes. Usually she groans. But she is a super communicator. And she's laughing because she wants to break the tension. She wants people to feel comfortable. She is saying through her laugh that she wants to connect with you. Now I understand. Alex, have you ever used laughter in your meetings with clients?
Yes, thanks, Brian. Great comments, and I too find that adding humor where I can during the course of our day-to-day practice is really appreciated by the clients. Those little interludes break tension, they open the opportunities to more deeply connect. There's a good example that occurred to me the other day. It was a YouTube clip that I saw. And in the midst of a conversation with a potential new client about her parenting challenges and when her daughter was younger and in her adolescent years, how difficult, the communication between them had become. And I told her about this YouTube clip. It was a mother who was at the border making crossing arrangements with her young adolescent daughter. And the border crossing agent turned to the young girl and said, "Is this your mother?" And the young girl responded by saying, "I hate her." And so the crossing agent said to the mother, "That's okay, ma'am, you can go. You're clearly the mother." So this raised laughter with this potential new client at a time when she was feeling the burden, of the strain of the conversation, and we were able to move on with that conversation more deeply connected. So yes.
Christina, how about you?
Yeah, same here. I also like to break tension with humor sometimes. I just find it makes people feel more comfortable with me, and it kind of puts them at ease. I know people will often get really nervous when they come to me for an initial consultation. I've heard numerous times that they feel like they're going to the doctor's office, or they feel like they're about to receive bad news right when they first come in. So I could like to joke with them, don't worry about it. I'm not very intimidating. I'm maybe 5 feet tall. I rarely bite. Just to kind of put them at ease, make them more comfortable. Then you can literally sometimes like just see the tension leave their shoulders, and they do become more relaxed. So I really do find that humor works.
Yeah, and the thing about Duhigg's book is we've all think back and we think, okay, yeah, we do use humor from time to time, but he's saying this is a tool that you can deliberately use and choose to use to deepen your communication. So I'm going to play a short video of oh yeah, oh good. Actually, we'll wait for this if that's all right. Wait for the poll. I'll tell you when the poll comes up. Okay, I'm going to show a video of a father and his baby laughing. Watch for what he does to match his baby. This is a remarkable example of matching, because this dad is, I think he's probably a super communicator. I don't know who the guy is. I hope he can keep this level of communication with his child when his child becomes a teenager. That's when it becomes challenging. But okay, let's play this video and see what your thoughts are on that. Okay, several things to notice here. First, how do you feel? I could see Alex and Christina's face, and they started to smile. Do you feel a little lighter, a little more open? Do you feel like your defenses have gone down a little bit? That's what humor does. Like a laughter, just for a moment or two can really be contagious, and it's involuntary sometimes. It's a really good tool that we can deliberately use in our meetings to be more effective as communicators. The father and baby were totally synced, weren't they? Notice that the father laughed in the same way as the baby. Sometimes it was a wholehearted laugh, sometimes it was a giggle. He held his mouth open the same way as the baby. The tone of the voices are the same. And so they're really connecting, and they're connecting without words, right? They're connecting through laughter, so I think this is a really good example of becoming synchronized. I bet if we could analyze their brainwaves would be totally synced. And that's what our goal should be with our clients when we're meeting them, is to sync with them, match what they're doing so that you can connect. Okay, let's ask the survey question now. Do you use humor in your client meetings? Yes, I use it often, and it's effective occasionally when appropriate, or almost never. I know some people would feel uncomfortable using humor, and yeah, it can be. You got to be careful the kind of humor you use. You don't want to offend somebody or alienate them. But if you can make it, and you don't want to belittle them through humor, it's a nuanced skill, but something that's worthwhile. Okay, let's show the results, Shannon. 37% use it often. 61 regularly, occasionally when appropriate, and 2% almost never. Great, thank you. Let's keep going. To align during conversations, Duhigg says we need to identify what type of conversation we are having. There are 3 types of conversation. Alex, what's the first one?
Yeah, practical is that first one. It's what's this conversation really about? What do you want? What do I want as a result of having the conversation? How are we going to resolve it? A real nuts and bolts approach that's focused on outcome and process.
Great, yeah, practical conversations, yeah. Christina, what's yours? Emotional?
Second is emotional conversations. So how are they feeling overall about their situation? How are they feeling in that moment? And that can change. So recognizing that, their worries, their fears, sensitivity, sadness, anger, and also kind of their hopes and dreams for the futures. So essentially their feelings.
Right, feelings. And then the third one is social, and that's who we are. It's a discussion about our identity as a human being. So if your client wants to have a practical conversation, Duhigg says you need to have that practical conversation. If they want an emotional one, engage in an emotional conversation. You have to use the style of conversation that your client wants. And so I'm going to play another quick video that illustrates this really well. It's called "It's Not About the Nail." And I hope you get a little giggle and see you learn something from it.
It's just, there's all this pressure, you know? And sometimes it feels like it's right up on me. And I can just feel it, like literally feel it in my head. And it's relentless. And I don't know if it's going to stop. I mean, that's the thing that scares me the most, is that I don't know if it's ever going to stop.
Yeah. Well, you do have a nail in your head.
It is not about the nail.
Are you sure? Because, I mean, I'll bet if we got that out of there...
Stop trying to fix it.
No, I'm not trying to fix it. I'm just pointing out that maybe the nail is causing...
You always do this. You always try to fix things when what I really need is for you to just listen.
Yeah, see, I don't think that is what you need. I think what you need is to get the nail
See, you're
out.
not even listening now.
Okay, fine. I will listen. Fine.
It's just... Sometimes it's like there's this achy... I don't know what it is. And I'm not sleeping very well at all. And all my sweaters are snagged. I mean, all of them.
Yeah, that sounds really hard.
It is. Thank you. Ow!
Oh, come on. If you would just...
Don't...
Try to see things my way. Do I have to keep on talking?
So that's an interesting video, I think, because you could see that she wanted to have an emotional conversation, and he really wanted to have a practical conversation. She wanted him to understand how terrible it is that all of her sweaters are snagged because of life for her with a nail in her head. And she just wanted him to understand that the trials and tribulations, he wanted to have a practical conversation. And look how they synced up together when he did have the type of conversation she wanted. Things were going well. But then when he reverted to his old ways and wanted to talk about the practical conversation, that's when they had problems again. So a good lesson, good illustration of choosing to have the type of conversation your client wants to have. Okay. Practical conversations are about what your client wants. What do they want to talk about? You know, their issues in a practical level. So I'll tell you an example. The first was a consultation I did with a woman, and she had questions about her rights and obligations and possible solutions to her situation. The next was a man. He had no interest in the law or process. He just wanted to discuss his feelings about the relationship. Both had been married about 25 years and were in similar situations, but they each wanted a different type of conversation. So I had the type of conversation they wanted so that we could align and learn from each other. Duhigg describes a story of a physician, I think this is really interesting, who treated men for prostate cancer. And the medical research indicates that in 97% of cases, the best course is not to have an operation. Yet this doctor was not able to persuade his patients that surgery was not the best route to take. He gave them medical articles and charts and graphs, and many still chose to have the operation against his advice. He just wasn't connecting with his clients, with his patients, I mean. So he sought out some advice and then changed his approach. He started to ask the patients what they wanted to talk about, what they valued, what was on their minds. Most of the time, the patients did not care about the medical research. They had other concerns like what would be the best choice to minimize the worry for their wife and kids. When the doctor started asking open-ended questions and getting to know his clients and what they wanted to talk about, he was able to guide them away from surgery more often. But he had to first connect with them during their conversations. Alex, have you ever had an experience with practical conversations?
Yeah, I've had similar experiences in this shift of the conversation that you're having. I had a client the other day. We started off on the basis of a practical conversation about constructive trust. But upon further probing, it was revealed that this client really wanted to have a social conversation about her concerns, that her spouse would reveal afflictions that she had with alcohol abuse. And therefore, as a nurse, she was concerned about her reputation and the damage that might do. And so the nature of the conversation shifted. And I found that in acknowledging that with her, discovering that and acknowledging that, the level of our conversation just went much more deeper and therefore became much more practical and effective.
Yeah. It could, because you shifted right from that practical conversation about rights and so on into the social one about her identity, and that I must have appreciated that and felt like, oh, this guy's really listening to me. He cares about me, and I trust this guy. Yeah. Christina, what about you?
Same here. I had a client who was a Honda shift worker, and we were discussing parenting time. And he was his only concern around parenting time was that the parenting time schedule could accommodate his shift work. He was worried about hours and minutes, and that's it. He didn't want to have any discussion around his identity as a father or how that identity would change after separation, his emotions around parenting or anything like that. It was all practical elements about his shift work. So I had to meet him where he was at because I enjoy talking about emotions and feelings, but nope, he didn't want that. So I had to meet him where he was at. And that led to a deeper connection between him and I and really to trust between us.
Yeah. That's and that's so good that you recognize that your inclination is, oh, I'd rather have that emotional conversation, right? But that's not about me as the lawyer, as the professional. It's about the client. What does the client want to talk about, right? And this guy, it was all about the practicalities of accommodating parenting and shift work, right? Yeah, great. Okay. Another thing that Duhigg pulls from the research are that there's two styles of decision making. I thought this was fascinating. The first one is, well, the logic of costs and benefits. This is not new. We all know about this. As professionals, we do this every day. What are the costs of the potential costs? What potential benefits of various options and solutions? and we logically weigh the cost versus the benefits before we make a decision. So this wasn't new. This is something we do every day. But he talked about a second way called the logic of similarities. This is very different to me, at least. This was a revelation. In this decision-making process, facts are less important and less persuasive. Reason and logic are not used. In this process, our clients ask themselves a question. What does someone like me usually do in a situation like this? So what does someone like me usually do in a situation like this? These folks love to hear stories and share stories, and they appreciate compassion and understanding. So I remember a collaborative case I had, which did not go well. My client was alleged to have had drug issues and being a bit of a negligent parent due to his drug abuse. And I explained that we came up with a plan for staged time with his children. That if it was a minimal at first, if it went well, then it would get better, and if it continued to get better, well, then it would increase again. And I explained to him that a judge would likely err on the side of caution, would want him to prove that he's drug-free, and that a court process would probably take 6 months before a judge to get started. And the whole case would probably take, maybe 2 years before it was resolved. It would cost him a fortune, and he would miss time with his kids. I saw no benefit to going to court. I didn't see any way that he would do better in court, and it would just cost him more money and delay the process. But he terminated the case, and he went to court. I couldn't figure it out. It did not make sense to me until I read Duhigg's book. And then I think this guy, this is my guess now, is that he was using the logic of similarities. Maybe he was seeing himself as a fighter. A fighter would go to court and battle it out. He was an entrepreneur, and he'd always done battle all through his life to get to where he was. And so I think, if I thought of that, if I thought that was how he was making this decision, then I could have had different discussions with him. I wouldn't have done the cost-benefit analysis. I would be talking to him about how he's made decisions in the past and what he's inclined to do as a person who's a fighter, always been a struggler. I don't know. I think I could have had a different conversation and maybe helped him avoid court. I could have said, fighters are always strategic, and you got to know when to fight and when to settle to be effective, and talked about maybe similar situations where he'd settled matters sooner so that he could get a better result. Anyway, I thought that was interesting. Alex, have you ever had a situation like that?
Yeah, this insight from Duhigg has really been revealing for me too, because I've sometimes found myself, I don't think I'm alone in having found myself reverting into or defaulting into a fighting mode when a client presents in a fighting mode and about the fight. And sometimes that can even end up in me getting into a controversial position, even with the client, about this issue or that issue, which is exactly the reverse of where I want the conversation to go. I want to more deeply connect with that potential client or that client and not get into a fighting mode. And so this logic of similarities and understanding that, and therefore being able to work with that in these different ways has been really revealing. There was a personal anecdote, Brian, that I recently had the occasion to observe, which relates to you and your own communication. I happen to be privy to a dialogue between yourself and some other parties engaged in a certain conflict there. I was copied on the email, and I watched how this unfolded. And there was an observation that you made there, which I found so profound, and yet so simple. And it was a statement. Here it is. If you don't pick a fight, you won't get a fight.
Right.
I have since relayed that to clients and potential clients going forward to try and coach them to be sensitive to a position that they don't want to get into with their partner or a conversation with others, period, because they want to become more productive in their communications and recognizing that as a real way to do it.
What about you, Christina? We have just a minute left.
Same here. And mine is kind of on the flip side because I've had clients, a few clients who will cave in. And we've had discussions about how they've caved in throughout their marriage, they've caved in throughout their life, they've compromised. So even though they may have a really strong case, they're willing to just give it up just to get it resolved. And so I have had discussions with them about, they have a history of caving in, and that shows up now when we're talking about their family law negotiations. I've had quite a few people, it's an odd scenario, but I've had quite a few clients who are stuck with an expensive car that they don't want because the spouse wanted it during their marriage and they got it, and now they're going to be paying, a monthly amount that is really too high for them. And they just cave in and say, oh, well, they'll figure it out. It's just they have an identity as someone who compromises, and that just continues.
Right. Yeah. Okay, so it's Shannon, I think it's 11:30. I think you wanted to have a break at this time. Is that my understanding?
Yeah, that's right. So we're gonna have a short break. Thanks so much for the presentations so far. Part 1 was fantastic. We're gonna come back for part 2 at 11:45. So go grab a coffee, do whatever you need to do, and we'll see you back here in about 15 minutes.
Perfect. Thank you.
Okay, thanks everyone.
So
Hi, everyone. Welcome back. Hello, hello. Welcome back, everyone. Hope you had a nice break.
All right, shall we just launch in?
Yeah, let's get right into it.
All right, well, I'm going to share my screen again. Okay, Duhigg says that we're all taught to take the other person's perspective and show that we are empathetic. Instead, he says we need to ask more questions to understand the other person's perspective. So we're not perspective taking, we are perspective getting. The idea from Duhigg's material is that we need to ask deep questions so that we truly understand our client's emotional state, their values, beliefs, feelings, and their inner life. Of course, I've been using open questions for many years, but this is different. Deep questions come from the work of Elaine and Arthur Aaron. They discovered 36 deep questions. That's called the Fast Friends procedure. These questions are asked in order and answered by both persons. So you ask a question and then you answer the same question before moving on. So you can Google it. It's called 36 Deep Questions, and it's by Elaine and Arthur Aaron. Aaron is A-R-O-N. And they used these questions with a group of hedge fund managers. Now, hedge fund managers are not used to showing vulnerability. I don't mean to stereotype, but many are not used to being vulnerable. And they're generally used to yelling at each other and aggressively pursuing their goals. They were asked to form pairs at this conference. Form a pair with someone they've never met before, and then ask 3 of these 36 questions. The researcher just dove right into it, and when the exercise began, something special happened. Many of these men and women began opening up. Some were crying, and it was quite remarkable. In fact, it was remarkable to the point that 2 of the hedge fund managers who met through this exercise at this conference started dating and eventually married each other. So it's pretty cool. So Christina and Alex, what examples of deep questions do you offer to get the client's perspective to understand who they are? Christine?
My favorite deep question is to ask a client, what does your life look like once your case settles? I don't want to assume their long-term goals, but I want to know what their long-term goals are so that I can set them up so that they can get there. I also find that asking this question makes them a lot more comfortable, and it puts them in a different frame of mind, right? They're not stuck on the nitty-gritty, it gets them forward thinking. That is hands down my favorite deep question to ask.
Yeah, and it's remarkable. I find when I ask it, it changes the whole dynamics with the client, right? Because they haven't been thinking about what life will look like when everything's resolved. And so all of a sudden you're giving them hope that there's going to be a better day, but you're starting to get to them to focus on what's important to them and their values, right? That's right. That's, I think what you're doing is you're saying what's important to you. What do you want life to look like, right? That really is an expression of their values and priorities.
Yep.
Alex, any good questions that you use?
Well, to build on that one, tell me more about why that is important to you. Is a follow-up question that oftentimes yields more information. A good example is, well, I want to stay in the house. Well, why is it important to you to stay in the house is oftentimes a revealing direction for the conversation to take.
Yeah, and then I love that because you can say that first why question, but then you say, tell me more. tell me more about why that's important. And that takes them to a deeper level. And it sometimes I find, the clients are sometimes stumble, when you ask them to go a little bit deeper, but it's really revealing, and you're building that connection by asking those questions. One risk is that we assume we understand the client's perspective, right? When we could be wrong. We need to ask. I'll tell you a quick story. I remember many years, 30 years ago, client came in and her child had been taken away from her by the CAS. And so during in conversation with her, I had assumed that she wanted to find a way to get her child back. And it wasn't until the end of the conversation that I realized my assumption was totally wrong. She knew she was not able to look after her young child. And all she really wanted at this point was to maintain a relationship, see the child occasionally so that she would have an opportunity to get her life together, clean up her drug addiction and all those sorts of things. So I felt so foolish that I had made that wrong assumption. What about you, Christine?
Yeah, mine is along the similar lines. I am really bad at this. When talking about parenting time, I assume that parents want 50-50 parenting time. And sometimes that is not their goal. And so I'm really working on putting that assumption aside and asking them, what do you want, right? It's not about what I want, it's about what the clients want. And yeah, that is my one big assumption. I'm always assuming 50-50 parenting time.
Yeah. Yeah, that's important. We need to be aware of our biases, right? So that we don't assume that somebody's going to have the same perspective as us. We have to ask, right? Yeah, that's great. How about you, Alex?
Yeah, I must say a lasting lesson that stayed with me, Brian, is an anecdote that you related to me some time back about your earlier life experiences in working with and training quarter horses. And you explained in working with several different horses throughout the course of a day in those days, you learned the lesson never to assume that any of the attributes exhibited by a previous horse were going to be repeated with the horse that you were on. You start from scratch. You don't make any assumptions about the way this horse is going to behave. Otherwise, you may get hurt. So you learned the lesson well. You passed it on to me. And as you explained then, it's the one lesson you've been able to, it's transportable. You've been able to apply that lesson to your own practice of family law. And I've learned from it too.
Yeah, that is a good lesson, before an initial consultation, I try to have a few moments. I read their intake forms. I understand the basic facts of the case, but I try to separate myself from all the other things that are going on and come into it. So you, as you said, to start from scratch, blank slate, blank page. Let me understand who you are and what your needs are. There was a question. I'll just answer this. There was a question. How do you deal with the client who won't talk? You ask an open question. You say, "Tell me about your life circumstance," and they say, "We're getting a divorce." And tell me about your children. We have 3. Right? So those are tough clients. So my answer to that is I start, when I have a client like that, I start to sort of prime the pump. So what I do is I start asking direct questions and I say, okay, tell me about your children. How many children do you have? How old are the children? What are the activities of the children like? How are they feeling these days? Have you told them about the separation? Who's been involved in parenting the children? So these are not open-ended questions. These are closed questions. It's sort of like a cross-examination. But I get the client talking, prime the pump, and then I start to slip in, well, tell me more about the children, right? And then that's an open-ended question. And they're after they've been primed a little bit and they're talking and opening up a little bit, then they'll start to hopefully share more of themselves. But, I think the key, Duhigg would say, is you need to connect with the person, and keep working on that neurological synchronization, and have the type of conversation that they want to have so they feel comfortable and they trust you, and use laughter. There's lots of tools we've talked about that you can use to connect with the client. So when the client feels connection and trust, they're going to open up and share their perspective and their values, their priorities, and retain you, right? So that's a long answer to a short question. Okay, so let's ask the next survey question, Daphne or Shannon. Do you ever fall into the trap of assuming a client's perspective? Yeah, yes, I often make assumptions. Sometimes, but I try to remember to ask if I have it right. That's a really good question. You know, if you think you've got their perspective, you offer it to the client, right? I understand that your goal is to build a relationship with your child, and you're not really wanting to remove the child from CAS's care. You want a relationship. Do I have it right? Because you might have it wrong. So that's a really good technique. No, I'm always very curious. Okay, let's see the results. Yes, I often make assumptions sometimes, but I try to remember to ask if I have it right. No, I'm always very curious. Well, for those 22% who are always curious, good on you. You're a super communicator, and that's where I hope to get one day as well, is to consciously always try to be curious and try and don't make assumptions. I don't want to fall into that trap. Okay, thanks. You can close the poll. We'll go on. So looping. Now, I was always taught that I should maintain eye contact and keep nodding my head when my client is telling me their story, or say things like, oh, I see, or something like that. Duhigg says the research suggests these gestures are not effective. Duhigg says we need to do more, and we need to prove we are listening. So Duhigg is a big fan of looping to prove we are listening. This is something I'd never thought of. I've heard of looping, of course. It's a very much a traditional technique taught in mediation courses and in collaborative courses. But I've never understood it to be a way of proving that we're listening, and it's interesting. So simple: ask a question, an open question, and then when you hear the answers, you summarize or rephrase what you've heard the answer to be, and then ask if you got it right, and then start over. Oftentimes, lawyers start off with an open question, and then we fall into cross-examination mode, right? No, don't. Keep looping, and getting to know your client. The open-ended questions after open-ended questions really help to, deep questions help to reveal what's going on for the client. And what Duhigg says is that through looping and proving that we're listening, you draw out emotions. And by proving that you're understanding, proving that you're listening, that you're caring. Of course, matching the client's tone and mannerisms and feeling also proves you're listening and doing our best to understand them. Because clients who feel heard will be happier clients. Christina, what's your experience with this?
Yeah, I really like looping. I feel like when you loop with your questions, your clients really do feel heard, and that in turn deepens your connection with them. They become more comfortable with you, and really, really important, they're more willing to open up. And so when you loop, it's an invitation for the client to go deeper. So for example, if I'm screening for domestic violence, I will always ask, what does conflict look like between you and your spouse? And for instance, I might get an answer that's something along the lines of, oh, we'll yell and we'll shout, maybe we'll swear sometimes. And so I'll summarize exactly what they've said to me. Okay, I understand that conflict between you and your spouse often turns into, devolves into yelling and swearing. And then I ask them, do I have that right? Which invites them to dig deeper and gets them to tell me more. And I think if I didn't ask that question, I might never get to the answer that I really want, because they may not feel comfortable. And so it gives them space to open up.
That's interesting. You said it gives them space. Can you talk more about that?
Yeah, it invites them to dig deeper, right? It invites them to think about it. And I think they're just asking that question and having them feel heard, right? It really makes them feel more comfortable, and then they're more willing to share.
Ah, yeah. Cool. What about you, Alex?
Yeah, very similar theme. This reference you've made to looping, bringing out emotions was really manifest for me. Just recently, I met with a man during a consultation, their prospective new client, who presented as a real rough and ready character there. That was his personality. And he spoke briefly about his relationship with his daughter. And when I did some looping there to check in with him about my understanding of that, did I get that right? Wow, this personality type that had been demonstrated up until that moment just disappeared. He broke into tears and then said to me, "I'm sorry, you promised myself I wouldn't do this." And then he went on to reveal much more deeply important factors and considerations regarding his relationship with his daughter. So, whoa, what an effective tool.
Yeah, and clearly he must have trusted you, and he felt that you had created a safe space for him to share his feelings. And that's what we want to do with our clients. We want to create that safe space so that they will connect with us deeply. And yeah, great, good job. Good. That's so cool when you have moments like that, right? And it's moments like that you want to share with somebody, and nobody gets it. What do you mean, Alex? You made a client cry? No, it's not about that. It's about us connecting as two human beings, right?
Yeah, it's a satisfying moment. Yeah.
Yeah, it's a real victory. That's a gold star moment. Yeah. Okay. So that takes us to what Duhigg says is another tool called or what he calls reciprocal vulnerability. He says that reciprocal vulnerability can lead to emotional contagion. In other words, if we want to really connect, we need to share something of ourselves when our client shares a story of pain or joy. So, for example, if a client tells you a painful memory or a moment of joy, and we reveal our own pain or happiness, it creates an opportunity to connect through our having a shared similar experience. It creates an opportunity to share feelings together. And it's an invitation to open up for that person. So what's your experience with this? I'll tell you, my own experience is that I often will tell people that I've gone through my own divorce, and I don't get into all the details of it. I don't say the ups and downs and all the whole experience, because it's not about me. But I can say, honestly, look, yeah, I remember those days when we'd have to come to the meetings and so on. It was very stressful, and I kind of get where you're coming from, because I've been there too. And it really has opened up people. I even have it on my website that I've gone through my own separation and divorce. And it really seems to, by me opening the door a little bit about my own life, shows that I'm a human being, and people connect with that. So what about you, Alex? Have you ever tried this?
Yeah, boy, a couple of easy examples come to mind. I found time and again, really, when potential new clients or supporting family members explain that their occupation is that of a nurse and nursing, I can oftentimes relate to them by revealing that, back in the days when I was a student and part-time worker, I worked at a local hospital. And in that capacity, I really got to understand and therefore have a lot of respect for nursing and nurses that filled that role. And so I know where they're coming from, and oh boy, the open responses I've received by just, revealing that vulnerability, if that's what it's labeled as being. Another good example are teachers. I have a niece who's a teacher, and it's given me some insight into that occupational role. And I find that clients and potential new clients really respond to being identified with in that way, and that really helps deepen a connection and a conversation.
Hey, the other day you told me that sometimes if someone is suffering from some physical health issues, you'll share that you have a family member who has a chronic health condition, right? And that's really opened up people around that issue as well.
That is just a reality, because people can feel sensitivities, about this subject and about that reality for them. But I can, in the appropriate circumstances, reveal that my good wife suffers from a chronic health challenge, and boy, they're interested to hear this, and so that immediately opens up that deeper connection that you're looking for. Yeah.
Yeah, and you don't have to get into all the details of it or anything. You just crack the door open a little bit, show them that you're a real human with same troubles as they have. So what about you, Christina?
Yeah, mine is similar. For instance, I had a client who suffered from a mental health issue. And I shared in a meeting that I had a member who lived with me, member of my family who lived with me as a child who also suffered from a mental health condition. And I could tell when my client was trying to tell me that about the diagnosis, that she was really uncomfortable about it. And so just by sharing my own story, and again, I didn't go into my whole life story, but just
Right.
one or two sentences, just by sharing a little bit, it really enabled us to deepen our connection with each other, and she was a lot more comfortable opening up and talking about what was going on.
Yeah, that's good. Great examples, and I think a lot of some people, I should say, are really a little bit reluctant to be vulnerable during their meeting. They think as a lawyer they're supposed to look strong and tough or whatever. I think the opposite. I think that if you show you're vulnerable and show an openness to share a little bit about your life, people will really respect that. It resonates with people. They appreciate that, and it breaks down the boundary between ourselves and our clients. So, you have to think about it. You have to be prepared. It's like everything else. This is a tool you could use and be deliberate about it. So you need to think about, okay, what am I willing to say so that I can use this to open myself up to my client? How much of the door do I want to open? And so you need to prepare and think about it before you're meeting with clients to use it as a tool. Okay, another couple of survey questions there. Do you use looping when meeting with clients? Yes, I use it. Occasionally, it's okay. Occasionally, but I want to use it more often. Rarely. What is looping again? Yeah, it's I've known about looping for many years, but reading this book, Duhigg brings back the importance of it, and he changes the perspective because he said it's about proving that you're listening, proving that you care. So I'm using it more and more. So let's see the results there, Daphne or Shannon. Yes, I regularly, that's 36%. Regularly, occasionally 17, occasionally, but I want to use it more. That's me. That's the group I'm in. Rarely 4%, and 12% weren't paying attention. That's cool. Checking their email. Thanks for your honesty. Okay, next question. Have you tried reciprocal vulnerability when meeting with a client? That's a tougher one. I bet we'll have fewer people saying yes. But when I've done this before, some people say, yeah, I've done it, but it just sort of happened, right? It wasn't deliberately used as a tool. And again, that's what Duhigg is suggesting, is be deliberate in the use of this as a tool to connect with your client. So let's see the results here. Yes, 24% use this as a technique. Occasionally, I deliberately use it. I have occasionally used it, but not deliberately, 38%. Yeah, that's typical, is that people maybe do it, but it's not a deliberate thing now. And that's what I think we need to start being more deliberate in our choice of tools we use during our conversations so that we can build that connection. Okay, thanks. We'll move on. Okay. So social conversations are about who we are, our identity, and how we see our place in the world. Remember, our goal is to have a learning conversation, and so we can connect and become aligned. So in social conversations, it's helpful to start by finding a multiplicity of identities, a multiplicity, and explore them with curiosity. Look for similarities where you and your client share the same identity. Now, these conversations can be difficult. They can go badly, Duhigg says. You can trigger what he calls an identity threat. This is when you say someone does not belong, or you assume that they are part of the wrong group. In other words, you get it wrong. This can cause a lot of discomfort, and you can alienate the person instead of building connection. So you have to be careful when you're exploring people's identity and having these social conversations. I did a consultation a few weeks ago where I discovered that the potential new client had quarter horses. And so I said, hey, I used to show and train quarter horses. I paid for my first university degree by training problem horses, breaking horses, and giving lessons and showing horses. We instantly bonded. We were part of a shared community, the quarter horse community. I felt a connection with my client just by sharing that with him. As a result, he trusted me and wanted me to be his lawyer and immediately retained me. At times, at the time, I did not realize what I was doing. I just had this social conversation with the potential new client, but now I can deliberately choose to do that, have that type of conversation. Last week, I was meeting with some grandparents, and they were interested in spending time with their grandchildren. And I tried to connect through us both being grandparents. I have 2 grandchildren. It did not land well. It landed like a lead balloon. No connection there. It didn't work. But I eventually found out that they both traveled in Europe extensively last year, and so did I. We did 2 trips last year. So we immediately were able to bond on that level. It was amazing. I could see the shift when I started to talk about traveling in Europe, because I was no longer a stranger to them. I was a trusted European traveler, just like them, and it was so good. We had something that we shared in common. So I often talk about being an NBA fan. That's something I can share. Another, I love canoeing. I often will connect with people when I discover they're curlers, because I love curling. And of course, when I talk about curling, it's not with people from Florida. They have no idea what we're talking about. But anyway, it's really a nice way of connecting with a client to find something, some identity that you share with them. Christine, what have you found works?
Yeah, I found that because, well, I work out of the Barrie office, and that means we get a lot of rural clients oftentimes. And I live rurally, and so I can connect with clients about living rurally. We can talk about, the bad internet, the bad roads, you can't get any cable TV, just the whole experience of rural living. And that really makes me feel connected to the clients, which in turn makes them more comfortable with me, right? I'm revealing myself, just I'm a human being, and that really does make them feel more comfortable.
Yeah, we're in this group together. We're rural livers. We're living in a rural setting, right? We're brothers or sisters, right? Part of the same family. What about you, Alex?
Yeah, I guess I just reiterate, frankly, those comments I made about nurses and teachers as a group, because boy, it's hard to fake or to replicate. That feeling that you're in a common group with common interests, and therefore that's going to translate to a common understanding, and therefore deepen that communication.
Yeah, and it's not about the facts of their case or their divorce or their situation. It's about the two of you sharing a bond through your common identity. So yeah, it's interesting how that works. Okay, ask survey question 7. Have you tried finding a social connection with your client? I deliberately use this technique. I occasionally deliberately use it. I have occasionally used it, but not deliberately. I want to start using this tool more often. So yeah, it's helpful. And I would say prior to reading this book that I would often use this technique, but I didn't know it. I didn't realize I was trying to establish a connection between my identity and their identity. But yeah, there you go. Now I do it more deliberately. Okay, so let's see the results. 25% deliberately use this technique. So 26 occasionally. 41%. I have occasionally used it, but not deliberately as a tool. And I want to use it more often, 8%. So that's interesting. Yeah, that was where I was at. I occasionally used it, but I didn't know I was using it, right? I didn't realize that it was a tool to deepen connection. So now I can use it deliberately and choose to use it. It's in my toolbox. Okay, thank you. And we're going to just go have a few, whoops, we did that. Key takeaways. And then I'm going to turn off the slideshow and we'll look at the questions. And if you want to post any more questions in the question box, we can answer them while we're still on. We've got a few minutes left. So Alex, what's this book, Duhigg's book, Super Communicators, meant for you?
Boy, I feel like I have a lot I want to say. I suppose the big takeaway, and I hope it's resonated with folks today, these highlights are, for me, have been remarkable because the book provides a roadmap to break down the various components that, yeah, sometimes, as Brian's been saying, we're just, we know intuitively where they may be part of our practices intuitively, but it makes it a deliberate act. Revealing them allows the reader to examine those components, think about, yes, their own communication in those respects, but even to work on and practice those various components so that they can become better at communications. And that for me is the real big takeaway, and I hope it's been a takeaway for other listeners today.
Yeah, for sure. Yeah, Christina, what about for you?
My big takeaway is really, it's about meeting people where they are, recognizing what type of conversation you're having, and then meeting them there. Matching people, match their mood, match their energy. It's really about giving them space, and the real big takeaway is just meet people where they are. come down to their level, don't assume, right? Yeah, meet people where they are.
Yeah, good comments. Yeah, for me, you know, we started this webinar to talk about AI, and the AI is a tool, and I think it's an important tool we can use in our practices, and I think it's going to be beneficial. But what's more important is that we connect with our clients, and that's why I really enjoyed this book, because it really taught me how we can better connect with our clients. And it's research based, it's science, it's not speculation or hoodoo, or you know, it is research based information. So I would really encourage everyone to get this book, listen to it, read it, or do both. I'll answer a few questions. One question about AI was, how do you address concerns re confidentiality when using AI? And that's a very important question. You know, ChatGPT will, if you put information about your client into it, it's like spreading it everywhere in the world. So one thing you can do is you can change ChatGPT so it doesn't learn from you. That means it's not using your private information for others to distribute it widely around the world. So that there's a switch you can flip in ChatGPT. But and I'll answer. Somebody asked about the platforms we use. One is Copilot, and the Copilot is a Microsoft tool that works with all the Microsoft products like Word and Outlook and Excel, and actually many of the visuals that were created for this PowerPoint were created using either Copilot or used ChatGPT. So the nice thing about Copilot is it doesn't, again, it's confidential. It only works on your materials, and it doesn't disseminate the learning outside of your materials. So but this is something you need to always look at, is whether it is maintaining the confidentiality of your client. Other tools that we use is, what's that legal research platform we use for memos? Alexi. Yes, I always forget. Alexi is really great, and it creates a legal memo using AI, and it pulls case law, and it has connections with actual cases. It doesn't hallucinate cases, but it may interpret it wrongly. You know, so our policy at our firm is, yeah, use AI for your research, but you need to confirm that the conclusions reached by the AI are real and accurate. You don't assume that AI got it right, because we had a memo that came out of was produced by AI, and it had the wrong conclusions. It had the right cases, but it misinterpreted them. So you need to verify the results. We use Westlaw, and Westlaw also has an AI component which helps us do legal research. So those are worthwhile. So are there any other questions that people might have? You can post them under questions and answers.
Yeah, if I'll just jump in here. If anyone has any additional questions for Brian, please put them in the Q&A. I love how we got onto this topic of AI. It's such a hot topic right now, and you know, going from communication and how do you communicate effectively with your clients. Now we're communicating with AI, and that's a whole other topic.
Right.
It's a good transition, and there will be a session on AI tomorrow towards the end of the day. So if you're wanting to learn more about that, make sure you're registered for day 2 so that you attend that session as well. We're really looking forward to it.
Great presentation. I really like the looping aspect, Brian. I would use mirroring that, that we learned through collaborative practice, often repeat back to clients. So what I hear you saying is X, Y, Z, but I never took that extra step saying, did I get that right? That is that fourth step I never looped in. I just assume, well, I've got it right. I'm saying it, but that's a good way to lock it in.
Yeah, and it also, like Christina said, it creates a safe space for the client to go a little deeper if they want to, right? It's an invitation to say, is that it? Is there more, right? So yeah, it really is effective, and we need to remind ourselves to use that tool often in our meetings.
Yeah, it sort of completes that circle, right?
Right.
You stop at the mirroring, but I never thought, there's a further step you can take to dig deeper, or confirm that's right, or maybe there's something else, or maybe it wasn't right.
Yeah. And the other point I really want to emphasize about looping is don't just use it once. Use it over and over and over again in your conversations, right? And you'll find it more effective if you do that, right? Like I said, it often as lawyers we ask one good question like that, and then we start to cross-examine, and we get off track. We need to always be looking for the client's values and goals and interests and what's important to them. And looping is a really good technique.
And sometimes those hidden nuances that you may not pick up without asking, you can lead to impasse, right? They don't, that's a stone that was left unturned in your initial consultation, or there's an emotional connection or something the client's not sharing with you that you may not discover until 2 or 3 meetings later.
Right, absolutely. Yeah, and although we were talking primarily about the initial consultation, because that's where you're really starting to first get to know the client and you hope to build a trusting relationship so they'll retain you. These techniques can be used throughout the course of your whole case with the client. They're really useful to maintain that trusting relationship.
It doesn't even have to be in the collaborative setting. A lot of collaborative tools make lawyers better litigators.
Oh, absolutely. All of our lawyers are trained collaboratively, but about 30% of our cases are court cases. And we go into, the way we interact with our client doesn't change. We continue to use the same tools that we use in collaborative cases, in litigation cases, in every type of case, in lawyer-to-lawyer negotiation or what have you. They're just good communication. And that is key, Russ. You know that. Good communication is key to the successful practice of law.
Yeah. This has been a fantastic presentation. Such a unique perspective. I've learned so much. Thank you so much. Alexander, Christina, fantastic insight. I appreciate it. I like the horse story too. That was interesting, right?
Well, that story is I used to train horses when I was in my early 20s and during university, and you get on a horse and you have a bad ride with a horse and you're fighting them and you're struggling and you get off that horse, and then you have to, the next horse maybe doesn't have that same attitude, right? And so I learned at that point in my life, I just have to take a deep breath and separate them. My experience from the bad horse to the new horse. And that's what we also need to do in our own practices, Russ. Like if you have a nasty conversation with another lawyer or a difficult situation with your own client, you end that, you've got to put that behind you and come to the next meeting fresh with a blank slate, open and willing to connect with the next client. So yeah,
that's a pro tip. We did have some questions coming in about collaborative practice, how to get the training. I think there's training coming up this fall, right, Brian?
Yeah, we've got a course that Jonathan and Carrie, you and I are offering. It's starting in the end of October. I'm not sure what the date is, but our website is, I think it's cptraining.com. and that's where you can learn more about the training. So we have the full training that you need to take to be able to take on collaborative cases.
Yeah,
So we've already got a bunch of people registered. You know, since the pandemic started, we've trained probably 175 or more people. You know, there's so much interest in collaborative practice, and maybe not all of them are doing collaborative cases, but the whole approach to a file, it's really helpful if you understand the collaborative approach and understand. So it's still useful in all your other cases as well.
So if you go to the chat box, Shannon just dropped some information in. There's a link if you want to sign up. Starts October 21st. And I think we're offering a discount code for people who attend this program this week, right, Brian? If they sign up by Friday, 10%.
Yeah, don't tell everybody. It's only for people who have signed up for this course. This is for you folks, not for your friends and colleagues. But yeah, you just type in early bird when it comes up with a with the, you know, if there's any discount, and you'll get 10% off. We've got a bunch of people already registered, so we hope to fill the course over the next few weeks.
All right. Well, thank you so much. It's 12:30. I really appreciate this. Great presentation. I know hopefully the audience got as much out of it as I did. It was fantastic.
Russ, it looks like we buy our ties at the same location there.
Yeah, Value Village or whatever. Yeah.
All right. Take care,
All
everybody.
right. Have a good
Thank
morning,
you.
guys. Good afternoon.
Thanks
So-
for doing this, Russ.
Thank
Yeah.
you. Yeah.
Bye-bye.
Great job. Appreciate you presenting. So a few housekeeping things just before we wrap up. We have our lunch coming up, and I see our main host, Shannon's back. Welcome back, Shannon.
Thank you. Great presentation.
was
And
so
it'll tie well into, I feel like the presentations this afternoon are going to be very complementary to those. I know you mentioned impasse as part of things that come up in those scenarios. So I'm looking forward to your presentation with Carrie and Jonathan, and then more on option generation. It'll tie in nicely with Brian, Alex, and Christina's presentation.
Yeah. I want to thank everybody who's attended so far this morning and everybody watching on YouTube Live. Really appreciate the turnout that we have. It's been fantastic. We a few tips. Participate in the polls if you can. It's really helpful for the speakers to tailor their content when they can see the results and maybe focus on different areas. So poll participation is really helpful to the speakers. Submit your questions early if you can. Lots of the presenters will answer the questions throughout the course. If you can get the questions in early, that gives them time to get to all the questions. If they have 20 or 30 come in the last few minutes, we might not get to them all. Want to thank our speakers. Fantastic lineup this morning. I did see some questions about how to donate. Shannon has put a link in the chat box if you want to contribute to the Denise House. So GoFundMe page, you simply click on the button, add in your name and credit card information, give the details if you want a tax receipt, choose the amount that you want to donate. As a rule of thumb, I know the IECP asks for 1 hour of somebody's time to contribute, but whatever donations we get, small or big, is going to help make an impact on these women's lives. So we deeply appreciate everybody who's donated so far, including Shannon, Jonathan, Jean, and others, and hopefully we'll meet our target. Shannon, what do you have on your list? Anything else we want to cover off?
So I know you already mentioned the GoFundMe, and I just dropped that into the chat there now, just in case there's anyone who logged on a bit later, along with the CP links there as well. We're going to take an hour break, so we'll be returning at 1:30 with a presentation on impasse with Russell, Carrie Heinzel, and Jonathan Painter. So looking forward to hearing that. And then other than that, I just want to mention that it'll be the same link for the afternoon. So you're welcome to stay on the call and just leave it live, but you can also log off and log back in once we're ready to get started at 1:30 again.
All right. So Daphne, great job. Shannon, thank you so much for everything this morning. We're going to save everybody back here at 1:30, but we'll leave the program live. If you want to just come back at 1:30, we'll be here.
Good. And sorry, Russ, just one last point. I had a few questions coming in about CPD hours. So I did drop the agenda. There's one that has a snapshot of which ones have been accredited, but then there's another agenda that I shared that has the detailed outlines along with the hours of CPDs that you can get for each presentation. But just as an easy reference, each one that has an LSO badging has been accredited for 1 hour of professionalism, with the exception of one presentation tomorrow, which has been EDI professionalism. And it's my understanding all others can be submitted as substantive, as those do not need to be accredited.
So day 1 and day 2 qualify for 12 credits total.
Yes,
5 professionalism, 1 EDI, 6 substantive.
exactly.
Excellent. Good summary. Thank you, Shannon.
All right. Okay, we'll see everyone back here at 1:30. Enjoy your lunch.
Thank you. Good afternoon, everybody. Welcome back. Got a few minutes before we begin. DJ Shannon.
No, I'm not the DJ this round, Russ. I've passed the ratings.
I feel like I'm in a club or something.
Yeah, it's like kind of like a loungy club, I think. Like maybe
What a great morning, right?
it's been wonderful. Welcome, Carrie. How are you?
I'm well. How are you?
Good, thank you. Oh, I also see Jonathan.
Good to see you both.
So we've done great. We're at $5,865. I want to thank Annabelle, who just donated 200, and an anonymous donor who just donated $50. So thank you so much for supporting the Denise House. It's deeply appreciated.
Yes. Those were pretty shocking numbers that Sandra shared this morning, and yeah, it's really good to know that, you know, these funds will go towards creating a safe place for women and children in our community.
Yeah, and it's something physical that they built, right? They got a new center, they're getting new equipment. So I like the idea of making the facility the ability to accommodate larger pets too, because pets are sometimes the only stable thing in people's lives or children's lives when they're going through separation.
I know with my kids, I don't think they'd ever want to be separated from their pets.
We have lots of separated families. The dogs travel with the kids.
Yeah, it's a big deal.
Common. Yeah,
it's a really big deal. Now, I know I try and travel with my dog.
Where it was a bird, it was a parrot that would travel with the kids.
yeah. I don't know, Shannon, could you give up Jack for a week?
Well, I actually am right now. He's got shared custody with his dad, so he's my cat's gone for a little while.
Are you going through withdrawals?
I did for a day, and now it's kind of nice. It's a little bit more quiet, but I will miss him.
Yeah.
I've always been a dog person, so the fact that I'm even attached to a cat is very new.
Should get another dog.
Yeah, I would love to. I don't know how my cat would feel about that though.
I have cats and dogs.
Do you?
Both.
They get along well?
Extremely well, and I'm pretty sure they conspire with each other against me so that, you know, they're all getting what they want. Miraculously, things land on the floor that were never supposed to be on the floor, and my dog doesn't seem to mind.
They have you outnumbered.
Oh, very much so. Absolutely. And I love it when, you know, I go to bed, and if I have to get up in the middle of the night and come back, my spot is gone. It no longer exists. It's like they all look at me like, what? You got up.
That was your temporary
Who's in charge
spot.
of who, Carrie?
Sorry?
Who's the owner? Who's the owner? You or the pet?
Yeah.
Oh, Stanley the cat. He owns everybody. Like he owns the dog, he owns me. I just, you know, my whole goal in life is to pay his mortgage. You know, it's his house. It's all his.
Those cats are almost too independent. Wouldn't it be cool to know what they're thinking sometimes when they give you that look, you know?
No, I'm actually afraid of that, Russ. I'm very, very fearful of that. I don't want to know what they're thinking.
Well, we got 1:30. We're going to get into this. Any other housekeeping things we want to cover off, Shannon?
No, just a reminder, if you have questions throughout the presentation, to send them in through the Q&A. And we also will be sharing links and resources through the chat. So I think that covers it. If you have any questions throughout, feel free to email me, but I'll also be behind the scenes once we get started with the presentation. So I'll be available through the Q&A too, if needed. So I think that's about it. And then I can get into some introductions.
Sure. Let's throw our first poll up and start our introductions if that's convenient. And we'll just get everybody's feedback right off the bat.
Sure.
And thank you so much, Carrie and Jonathan, for joining us this afternoon. I'm really, really looking forward to your presentations and participating in this one.
Yeah, what a treat. 2 hours with Carrie and Jonathan.
I don't know if everybody would agree with
A
it.
treat or
being a treat.
torture? We haven't decided yet.
A treat and an honor.
We know we're going to learn a lot, and we know we're going to have fun. It's always guaranteed with your presentations.
Well, I
So
always want to have fun.
First poll question right out of the gate, even before we get to intros. Have you ever experienced impasse? So we'll give everybody a minute and let's find out who we're presenting with today, Shannon.
Sure. So if you haven't seen our programs with Carrie and Jonathan before, I'm just going to take a moment to introduce them. So Carrie Heinzel is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for seasoned practitioners. She sits on the board of directors for York, and Durham Collaborative Practice and is the president of the OACP. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition to that, Carrie has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution, Institute Ontario Annual Conference, and the International Academy of Collaborative Professionals. Thanks so much for being here, Carrie.
My pleasure.
Next, we have Jonathan Painter. Welcome back, Jonathan. Jonathan is a registered social worker and psychotherapist who works in the family law system, completing parenting plan assessments, voice of the child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, and couples counseling for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of the Collaborative Practice Durham region. So today we have Carrie and Jonathan presenting alongside Russ with a presentation on impasse. And I'm just going to go back here, and nope, I'm just going forward. Just having some technical difficulties here, everyone. But before I get started, I just wanted to do a quick summary of what they'll be going over for all of you. So they will be discussing, oh my goodness, you think I know this by now, how to control the PowerPoint.
I think we're going to be discussing impasse.
Impasse, yes. What it is, what it's not, conflict styles, preparing for impasse, distorting the separation, effective communication strategies, bring in the neutrals, bring in the lawyers, boomerang cases, and they'll also be sharing some case studies, and we'll do our best to save some time for Q&A throughout. So as I mentioned, you can send in your questions through the Q&A, and we'll be answering those. I imagine we'll have some time while we do polls, but also towards the end of the presentation as well.
All right, thank you so much for those kind introductions, Shannon. Maybe we could see the results of our first poll.
Absolutely. So
have you ever experienced impasse? Yes, 77%. Wow, that's pretty common. 4% said no. What is impasse? 17%. Well, must be a really effective lawyer, a really reasonable client if you haven't had that. And 2% other. You can just put that in the chat box or the Q&A box, and we'll find out what that is. So thank you so much. Big theme of what we're going to talk about today is normalizing impasse. We're going to talk about it, give you some strategies. In my view, the biggest takeaway is you want to normalize this right from day one. So when I meet with my new clients or am I doing a consultation, I explain this is a normal part of the process. There'll be impasse regardless of what process you're in, if it's negotiation or court action or a separation agreement or collaborative practice, is commonplace. But who wants to start us off with a definition of what impasse is? Carrie, you want to take a swing at this?
Well, impasse, quite frankly, is the easiest definition is you just don't agree with what's being presented in front of you. You have two differing opinions, two differing thoughts of what's really going on in front of you. And an impasse can be all different sizes. It doesn't necessarily mean it's something big. It can be all the way down to you guys having a disagreement about how somebody likes to take their cup of coffee. That can be an impasse. It can
Who
also
takes the
be as
last
big as
donut?
Yeah.
exactly. Well, in that case, Jonathan, I'm going to tackle you if you take the last donut, but that's beside the point.
Jonathan, your thoughts on what impasse is?
Yeah, I mean, it's just whenever there are competing interests, and in negotiations, there's always competing interests. It could be, something minor, like I want a 4:30 p.m. pickup for the kids instead of a 4 p.m. Or it could be something major, like I'm not giving you any of my pension, no matter what. So usually there are emotional issues that underpin the impasse. And that's kind of what today's presentation is about. It's about kind of understanding some of those emotional, psychological underpinning issues that can cause impasse.
And it can come at any time. It can come at
What's
any
that?
time, right? And it can derail an entire agreement. Let's go into story time for a moment. I had a client, no kidding. The whole case was settled. We were down to one Kirby vacuum cleaner. Now I'm dating myself. 30 years ago, people used to go door to door and sell vacuum cleaners. That would cost like $3,000 or $4,000, right? You'd put it on a payment plan. And long story short, this professional couple, they're both college professors, had a disagreement over the vacuum cleaner. My client, the husband, said, I want the vacuum cleaner. Wife says he's never vacuumed a house in 20 years. The case was done. And so we're going back and forth. I said to the landlord, what's going on? Why can't we get through this? My guy really wants the vacuum cleaner, and he goes back to his client. Wife says he doesn't even own any carpets. Right? It wasn't about the vacuum cleaner, is my point. There was an unresolved underlying issue, which is what you're talking about, right, Jonathan?
That's a great example, Russ. Yeah, the vacuum cleaner isn't really the issue. It's the emotional issues that underpin it. And in that case, the husband sounds like he found a really great way of just jabbing in a little shank into the side of his ex, figuratively, by trying to get the vacuum cleaner off her. So, Carrie, what would you say is not impasse? Russ, too. What do you think?
What is not
is not?
impasse?
Yeah.
Oh, that's actually a great question. So impasse is not a sign that someone's failing or that they're doing a bad job. So often we take impasse as this, oh, well, I'll throw this entire process up in the air and throw it away because it's not working. It's not that. Impasse is normal. It's going to happen in everything that you do. So to say that you're failing, that's not impasse. Doing a bad job, that's not impasse. That's just a feeling that you may have as a result of it.
And it's not a sign that your clients are a problem, right? Oftentimes, I hear many lawyers say, oh, I've got this nightmare client, or the client's a problem. They're legitimately allowed to have their views and opinions. And if they're hitting an impasse, it's up to the professionals, especially if you have a full team, to drill down and find out what the underlying issue is. It's usually not the issue that they're deciding that they want to die on this particular hill. There's usually something else going on.
Absolutely. And you know what? It's also not a sign that you have to go to court. If you're in collaborative process, or if you're in mediation or any other types of alternative dispute resolution, it's not the sign that you need to go and run into court and have a judge decide the issue. It's usually meaning that you just have to dig deeper into something. And sometimes it's not even that. I've found so many times when we just sit and you listen to what the beef is or what the total problem is, that person just being heard is sometimes all it takes to get past to the next level. So you don't take it as, oh, everything's failing, we must run to court.
Yeah, and probably
sometimes I find like a break can help too. I often in my negotiations come up against the impasse about Christmas, and people can go away feeling very upset and not agree about how they're going to share time with the kids on Christmas. And then often what I'll do is suggest, well, why don't you just take a break? We'll come back to it next week and talk about it again then. And that is often enough to just give them time to, emotionally decompress and turn their minds back to it. And they realize, oh yeah, I was kind of being unrealistic and maybe a bit of a jerk by saying that the other parent can't have the kids on Christmas ever. So I find sometimes just people need to calm down and think things through a bit, and that can get you through.
Have that soak time with the idea.
What I hear you saying is that separation agreement that says Christmas time is to be shared equally is not detailed enough for some people.
Great active listening there, Russ. Yes.
I want to do the loop. Did I get that right?
Yeah. I mean, it depends on the level of conflict in your clients. If your clients are people that get along and they can sit down and have a coffee and talk about the kids and agree to things, you may not need to specify a time. But if you're involved in a high conflict case, which we often are, better to specify, get as much detail in that agreement as possible to prevent future impasses about, interpreting the agreement. So I think your point's very well made.
Not a sign that the collaborative process or mediation is not going to work for this family or these clients. One of the biggest objections I used to get, not anymore, is, well, what if we can't agree when I'm introducing clients to the collaborative process? And part of that process is the lawyers agree not to go to court. So if they don't get an agreement, we're not going to take your case to court. You need to go find new lawyers. This is one of the fundamental underpinnings of the collaborative process, because we want everybody to buy into it. And the objections I always used to get were, well, I want you to be my lawyer if I go to court. And what if we don't agree on something? And I don't want to use collaborative practice because so-and-so will never agree to X, Y, or Z. And that's a pretty big objection to get over and sort of explain to the client, there will be impasse, but that's normal. That doesn't mean court is going to be a more effective process to deal with that. You may get a judge to make an order to break the impasse, but it might take you 2 years to get a trial date before a judge is prepared to make that order, especially if there's conflicting evidence. So I find that clients who are genuine about the collaborative process help find a way to work through the impasse. But let's
Russ, sometimes I find just asking clients why they think court would be more effective to be a great question to ask. What's their expectation by doing that? It's a great way to get over some of the impasse with those objections, because sometimes they're dealing with a movie or a TV version of what reality is and not what's really going to happen.
And I get a lot of clients after they've been in court for 2 years and they come see me, and it's a heated court case, high conflict, runaway train. We've talked about this extensively. And when I explain the collaborative process to them, they'll say, well, why didn't somebody tell me about this 18 months ago? I didn't realize there was an option where I didn't have to go to court to resolve issues. So really important aspect of collaborative process, which we're talking about today, is how to get work through impasse. But the lessons you'll learn today will work in litigation files and mediation and arbitration. So the next poll question for our audience is, what issues most often lead to impasse? You've got a series of choices. You can choose more than one. And while we're doing that, let's go to an audience question that came in advance. Maybe I'll throw this one to you, Jonathan. How does power imbalance between the parties likely affect the reaching of impasse?
Good question.
Yeah, it definitely can significantly influence the development of impasse, right? Because usually if there is a power imbalance, that could mean that the person who's kind of in a position of power has what we call kind of a rigid way of thinking. So they tend to be more positional, like, I want this in the negotiation and I'm not going to accept anything else. They tend to be less mentally flexible. They're not really good at of taking in new information and using that new information to change their belief systems. Their belief systems are very, very solid and hard to deal with. And then you're also dealing with the person who's has less power in that dynamic, feeling like, oh, I just want this to be over, and I'll let them have whatever they want, or maybe the request that they're making, maybe the demands that they're making are really unreasonable, and the person with less power, is reluctant to agree to them. So yeah, that can have a major impact on impasse, and that's why it's really important for us as a team to set ourselves up for success by picking kind of the best team possible, and B, by preparing our clients as much as possible to address the impasse before it arises. So Carrie and Russ, you guys talked about clients' expectations, and when clients hear collaborative, they think, well, collaborative means we're never ever going to disagree, and the second they find a disagreement, they're like, oh my God, the whole process is a waste of time and useless. So explaining to them ahead of time that collaborative doesn't mean that there aren't any disagreements. It just means when there are disagreements, we work together as a team to overcome them and find a way around them. See them as a barrier, not as an impassable wall.
Great questions coming in. Please keep them coming in. We love the questions. Monica just sent this in. I know you answered it, Carrie, but I think the audience would benefit from this. Sometimes impasse happens when one party does not want the process to end. In other words, they're not ready for the relationship or interaction to be over. That's actually quite more common than you would expect. So Jonathan, we've got the agreement, we're all signed up, and then, somebody finds something to drag it on. Or, we'll talk a little bit about boomerang cases. What do you do with these clients who don't want the relationship to end? Or maybe they feel special, right? They have all these professionals giving them this attention and spending these days with them in these meetings. And once that ends, they go back to the regular life. They're not going to have that spotlight on them anymore. So how do you get over that aspect of impasse?
Yeah, that's a good question, Russ. And I kind of experienced that a little bit when our firstborn was born. We had our oldest child at home, and with midwives. And when the midwives were preparing to leave, we were like, no, you can't go. You can't leave us alone with this child. It's not going to survive the night. So I kind of get that feeling when people are reluctant to end the process, because they're going to lose all these supports. They'll lose, Carrie giving them financial advice, me giving them, emotional support, Russ giving them legal advice. But a lot of the times it's more about the relationship and what the relationship meant to the clients. And if someone really doesn't want the relationship to end, they're going to lose more by the relationship ending than the other person. That's when you kind of tend to see that reluctance, and you might see them missing meetings, or being really distracted during meetings, or not getting their homework with Carrie done, or not responding to your messages, Russ. That kind of avoidance behaviors that might signal that there's some kind of underlying emotional issue, that the client is really having a hard time getting through the separation and just getting their mind around it. And it can be a really hard psychological healing process to recover from separation, even if it's the right decision. And so that's where a family professional can really help by meeting with the client and getting to the bottom of a lot of those emotional issues, and just helping them accept that the relationship is ending. In psychology, we use the term radical acceptance to help clients deal with very tough situations that they don't have control over. So that might be, getting disabled, having an injury or an illness that makes you disabled. It could be losing your job. It could be one of your kids has some kind of really serious long-term illness, or it could be the end of a relationship. And if you're having a really tough time dealing with the end of the relationship, accepting it, it might be a good opportunity to reach out for therapy.
Okay, let's go to our poll results. They just ended, actually. Oh, here we go. So issues that most often lead to impasse: property division, 43%, sale of home, 29%. Parenting time, that's always a big one, 64%. think that sometimes leads into support issues too, right? Some parents think, okay, my support obligation is going to be determined by my parenting time. Holiday schedule is always a big one, 32%. It's amazing that we still don't have that worked out. Reluctance to settle, we kind of just talked about that, 30%. Support issues, 46%. And who gets the Kirby vacuum cleaner? Yes, we've got 7% agreeing with that story about the Kirby vacuum cleaner. I want to go to one more question, and then we're going to go to conflict style. So how often do family law cases reach an impasse, and are there common triggers? So maybe we'll get to the triggers in a moment, but let's just do a quick rapid fire roundtable. Jonathan, how often you say your cases hit an impasse?
Almost every time. There's always some issue that's tough to get through. It doesn't mean that that impasse is permanent and that you won't get through it, but I see, for me, the most common issues I would say were parenting time and spousal support. Those are the two issues that come up. I'm curious about your survey results, Russ. It seems like a lot of people have had issues with Kirby vacuums.
The vacuums are great.
People that said that they'd experienced that. So that's not an impasse I've ever experienced.
I should have put on Who Gets the Family Bible. That's another one that we didn't. Carrie, how often you see impasse?
I'm going to say 100% of the time. Beware of the file that comes to you either by the clients or somebody else saying this is an easy file. That is
That's a red flag right there, right?
That is a massive red flag. For me, I just go, oh, this one's going to be a mess. It just doesn't feel good. I know it's supposed to be a happy thing to hear. It's the worst thing for all of us to hear because that's the one that all of a sudden gets really, really messy. So you know what, impasse is going to happen all the time. I don't think I've ever had a file where there wasn't some level of impasse. I think that's the difference is when we don't normalize impasse, I think it becomes harder to resolve. I think when we're aware and willing to be actively working with it, then I think it becomes a much more manageable thing to go through.
Yeah, you need to talk about the elephant in the room. It's like you're on the highway and you see the construction warning signs, and you see that in family litigation and collaborative practice, right? You see warning signs of impasse all the time. They take it all different shapes and sizes. Something that seems relatively minor can blow the whole case up. So the answer is it's frequent, maybe if not always, and maybe not always because the professionals pick up the road sign saying we've got an impasse approaching, how are we going to do it, and work through it before it becomes impassable, right? So
absolutely.
Conflict styles. Jonathan, what does our audience need to know?
Yeah, so a bunch of people far more intelligent than me came up with this kind of model of conflict, which a lot of collaborative courses have in, and I find really helpful to help understand how people tend to behave in a conflict. So we are all born with a personality. That personality gets added to throughout our life based on our life experiences, and that personality tends to engage in certain patterns of interaction with other people. And so the conflict style model has two dimensions. One is how goal-driven you are. So you either really, really want to reach your goal, or your position, I guess, or the goal may not be the important part. It might be the relationship that's the important part, or other factors that might be important to them. The other dimension is the relationship, how important the relationship is. So if your relationship is really, really important with your ex because you're co-parents, then you're going to behave very differently than if you don't care, or even worse, if you actively hate the other person. So understanding that both your clients' conflict styles and your coworkers, your team's conflict styles can be really helpful, because certain combinations can be really problematic. So for example, if you have a competitors are very goal-driven and they don't value the relationship. So they want to win in the negotiation, and they don't care whose emotions they step on to get their goals met. Some people call those the sharks, right? Because they're going around eating everything and trying to consume it. And then if you have the opposite end of the spectrum, an accommodator, that's someone who's always, giving and always giving in to the other person and saying, oh, what, if they're in a dating relationship, what movie do you want? Which restaurant do you want to go to? What kind of food do you like? All those kinds of things. You're going to have a bad combination because the shark is going to get everything they want. The accommodator is going to get nothing they want, and they're going to feel really, really unsatisfied with the process, and that might influence the success of your negotiation. So understand that ahead of time, and working with your clients to move them kind of into the middle. So the shark you would move to be more amicable, more compromising, more a little bit more accommodating, whereas the accommodator you would work to be more firm in their positions and more setting boundaries and standing up for themselves. So that kind of information can be really, really helpful to know ahead of time. And the other styles of conflict are the collaborators, and they just want, they're very goal oriented, and they value very highly the relationship. So they want to work together to create an agreement that works for everybody. They're the best kinds of clients to have. And if you got two of them, count your lucky stars, get a lottery ticket because you just won the lottery. And then there's the avoiders. Those are really difficult to deal with. Some people call them the turtlers because they kind of withdraw into their shell, and they're the ones that, we've already talked about. They don't get their financial disclosure to carry. They're not returning emails. They're missing appointments, that kind of thing. And then the middle ground people are the compromisers. And they like to find a common, they want to find a middle ground between them and the other party. And they're pretty good to work with as well.
What about the one where there's infidelity and one client just wants to give up, right? Or another client wants a premium, right? I should get more.
Yeah.
That's what part of your conflict models or styles would that fit into, or would it be a combination?
Yeah. So, if someone's angry about an affair and wants to punish them for that affair by, getting way more out of the financial agreement than maybe they're entitled to, that would probably be a competitor, a shark. They're trying to win by defeating the other person and damaging them in the similar way. It's kind of an eye for an eye kind of philosophy to conflict. Like if you did something horrible to me, I'm going to do something worse to you. And often you will find the person who had the affair feels very guilty about it, and they might be more willing to accommodate the other person. So that's where the team can step in. Carrie and you, Russ, can step in and talk to the client and say, hey, you know what? I understand you're feeling guilty about all this, but think of the consequences if you agree to give everything you own to the other party. How is that going to affect you and the kids in 10 years and in 20 years? So getting them to see the long-term picture can be a helpful way of getting accommodators out of that guilty mindset. I'm just going to give the other party what they want because I feel guilty.
Or they may take the opposite mindset and say there was no affair. And the first spouse has to get this admission that there was, right? Needs that validation, which leaves impasse, right?
I sometimes find with accommodators, they do it also because they think that, well, if I'm going to give you this, you'll be nicer to me, or, you'll stop doing certain behaviors. And it never happens. I've yet to see where somebody giving more has allowed the other person to go, oh, you know what, you're being really reasonable and generous, so I'm going to do the same. I find that for the most part, the other person goes, great, thanks.
Yeah. Next poll, what are common barriers to resolving impasse? So multiple choice again. Let's find out what our audience thinks. And more audience questions coming in fast and furious. Thank you so much. We're going to get to as many as we can. Oh my God, look at the quick result with those poll results. Didn't even get a chance to ask my question. I can ask the question anyway, and then we're going to get to the result. Has there been an increase in impasses, repets, as more and more couples are refusing to have kids, instead own pets, cats, dogs? Has there been an increase in trend? If so, is it different? Is there, do they differentiate parenting time? What about the best interest of the pet? I don't know. You guys seeing impasse over pets?
Yes, Did you know that there was actually an article that came out about BC, and they've actually changed how they're dealing with pets. They're not seeing them anymore as being property. They're now seeing them as being part of the family.
Change the
And
legislation up there.
there are times I know where I would have, when my kids were little, I would have replaced them with my animals, happily given them to somebody else. I think that was around when they were 15 and learned how to be mouthy. I think that was
You
around
can't
that
take your
time.
Can't take your kids back to Costco when they turn 15 and
No, you can't do that. And I didn't have enough money for boarding school. So
I know. We had a case pre-pandemic. It's funny how things are measured in pandemic times.
Yeah.
And husband insisted he wanted access to the dog, which was clearly the wife's dog. And so we set up a parenting schedule, he had Wednesdays and alternate weekends for him to have access to the dog. That happened for about 2 weeks. He just wanted to have access to her. And she would have a friend or family member do the drop off, and then it faded. So some of these pet concerns are valid, and sometimes the claims are being made for nefarious reasons.
Yeah.
Or in that case, maybe he was having a hard time getting over the separation, and that was kind of a link to his old life that he wanted to hold on to for as long as possible.
All right, let's hear what our audience is thinking. Common barriers to resolving impasse: misunderstanding, 42%. Poor communication, 51%. I'd certainly agree with that. Trust issues, always up there, 63%. Emotional factors, well, that's why we bring Jonathan into the room, 60%. Power and control, 57%. Vindictiveness and retribution. Yes, there's no place for that in the family court, but it keeps showing up. 55%. Psychological health, mental health issues, 31%. Not wanting, ready to settle. Yes, we've seen that this afternoon. Fear, uncertainty, and around the 20s, and other, you put that in the chat box. Thank you. So really, it could be anything is what our audience is telling us that we can hit impasse on. And in my view, this is why it's important to bring a team in, but we're going to talk about that more in a moment. But let's talk about preparing for impasse. Jonathan, you want to take the lead on this?
Sure, yeah. So one of the things that we thought would be helpful to talk about is preparing your team, like getting the right team together to address the impasse. So pick your favorites, pick people that you trust, that you've worked with before. If you haven't worked with people before, get to know people, attend collaborative meetings, go to collaborative conferences, go to events where you can network with them and get to know them on a more personal basis, and that will develop those important relationships and trust. And generally, when you're picking your team, you want people that are high on. So I'm going to talk about what's called the Big Five personality model. And the acronym is OCEAN. It stands for openness to new experiences, conscientiousness, introversion, extroversion, agreeableness, and neuroticism. And those are all things that are part of our personality that are pretty stable over time and can kind of help you understand who you are and who your team members are. So agreeableness is a measure of how empathetic you are. And when you're doing family law work, you have to have a lot of empathy because you're working with people who are going through their worst period, potentially of their entire lives. And they need a lot of help and support, both, practical support, like crunching numbers and understanding laws and blah, 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 but also emotional support, active listening and validating and, all the other kind of supportive things that the team can provide for them. So getting team members that are high in agreeableness who have a lot of empathy is really important because they're going to work better with clients who are going through difficult times. You want generally to have team members that are low on the neuroticism end of the spectrum. Neuroticism is a measure of how anxious you are, and anxiety is an emotion that's very infectious. So if you have one person who's anxious in a room, it's going to spread to the other people in the room. So if you have someone who's really high energy and they're talking like this all the time and they're, oh my God, I don't know how to deal with this. They're going to ramp up the clients and make them feel more anxious about the process as well. So you want someone who's calm in a storm, who's not going to freak out themselves or freak out clients by getting upset. And then lastly, I would suggest people high in the conscientiousness scale. The conscientiousness is a very difficult word to say, and B, it kind of means how organized you are. And so you want someone on the team to be high on that scale because they're going to be the ones who are driving the process, making sure we make appointments, meet deadlines, and those kinds of things. So before you meet with the clients, it's, it might be helpful for you guys to meet as a team and talk about process, get to know each other a little bit more, and talk about what are the likely impasses based on the information we know so far. What are the topics that we're going to have the most difficulty handling, and what are the topics that are going to be much more easy to resolve? So that's kind of my thoughts on preparing your team. What are your thoughts, Carrie and Russ?
The thing that I like about the team approach is clients are different with different members of the team. So what they tell their lawyer is going to be this much. Then what they tell the family professional might be a little bit like this. And then that's the same for the financial professional. We're getting bigger snippets, and the benefits of having a neutral financial and family is we're hearing both sides of the story. So we're hearing where they're aligned, and we are hearing where they're not aligned. We are your first defense on impasse of the file because we're getting it firsthand and we're getting it early. So we can have really great communications so that we can say, hey, entire team, here's where we may have some issues. For me as a financial, it may be saying to the team, we're going to have issues with the house. They both want it and they're not willing to budge. Or one person wants it, the other person is insisting on sale. It's allowing us to give those red flags super early. And then sometimes there are points where I'm hearing somebody say, they controlled the money. They controlled the money. I don't know anything. They controlled the money. That becomes a really great cue for me to talk to my family professional and say, hey, Jonathan, is this a matter of a power and control issue we're going to have? Or is this simply the rules that were conducted throughout the relationship? So we're giving those early warning signs right up front, which means we can start dealing with impasse before it happens.
Yeah, I agree. What about distorting the separation? Well, let's go to an audience question because I think this kind of ties in nicely to where we're at. And I appreciate all the questions coming in. They've been fantastic. Just on this concept of impasse, a questioner asked, can it be temporary or how long does it usually last? I think if you don't deal with it, it could derail the entire case. But what's your experience, Carrie?
It's really funny because I have seen things where people have thought that the impasse was going to be massive and was going to be a really big deal, and we resolve it very, very quickly. And the reasonableness comes out and everybody goes in. There are other times where I've seen where I've had to do things where I like to say throwing in the holy hand grenade, where I'm pulling the pin and having to tell the team some really, really bad news. That's always a good time for me. And those can take a little bit more time to get through. It depends like how the issue is and how readiness the clients are ready to hear things, or even how ready some people on your team are ready to deal with the matters. I know I have an issue where, we have parenting concerns and it's a big piece of impasse, and there's a big financial part that goes with that. And so it's now, let's pull it back, and we're going to have to pull things apart a little bit more before we can move forward. That's going to take way more time than just some of the other issues that we may have. Maybe, who gets the family Bible? It might be a smaller issue.
Who gets the family Bible? What was that timing where Nat sang that song? I can't remember. Okay, let's talk about distorting the separation, Jonathan. What do we need to be mindful of in terms of the client's view of the separation and how it can inform or create impasse?
Yeah, this is where kind of the fields of family law and psychology kind of overlap nicely. One thing that you'll find a lot in impasse situations is what are called cognitive distortions. Cognitive distortions are patterns of thinking that are normal in people, but they're inherently irrational, illogical, and they can cause major problems. So examples of this might be something like all or nothing thinking, where if people are either good or evil. There's no kind of in between. Good people don't do bad things, and bad people don't do good things. We know that there's lots of shades of gray in between those two extremes. But if you're engaging in all or nothing thinking, you might think, for example, that the marriage breakdown was 100% the other person's fault. I have no responsibility for the breakdown. It was all their fault. So that would be an example of all or nothing thinking.
I know
Catastrophizing.
I know lawyers who approach cases that way, right? They start emoting their client's behavior. And they say, oh yeah, your client cheated on my client. And it's all or nothing. They think the client can tell them no wrong, and they don't think outside the box. And
we know, like from a psychological point of view, affairs are a very complex situation, and there's a lot of complex reasons why they happen, and having a really simplistic explanation for this kind of complex behavior is never really that helpful. It can really drive, like, if you think the other person's 100% at fault for the marriage ending, then your negotiation stance is going to be very different than you think, well, we both screwed up, we both made mistakes, we're both partially responsible for the end of the marriage, and let's find a way to amicably separate and get along. So there are lots of different cognitive distortions that can cause problems. All or nothing thinking is just one of them. Another good one is catastrophizing. So, for example, I had a case recently where the husband was saying, she wants to bankrupt me. Saying that about his ex. So I asked him, well, what do you mean by that? Well, she wants me to buy her out of the matrimonial home. Well, she's not trying to bankrupt you. She's just trying to get her portion of the value of the house, which she's 100% entitled to. So helping clients address those thinking errors with, things like logic and reframing. Reflective questions are really important. Like, do you really think that that's why? Are there any other reasons why she might want the house, for example? Or another good example is
I'll be a bag lady.
Reason. Yeah. Emotional reasoning is another good example of where it's a cognitive distortion where someone feels a certain way and therefore believes the feeling's true. So they feel angry at their ex-spouse. That means that they're an evil person and they deserve their hatred and disrespect. So so the team member's job is to identify these cognitive distortions, B, trying to get ahead of them by, doing things like reframing and asking reflective questions to get people to engage in what's called flexible thinking, to change the way they believe based on new information. So yeah, lots of different options for addressing those cognitive distortions. And that's why having a family professional can be really helpful, because they'll have, a lot of training experience on those cognitive distortions.
We'll get to this in a moment, but I think it's essential to start with the full team. And it's cost effective. I'll explain why in a moment, but let's go to our audience. Thank you, everybody, for submitting your questions and continue to support the Denise House. I see that we just broke $6,000 on our way to 10. So thank you so much. Please consider contributing if you can. Impasse, what strategies do you use to overcome impasse? So we've got a number of options here. Let's go to another audience question because they're simply fantastic. And thank you so much for participating. Jonathan and Carrie, what are the warning signs that impasse may be approaching in negotiations? So we talk about the highway construction signs. So what are some of the signs you want to look for? What do you see?
Well, I think Jonathan's
feeling in your stomach.
Yeah.
You know, you see clients having emotional reactions in meetings, crying, shutting down, not participating, just disengaging. There are a number of
Being
things.
very positional right from the beginning, you know,
Right.
positional attitudes towards, you know, things that, you know, maybe should be more flexible, like saying that the other parent should never have the kids on Christmas Eve and Christmas morning might be an example. Yeah.
Very, very nuanced things like canceling meetings last minute, rescheduling, not providing the professionals with the information that they need, maybe over focusing on one specific issue or one specific event during the course of the marriage or the breakdown. There's a number of triggers that you see. What about you, Carrie?
You know, it can come down to the simplest of things. It can be coming down to just fear-based, that even they are really rational when you're talking about each of these things on an individual basis, but it's the whole fear of the unknown can cause an impasse all on its own. People want some degrees of certainty. They want some degrees of, I'm going to be okay. And that paralyzation of fear alone can cause an impasse. And it's a little bit more difficult to get past. We don't have crystal balls. We can't predict people's future. What we can do is just simply set them up for the best possible way forward. And then it's up to them. And, you know, just because you're at one point at the date of your separation and going through the process doesn't mean that you're going to be in that same point 10 years from now.
And I
So
find
it's
the
helping them realize.
professional team as a lawyer are really can be my eyes and ears, because a client may share with Jonathan or with you, Carrie, something they didn't share with me during the consultation. Or maybe they shared it and I didn't think it was overly significant. It could be the issue of a family cottage that has to be divided, or it could be an emotional issue that they didn't want to talk to their lawyer about, but they talked to Jonathan about it. So we have these professional calls before we have team meetings, and these issues get discussed, where otherwise they might have just got buried and the client would feel their voice isn't being heard and the process is just not working for him or her.
You know, one thing that I find is a really big piece of impasse is people not understanding the differences between some things. So an example of that is a gift versus an inheritance. So I find that sometimes language gets lost, or the expectations around an inheritance where one person has received a lot of money and the other person has an expectation that they should be entitled because they cared for that person before they passed away, or they had a really good relationship, and how dare they not put me in the will now, and why does this happen? Or you hear the opposite. Well, their parents are going to die in 5-10 years from now. They're going to get a lot of money then. Why do I have to give them my money now?
Or
So,
my former spouse is going to die, so why do I need to settle with them or her?
oh yeah.
That's a real case example. It's incredible what can create an impact.
That still gives me post-traumatic stress disorder, that matter. I'm not gonna lie. It still gives me heart
We're not
palpitations.
supposed to talk about it anymore. It doesn't help the recovery process. So let's see what our audience thinks. Strategies to use to overcome impasse, and the results are, oh my God, Shannon's just so fantastic.
She really is.
Reframing, 49%. Examine the evidence, 37%. Reflective questions, 38%. Educating clients, yes, very big. Top results, 64%. Encourage flexible thinking. There's a lot of lawyers who are not, who are, you know, firefighters and, you know, they're warriors and they think they just need to burn everything to the ground. And some of them are more peacemakers. So I think some of the lawyers could use, encourage more flexible thinking than they do sometimes, at least in my experience. Okay, so that leads us to our next topic, effective communication strategies. Jonathan, what do we need to know here?
Yeah, so one thing that we can do with clients is to help model good communication strategies with them. So teaching them about active listening can be really important during meetings. And so often you'll see either during my intake process and or during the first team meeting, before we even talk about goals and interests in a collaborative setting, for example, or in a mediation session, I'll talk about why active listening is important and how to do it. So that means you're really listening to the other person. You're not preparing an answer without hearing what the other person's saying. I call it loading your gun. So sometimes when the other person's talking, the person's kind of loading their gun and they're not really listening. And they're ready to blast them the second that they stop talking, instead of like taking a step back and really trying to hear what the other person's trying to say. So active listening can be really important. I teach clients that there are some rules of communication, right? If you say something positive, you're twice as likely to get a positive response compared to a neutral comment. But if you say something negative, you're 5 times as likely to get a negative response. So negative comments downward spiral really quickly. It takes a lot of positive communication to build it back up. So teaching clients to do something called make requests instead of demands. Demands would be things like, you have to, you must, you're gonna, I need you to. Those are the kinds of things your boss or your superior officer is going to say to you, and you have to jump. But you don't want to hear those kinds of comments from your ex, because if they're telling you what to do, you're going to get angry with them. So changing those into requests can soften it and turn it into positive language. So things like, would it be okay if, would you consider, could we do this? Could we try that? Those can automatically make the other person more open to hearing a proposal that you're making, while you're engaged in that option generation phase of collaborative that Carrie and I are going to talk about next. So just teaching clients how to use basic communication skills and modeling them yourselves, making sure your comments with the team are very respectful and that the professionals aren't, contributing to the impasse themselves. Harry, what are your thoughts?
Oh, my thoughts on that is the moment I hear somebody say I should do something or I have to do something, I don't know about you guys, but I put on my stubborn boots. That's my immediate go-to. So I completely relate to the idea, don't tell people what to do. But for effective communication strategies, quite frankly, giving clients information, explaining things, opening up that communication with them and really having them understand things. And by the way, it doesn't mean just telling them the good stuff. We've got to be telling them, here are the bad things that go with this. Like, this is the good part for you. This is the bad part for you, and vice versa. It's really about giving them the full information. They need to be free to make those decisions on their own. It's a really big deal. And then in that, it's easier to encourage the flexible thinking that we've been talking about so much today. It really is a big deal that people kind of are able to see something outside of their mindset. And I find sometimes when we do that, or a way that I've gotten people to kind of look at things maybe a little bit differently, I ask them to see something from their spouse's point of view. From the other person, if this was your spouse, if you were your spouse and this is what was coming at you, what would be your reaction? And the odd time I get a real smart ass answer back, which I know to be not true, and that happens. But for the most part, I get a lot of people that are going, I didn't think of it that way. And it really does start opening up that thinking a lot better. It gets people to be more resolution oriented rather than impasse oriented.
Yeah, and the collaborative practice agreements have communication guidelines attached to them as a schedule. I like the approach of having, if we're dealing with a support issue and my client has to pay support, I'll raise that issue and talk about the law on that issue. It's just less adversarial, it's more flexible. My client's not going to feel like they're being confronted by the other spouse's lawyer. So there's lots of little nuances. But sorry,
Russ, I was just going to say, all of this isn't just for collaborative practice.
Right.
I know so many lawyers that do so much better in their litigation practices because they know and understand collaborative principles. They may not practice collaborative, but they've done the training, they understand the principles, and they apply it to their litigation. And they're having great results because of it. Because most of our judges, they're now collaboratively trained.
Used as a mediation and arbitration outside the collaborative setting as well.
Absolutely.
So I may have spent a little bit too much time on audience questions, so I'm just going to speed up the train a little bit here and talk about neutrals, and then we're going to talk about lawyers and finish off with boomerang cases. So thank you everybody for submitting your questions. They've been simply fantastic this afternoon. So for neutrals, I like to bring in the full team. What that means to me is I'll bring in a financial professional, usually agree with the opposing counsel or the collaborative lawyer, which one person we're going to use. That adds credibility to the disclosure. It adds efficiency. We don't have two lawyers preparing two sets of briefs. It avoids the merry-go-round of disclosure requests and motions, and it's a much more efficient way to proceed. I'll bring in family professionals similar to Jonathan. That's going to assist in flagging all these issues that could potentially lead to impasse. The emotional, the communication issues, the issues clients are not sharing with their lawyers. Oftentimes we have a draft parenting plan ready even before we meet for the first meeting. So those several hours of traditional lawyer negotiation has been saved by bringing in a family professional. You can get parenting plan assessors involved, business evaluators. Tomorrow afternoon, we have two great business evaluators, Melanie Russell and Jason Kowalski, presenting two programs, and you're going to want to sit in on that. Voice of the Child reports is also a very effective tool, especially if you have older children, 14, 15, 16. Get their views. It's certainly the flavor of the day if you're going to court. Judges will often want to hear a voice of the child report, either formally through the OCL or done privately by the clients. Litigators are somebody you can bring in to give the clients a second opinion. And this team can grow and grow depending on your client's needs. So if you're dealing with clients who own multiple companies and have significant wealth, you may want to bring in corporate advisors, tax advisors, estate planning advisors to ensure if the company is going to continue and the spouses are going to continue to profit from it, that the legacy considerations are taken into consideration. Tax planning. What if the one spouse repartners? We don't want potentially that person making claims to the business. So lots of advantages when it comes to impasse and bringing in these neutrals to help you negotiate, or if you're in court, to resolve impasse. Carrie or Jonathan, you want to jump on those comments?
I really like the story that you and Carrie tell about clients who believe that the other party is hiding money, and then you bring Carrie in to show, nope, there's no hidden money, or yeah, there's a big pile of money under the living room carpet that you haven't been paying attention to.
Yeah, that does happen every now and then. See, for me, it's
the envelope or the shoebox of cash, right? There's always those.
No, it's the money tree.
Yeah.
It's the money tree in the backyard. Mine died, but that's okay.
All right. So, Carrie, what do we need to know about bringing in the lawyers with respect to impasse?
You have to bring your lawyers into the process. I think it's about the lawyers bring in a really nice dose of reality for a lot of clients. I bring in a lot of reality in the sense that the money is the money. There's really not a lot of wiggle room when it comes to so much of it. But sometimes I need them to understand what is the reality of what they're saying. So if somebody's saying, no, I deserve half of that inheritance, and they're just kind of being a petulant child about the entire thing, then I need to be able to say to legal counsel, listen, we need to have a meeting and have a really good combined view of what an inheritance is and where we go from here on it. So for me, bringing in the lawyers to say, this is the law, this is what it means, this is what would happen in court. That for a lot of clients is a big dose of reality that they need to hear to get past where they're at.
Yeah, 100%. Or they realize how much it's going to cost if a lawyer has to get involved. Jonathan, 30 seconds or less, boomerang cases.
Yeah, so boomerang cases, I call them zombie cases. Those are the cases that you feel like you've gotten everything sorted out, it's all on paper, and you don't have to see those clients again, and then some new conflict comes up, or a conflict over interpreting the agreement comes up, and the case is back in your lap. So my suggestion on how to deal with those is, and we talked about this a bit earlier, Russ, is to make your agreements as robust as possible. Make sure that if there's a lot of conflict, that you're very specific about all the financial details, all the parenting details in your agreement, so that there isn't any wiggle room for interpretation. And if ultimately they still can't resolve the issues, send them off to parenting coordination and hope that that will solve the problem for them.
All right. Well,
Great
on that
comment.
note, our hostess shows up just magically. Thank you, Shannon. Jonathan, Carrie, wow, what a presentation. I can't believe how quickly this went by.
This went really fast, really fast. Well
Alrighty.
A
done.
lot of fun, and you know, it's nice to see in the background that people are donating to Denise House and raising money for them. So thanks,
Yeah.
Russ and Shannon, for setting all this up and raising money for such a great cause.
I just got an
Absolutely.
update. We're at $6,315, getting towards our $10,000
Wow.
mark. Thank you, Raymond, Bev, Roxanne, and other anonymous donors for contributing. Deeply appreciate your support.
Well done. Well done. Well, this is a lot of fun as always, Russ. Thank you so much.
We're going to hit our mark, I'm sure of it.
Yeah, thank you so much, everyone who supported, and thank you, Carrie and Jonathan, and to all of our speakers who helped put this all together, because we wouldn't have been able to do it without you. So we really appreciate you contributing your time and your knowledge to our audience. So thank you. And I was going to say, this is the sad part where we say goodbye, but we're just going to take a short break, and we get to see Carrie and Jonathan come back for a presentation on the art and magic of option generation. So I'm excited to hear from you.
So we got what we got, 10-minute health break or coffee break, and we're back at
2:45. 2:45.
Okay.
Yeah.
And we're going to have Daphne come back on, and then Shannon and I are going to wrap up the day with ethics and strategy. So we'll see everybody this afternoon.
Okay, sounds
Great.
good. Thank
See you soon.
See you soon.
Sleep till I come home.
Hey, Michelle.
Hey, Carrie, you look beautiful today. Look at you.
Oh, you're so sweet. You always do. I had to up my game.
Oh, not at all. Not at all. Don't worry. You should have seen what I looked like a half hour ago.
Well, half an hour ago I was okay because Jonathan, Russ, and I were doing another presentation, but yeah, it's been a slow day to like kind of go, oh wait, I have to look like a human.
I have to
That's
remind
okay.
myself that every day. Don't worry. As you know, I have 4 kids, so getting up and getting dressed in the morning is it's never
interesting. I have to admit, there's parts of me that miss those days when my kids were little and a little bit crazy, and then there's parts of me that just does not miss it at all.
I heard that you have a little one in your life now.
I have 2.
Oh my goodness.
Yes.
Did your other daughter have a baby?
No, my oldest daughter now has 2. My grandson will be 3 in December, and my granddaughter is just turned 3 months.
Congratulations. Am I allowed to call you grandma? Is that allowed?
No, you're not. My grandchildren don't even call me grandma. So
well, speaking to another person with 4 kids. Hey, Jonathan, nice to see you.
Yeah.
Hey, Michelle, how are you?
I'm great. I'm really looking forward to hosting you guys. And so welcome to you both. First of all, thank you so much for taking your time today and joining us. This is really great. And the number of participants we have today, thank you guys for joining us. This is so great to see all the interest and everyone here. It's really lovely.
Oh, it's fantastic. You know, doing this is so much fun. I love being invited to do this, and I wouldn't say no for the world. So
you said it, it's recorded. You can't take it back.
I was heavily medicated when I said it.
All right. Well, why don't we? Yeah, Russ is behind her right now.
Yeah.
Why don't we start? So welcome everyone. I'm not going to really go through a real introduction of Carrie and Jonathan because first of all, you don't need it. And secondly, I'm sure most of us have done the introduction and seen you guys already today. So why don't we get started with our first poll? Welcome to the art and magic of option generation.
Yeah.
All right. So poll number 1. How important do you think option generation is in resolving family law disputes? You'll see it pop up right now. So A, extremely important. B, very important. C, moderately important. D, slightly important or not important at all. This is interesting.
I know what my vote is.
Not important at all. End of presentation. Goodbye, everyone.
This is the section where we just sit and have drinks and hang out with
Yeah.
That's right.
Oh, I wasn't told I was allowed to have wine at this presentation. I went and got Starbucks.
The wine is for after, Carrie.
Oh, very good. Okay. As long as I'm allowed after, that's okay.
All right. Why don't
No
we
one
see?
believes it's Starbucks. No one.
That's the best thing about the Starbucks cups. This is clear glass. You can see what's in here, but
Do we know, Michelle?
Straight vodka.
All right. So extremely important, very important, moderately important. So we've got 41% of us think it's extremely important, 38% very important, and 18% moderately important. Only 2 people think it's slightly important. So why don't we move on to the experts and see what you guys have to say?
Yeah. For me, I think it is extremely important that we have option generation, and I don't really think it matters what process you're in. So if you're in an alternative dispute resolution process like collaborative mediation, or if you're in litigation, you need to have options. I said it earlier, you know, most of our judges are now collaboratively trained, and they're looking for everybody to be coming to the table and finding ways to resolve this so that the family can move forward. It's not one size fits all. It can't be.
No, you're absolutely right, Carrie. And I think the most important point you made there is that it's a very important process, no matter what type of process you're picking. It's good for mediation. It's good for collaborative. It's good for litigation. You know, judges want clients to settle their disputes out of trial. And if you can generate a lot of options and pick one, you're going to make your judge very happy. You're going to save yourself a lot of money. And if you're a professional, you're going to save your clients a lot of money and a lot of stress for yourself as well.
I agree with both of you. And I think that sometimes the best options are ones that kind of, combine the two different parties. So one party will say, hey, what about A? One party will say, okay, what about B? And we find something that's a happy medium between them. So I've had great success with option generation.
Well, it's funny that you say that, because just this morning I got feedback on a report that I had written, and it went, I was working for one side, it went to the court, but I always make sure I'm being balanced. Money's balanced. It's never just one side gets everything. And the fact that the judge loved it so much and kind of admonished the other side for not considering it, because their client's situation was considered in the entire proposal. It made it more interesting when a judge is saying this is reasonable. Like these are good options, because they are looking at everybody's needs, the children in both parties. It's a win-win.
Absolutely. And it's so nice when judges back you up, when judges say, yeah, this is a great option, because it really helps that settlement. And I know I do a lot of work in the Central East area, and our judges are phenomenal about that. You know, they're really great about guiding the parties to what they think is reasonable and what they think would happen at a trial or a motion, so that the parties aren't wasting time and money.
Absolutely.
I always say to my clients, I would much rather that you put that extra 10K into your kid's RESP than you paid to us. We have lots of clients. We've got clients lining up the door. We want you and your family at the end of the day to be happy and healthy, and to be able to move forward, and to be able to see each other at, your kid's wedding and not absolutely hate each other.
Well, this process shouldn't destroy the family. It should be just creating a new path forward for the family to operate. That's all we're doing, is creating a new operating model. We're not destroying the family.
Absolutely. And it's so refreshing to have counsel and professionals that feel that way, because there are so many lawyers who come to the table and, we call it the old school, where it's the art of war. That's what we're doing.
Yeah.
And it really does not take into consideration the fact that these are real human beings and real people. All right. So let's talk a little bit about the definition, importance, key principles. What do you got for me?
Jonathan, do you want to start us out?
Sure. Yeah. So, option generation is, from a psychological point of view, is something that's been actually very, very well studied, because, this kind of social psychology information is used in so many different fields. They use it in marketing, they use it in family law, they use it in education, public health. The basis of option generation is something called psychological flexibility, where people have the ability to hold on to different competing ideas in their head at the same time, and kind of pick the one that's best for them. Some people are really naturally good at doing this, and other, they have a inborn and developed personality that supports flexibility. They, when they learn new information, they accommodate it and use it to influence their old beliefs and maybe change those beliefs to update them. And then some people are just not very flexible, and we've all, had members of our family or friends or colleagues or clients that are less psychologically flexible. We call them rigid people. Rigid people, tend to have a lot of difficulty changing their mind based on new information, often get stuck in a circular logic loop. And those are people that option generation can be really helpful to get them out of that psychological rigidity and get them to consider other options, right? So this is a process where the professionals and the clients are coming up with, okay, we have a problem with the parenting schedule. Okay, what are all the options that we could possibly think of to come up with a solution for that? And the reason why it's helpful, I think, is because it kind of gets people out of positional bargaining where they're, thinking, well, I'm only going to agree to a 50-50 schedule. Well, there might be other options that you would be able to consider if we put everything on the table and looked at it all. So yeah, I think it's a really important part of any family law process. And I don't think it's given the attention and the focus that's needed to actually make it, as useful as it could be in our system. What are your thoughts, Carrie? How would you define it?
I really liked when you said the word position. So the simplistic way of describing option generation is a position, which is something we see quite a bit in court, is there's only one solution. There's no other way to resolve the problem. But when we option generate, we can have 50 possible solutions. And sometimes what we're doing is we're looking at one party's options and we're looking at another person's options. And then magically, as everybody is watching this, they can see how melding of options can come together to create something very special that absolutely works for their unique family. And I think that's something that we always need to keep in mind, is that option generation allows us to give a concierge service to our clients where we're saying, this fits your family, this fits your situation. So I think that's a really important factor about why we want to look at and do option generation.
That's really insightful, guys. I'd never heard the term psychological flexibility versus rigidity, but it really does encapsulate what the underlying problem is. So why don't we go to our next poll, which is, which technique do you find most effective for generating options? So A, we have brainstorming. B, we have mind mapping. C, we've got a SWOT analysis. I've never actually heard of a SWOT analysis. I'm going to learn as well today. And D, others specify. So that's really interesting. It's funny because I don't actually know the technical terms for some of these things. I'm sure I'm aware of the different variations, but it'll be great today to learn the technical terms. And I was really interested, Jonathan, when you said there have been lots of studies. I may have to hound you send you an email after this to get those studies, because the psychological kind of background of why people do things is really interesting. And as lawyers, the more you can understand about the human psyche and personalities and how, people take in information, how they process information, what they do with that information, it's really helpful to understand your clients and where you can assist them in moving forward with option generation.
Absolutely.
Yeah,
And
I totally agree. Yeah.
And you want to keep some of those key factors, like even when we're going to talk more about each one of these that we have up here on the option generation, but you want to keep some key factors in mind. You want people to think outside of the box. So that's that creativity piece that we want people to be aware of. We want people to be open to all possibilities. And I think we've talked a lot about openness today and seeing that. And then also you want everybody to be client-centered. You want to focus on the needs and the interests of the clients, not on their positions, but on their needs, goals, interests. It's really an important factor when we're doing option generation and grabbing onto those key factors.
Excellent. So why don't we see what the audience has to say? All right, brainstorming, 78%, mind mapping, 6%, SWOT analysis, 11%, and other. So take it away. Why don't you guys educate us? I'm really excited to hear about this part.
There's so much here. It's absolutely fun. So there are lots of techniques out there, and we're gonna dive into each one of them. A really quick overview of each of them before we do a deeper dive. So brainstorming is the idea of free-flowing ideas, and there's no judgment. I always like it if we're doing team meetings and we're in the collaborative setting, one of the fun things about brainstorming is that we can either, if we're in a Zoom meeting, we put a white piece of paper up and we just start jotting them down. If we're in an in-person meeting, we get large pieces of paper and we put them up on the wall and we stick them all over the room. We've had that in the past. And the thing is, the idea here is that you're just going to do a lot of free-flowing ideas. Some that you're going to throw out are going to be really crazy. I usually like to start off with a really crazy idea like, okay, person A gets everything and you get nothing. There's one. That's an option. The other person gets everything and you get nothing. That's option number 2. We win the lottery, we split it, and everybody goes their separate ways and everybody's happy. These are all options. And we find that sometimes when you start off with something really crazy and really fun, people start to relax. And they start to just calmly saying, well, what about if you kept the house and, I did this with my pension? Or what if I kept the cottage, you kept the house, and we sold this property? Like they start getting really, really interesting and they get really creative, and you can see the people working together. So that's a great part about brainstorming, is you get to just go completely crazy. Mind mapping is more about visualizing the connection between ideas. So we're going to take one idea. So it might be client A is going to keep the house. So let's connect all the things that go with that. So that might be connecting parenting time. That might be location of where people are going to live. We're going to connect in there, the finances. Is the person having the financial flexibility to stay there? We're going to start doing that kind of mapping out of all of it. And then the next one is SWOT. And I'm going to let Jonathan talk about SWOT because I've been talking too much.
Thanks, Carrie. I'm not sure where the term SWOT came from, but I've been exposed to a lot in strategic planning when I'm on a board. And what they want to do is look at, the organizational health. Where is it going? So it looks at the SWOT. SWOT stands for strengths, weaknesses, opportunities, and threats. So every time you make a proposal, you're looking at what are the strengths of that proposal. So going with the example Carrie just gave, what are the strengths of keeping the house in the family? So one, it might be, well, the house is near the kids' school. Another is that you won't have to pay realtor fees and land transfer tax and whatnot to sell the house. 3, it might be like easier for the parent who's staying there just to keep all their stuff in the house and not have to move. So there's, you're looking at the strengths. And what are the weaknesses? Well, maybe one person having the home means it's harder for the other person to afford a home of their own because they're going to have trouble getting a mortgage. Or maybe the weakness is that the parent who wants to keep the home can't afford it. So you're looking at analyzing each of the proposals, each of the options in a thorough way to see, what are the opportunities? The opportunities might be good things that could happen in the future if you keep the house. Like maybe you can pass it on to your kids. We have a lot of I work a lot in rural areas, and in rural areas, people often buy homes that their family has owned, and they want to keep it in the family. So that might be an opportunity to pass on the home to future family members. And then the last one would be threats. What are potential future issues that might arise if you pick one option over the other? And the important thing about this analysis is to help getting the clients into the sort of mindset of critically analyzing each of the threats instead of narrowly interpreting them through their lens of what I call cognitive distortions or cognitive biases. Things like, oh, my ex wants to screw me, and that's why she wants to keep the matrimonial home, or the other parent wants to take the kids away from me because they want a shared parenting schedule, something like that. Those are cognitive distortions that can really negatively impact the way your client sees the options. And so having a SWOT analysis gives them the critical thinking skills to overcome those cognitive biases, like things like confirmation bias, where they come into the negotiations with a preset belief about the other person. The other person's evil. They just want to steal all my money. They just want to take the kids away from me. And when you develop all these options and get them to critically analyze those options, you're working very actively to overcome these cognitive biases that clients will often demonstrate in negotiations, and help them see other options, right? They don't have to be stuck in their one position if they can look at the other options and analyze them critically and find out, what's the best option for me. So I think it really, it dials up the resolution on the options you're generating, so people can really understand them, instead of just saying, hey, why don't we try sharing the pension? You're not really understanding what consequences might be for sharing the pension in the future. So that's my those are my thoughts on SWOT analysis. Carrie, did you have anything else that you wanted to add to that? Did I miss anything?
Well, one of the things that I wanted to mention is that all of these can go together. So it's not just you doing one technique and one technique only. There is a melding of all of the techniques that kind of go on at the same time. So while you're brainstorming, you may end up doing some mind mapping. And then while you're doing that, you're analyzing your strengths, your weaknesses, your opportunities, and your threats. You're doing all of these things in conjunction. It's not one or the other. You're usually working all of them in conjunction with each other. But having said that, there are also some steps that you want to be aware of as we're doing some of these things. So, and I know everybody loves coming to these things and getting some steps, like, okay, how do I actually do this? The theories are great.
Gary, give it to me. Step 1, 2, 3. I love that.
You want the full meat. Okay. So if we're going to look at brainstorming, I'm a big lover of brainstorming. I think it's so much fun. So just keeping in mind, it's a group activity. So it's a technique that you're going to do together. This is not one person going, okay, I'm going to brainstorm and hear all of my ideas. Please accept them all. That's, lovely. We want people to have some ideas coming in, but it really is a group activity. So the very first thing that you want to do is you want to set a clear objective. So that objective may be something like, how are we going to resolve an equalization payment? How is that going to get paid? What is it going to look like? So that might be our objective. And then we're going to encourage the clients to participate. Sometimes, like I said earlier, clients are a little shy. They don't want to say anything. They don't want to be the first to speak. So we may, as the professional team, either the lawyers, better coming though from a neutral first of us throwing out an idea. And that's usually when I'll throw out something crazy. Like, well, you win the lottery and you pay it that way. There's the easiest, simplest way to do it. We don't have to be very creative. It just gets done. So, but by doing that, by us as professional team throwing something out there, it gets the ball rolling. It gets the juices running. So we want to do that. We want to make sure their third step is that we're recording all of our ideas. And that we're not just recording one or two. We're recording all, including the crazy ones. You've got to record the crazy ones because it's really funny. Sometimes out of the crazy things, a little gem appears where somebody goes, I know this is on the crazy sheet, but I kind of like this, and can we tweak it? So you want to make sure you're writing down and recording all of those ideas. And then what you want to do is you're going to evaluate and refine each one of these ideas. There's going to be some that you're going to go, nope, this is an absolute no, and everybody's going to agree to it. Some people may be laughing about it. It is a great way to get people looking at the same problem from the same side of the table. They're not coming at each other. They're trying to resolve it together. So that's a really nice part of this. And as we're evaluating and refining, I find that a lot of clients will say, well, this won't work, and here's why it won't work. And then somebody else is saying, oh, I didn't consider that. Or wait a second, what if we added this from this option over here and we take and tweak it from that option over there? That's evaluating and refining the options. It's a great technique. Clients seem to like it. They find those meetings high value. The other thing that's really nice, it's their agreement. It's things that they want to do. It's not us imposing it on them. And we have found that clients that come up with their own agreements are more likely to follow those agreements because it's theirs. And that's a really big thing. It's about them having some control and process, which is a big deal. What do you think, Jonathan?
Yeah, a couple of things I would add to your already excellent description of option generation is it doesn't necessarily have to start in the meeting. What I would do with clients, both for mediation and for collaborative, is to ask them before the meeting, hey, these are the topics that we're going to come up with and have to reach an agreement on. Can you come up with 5 ideas of how you'd like to see these resolved? And that really gets them out of that mindset of positional bargaining where they're like, no, I'm only going to accept 50-50, or I'm only going to accept not paying spousal support, whatever the positional bargaining is, because then they have to come up with other options. So get them in the mindset early and get those wheels spinning so that, you know, when they're commuting to work, when they're making dinner, you know, when they're in the shower, they're starting to think, oh yeah, maybe this might be a better option than you know, the position I was taking before. And then, you know, I think that's where collaborative really shines, because you can support the clients very actively while they're trying to come up with options. And if you find one client is getting stuck, it might be a good idea for the neutrals or that person's lawyer to have a little breakout room and say, hey, what's going on? I noticed that you're having a difficult time coming up with these options, and kind of get to the bottom of what is acting as a barrier to them, you know, coming up with options. Maybe there's an emotional issue that they're upset about, or maybe they don't trust in the process. Maybe they don't trust their ex. Maybe they don't trust the professionals. Let's find out what it is and resolve that issue so we can get back to the drawing board and figure this out. That would be kind of one approach that I would recommend people take.
Yeah, I don't disagree with it. One of the other things to keep in mind when you're doing option generation, one of the things that I really like about it is your clients end up feeling heard. It's one of those things where because everybody's having their voice, everybody's having their say, is your clients are ending up going, I've had a part of this, so I'm being heard. And they don't feel so dismissed in the process, or it's just one person running all over the process. So it is another nice part about doing these steps.
And
Having said,
you know, Carrie and I have used this technique a few times to help resolve conflict. So what we do is if the parties are in a lot of conflict, they're fighting all the time, they're yelling at each other, you know, the kids are being exposed, Carrie and I and the lawyers will have a meeting with the clients to say, okay, let's come up with all the options for resolving or reducing or eliminating conflict while the process is going on. So we'll get, you know, as Carrie already said, if the clients come up with some ground rules on how to function while they're still living together, while they're negotiating their separation agreement, if they come up with those rules themselves, they're more likely to follow them. So you want to say, okay, what are all the things that we can suggest to help you guys manage conflict and reduce it and even eliminate it while the negotiations are going on? And they'll come up with a list, and then we'll send that list out to them and say, okay, we all agreed to these rules, and that you know, we'll follow these rules while the negotiations are on. And that will help when you're in the room actually negotiating the issues. You won't have as many of those emotional issues coming up and interfering with the process.
All right, team. There's so much. We can spend so much more time on this topic, but I think we should move on to our next poll. So, oh, there we go.
Look at that.
What do you think is the biggest challenge in generating options in collaborative family law? Power imbalances, emotional conflicts, lack of creativity, resistance to change, or other?
Oh, we need an all of the above button.
Can we also add the client did not have breakfast that morning? Because that has actually happened to me one
Yeah.
time. We stopped
Yeah,
with them and they
yeah.
were happier after that.
Yeah. And those biological issues are not insignificant when you're planning your meetings, right? So, you know, if you are going to have an option generation meeting, make sure you're not scheduling it around lunchtime when the clients are getting hungry and maybe a little antsy about eating, or you know, don't have like an 8-hour meeting and have the option generation in hour 7, because clients are going to be exhausted and less creative and more irritable by that point. Or if the clients have just had a major blow up at home before the meeting, maybe address that first so that they can kind of be more open to generating options, because if they've just been yelling and screaming and insulting each other, they're less likely to even hear the other person's options as they're generating as good options. You know, it doesn't really matter the value of the option. It's the person who's saying it that they're really angry with, so they're not going to listen. So I think that's an important point that you made there.
Yeah. I also think just general readiness, you know, some people, we've always talked about, you know, some people are at this place in their process of the separation, and other people are way back here. And so if you don't have people that are in the same place when we're getting into doing option generation, we're not going to be quite as successful, I don't think, just simply because the other person's readiness just isn't there yet. And I think that becomes an important part of this.
Absolutely.
You might even want like the clients to come up with the crazy idea first, right? Like,
Yeah.
and that will help kind of lighten the mood and get their creative juices flowing, right?
Absolutely.
Yeah,
I like when the clients are creative.
I do. The more you can get the clients engaged in the process and, you know, understanding that, you know, it is important, but you do have to take a step back from the conflict, the better your results are going to be. So let's see the results of our poll. What do people think? All right, emotional conflicts. The first one, I would agree. It's probably one of the bigger ones. Power imbalances at 24%, resistance to change at 19%, lack of creativity at 7%, and then other at 4%.
Yeah.
So why don't we talk a little bit about that and some of the challenges we have related to those categories?
Absolutely. Well, they're all challenges.
Carrie's like, it's all bad.
There you go. They're all challenges. They're all bad. You know what, though? I don't think they're all bad, because when we're looking at all of this is, you know, it kind of comes into each one of our realms. So some of these, when I look at and the emotional stuff, it is, you know, so important that we have our family professional on the file to deal with those emotions that are underlying. You know, we talked about in our last presentation about a Kirby vacuum cleaner. And and it's not always about the vacuum cleaner. The vacuum cleaner becomes a symbol, and it's the emotional things that underlie that. And that's when I look at Jonathan and I'm like, Jonathan, deal with the vacuum.
Isn't it nice when you can just say to Jonathan, this is your problem now, figure it out?
Yeah, it really is. It's great.
Poor Jonathan, I've done that to him so many times.
So have I, Michelle.
Yeah, I think a couple other challenges that aren't on this list are one is like a psychological challenge called anchoring. Do you both know what anchoring is?
Explain to us.
I think yes,
Okay,
but
so
go ahead.
the best way to explain it is with retail shopping, right? When someone says that an item is on sale, it's probably a lie. It probably isn't on sale. What they did was just before the sale, they raised the price to $100, and your opinion of the value of that item is anchored at $100. So when they offer it for 85, you're like, good Lord, I'm getting 15% off. This is incredible. I better go out and buy it. And you know, my wife always says that we save money by spending money on things that are for sale. And I tell her, well, you still have to pay money for those things. You're not actually making money off those sale, but anyway, so
Jonathan, let me explain to you girl math.
You can
Carrie,
talk to
we can do a
Danielle
whole
and set her
seminar on
straight.
girl math, but
That's right. So, so yeah, you have to be careful of anchoring. So that could be a real challenge to operate option generation if the client has an anchored view of, you know, spousal support or child support or the value of the home. You know, how many times have we seen a client coming in saying, well, I know my house is worth 1.5 million, even though the realtors say it's worth $900,000, you know? So that it's, they're going to have a really hard time agreeing to anything lower than 900,000 because their anchor is 1.5 million. So dealing with anchoring can be a real issue, or it could also be an issue for parenting, right? If their anchored belief is, well, I should have 50-50, even though that was never the case during the relationship. I had a file not too long ago where the father was anchored at 50-50 schedule, even though mom was a stay-at-home mom. She was on leave from work and was still earning money, but she wasn't working. So she was available for the kids 24/7. And dad had a night shift job where he was gone from the house from, I think it was like 7 to 7 every weekday. So he wouldn't even been available for the kids during that time. So that anchoring issue can be a real challenge. And there's lots of other cognitive biases that can contribute to those problems as well. One is the availability bias. So that would be where you are biased based on the last piece of information you heard. So for example, I have a case right now where there's a dispute between the parenting schedule. Mom, this is a different case, but mom, full-time parent, father works outside of the home, very busy schedule. And he heard from his buddy at work that all dads get 50-50. And so now he wants 50-50. So that's the last piece of information that he's heard, and that can influence his ability to generate options and reach an agreement. And you know, I think Carrie and I have had you know, other really good examples of that with what we call the Greek forest, where you have a you know, a family member or a friend who is in the peripheral of our clients, who are kind of advising them either to or not to agree to certain options. In fact, Carrie and I had a case where the client had an off-camera person in the room with them, and that person was kind of whispering in their ear to say, no, you shouldn't agree to this, you shouldn't agree to that. So that can be a real challenge, is dealing with those Greek forest people. And generally, you know, I think I've mentioned before, our clients' emotional states are really important too. If they're coming to the meeting more anxious and stressed than normal, then it's going to be harder for their mind to open up to options, because one thing that happens when we get stressed is our anxiety causes us to not have access to our thinking brain. You know, we have our thinking brain and we have our emotional brain, and sometimes they compete for control. And when our emotional brain is in charge, it actually turns our thinking brain off. And so it's much harder for people to think through and problem solve, because problem solving all comes from your thinking brain. So we want to make sure that clients are well fed, they're well rested, that if you have a family professional or a family mediator who has like a social work or psychology background, that they're working with the clients to help manage that stress. Maybe they're doing like a deep breathing exercise before the session. Maybe they have a support person, maybe not in the room, but in the house, that they can go to and decompress with. Or maybe the best way to generate options is not while the two parties are either in the same room or the same Zoom room together. Maybe you want to separate them to bring their emotional level down a little bit, and then the neutrals. And Carrie and I have done this many times in various different cases, where the two of us are bouncing back and forth between the two breakout rooms to help come up with options and help the clients manage their emotions so that they're not interfering with generating options. And then also you want to make sure that the team members aren't creating a barrier to option generation. You know, if one lawyer in particular is too vigorously defending their client's position and not looking at options, then it's going to be really hard to convince the client to generate options if their lawyer isn't on board either. So we want to make sure that we manage it. I also like Carrie's suggestion of writing everything down in a kind of nice visual way, because sometimes if there's too many options generated, people can get overwhelmed with the information and not remember things. So having a visual representation of each one is really good. And you might also want to take lots of breaks to help people spend a little bit more time considering whatever options have been placed on the table, because otherwise they might be too stressed and feel rushed and pressured, and people generally don't like making decisions when they're feeling super pressured. What other challenges or barriers have you seen, Carrie?
You know, I think some of the things that people end up with barriers, and I've said it before, is that fear again of the unknown, where they're really afraid that if I agree to this option, even though it sounds really good and it looks really good, what if it's wrong? What if it's the what if scenario that goes on through everybody's head, and we see that so often with money. Well, this sounds really great, but what if it's not great? What if there was a power imbalance, that what if they're still trying to manipulate me and now they've manipulated the entire team? So what if that is going on? And I think what ifs can be a really big problem. And I do think it's important for our clients to understand that when we're doing option generation, no matter which way you're going to do it, is that nobody has to make a decision in that moment. So they may say, you know what, I really, really like options 1 and 4. Those look really good to me, but I want to be able to talk to, you know, a financial advisor, or I want to be able to talk to a family member that can walk me through this and show me what I'm not seeing or not thinking of. They're still in a heightened emotional state when we're in these meetings. It's not like all of a sudden everybody just calms down and can be making rational decisions. So it's really important, I think, for people to be able to take those options away with them and say, okay, I feel good about this because of X, Y, and Z, or, you know, I thought this looked really good in the meeting, but it doesn't, and here's why it doesn't. So I think that way we get better buy-in when people have that ability to say, oh, I don't have to make the decision right now.
And I guess that's part of the SWOT analysis, Carrie, right? Taking that option and saying, okay, you know, what are the strengths, the weaknesses? How do we, you know, let's look at this critically and say, if this were what we're going to do, how is this going to look long term? Because that's really important. It's a really great analysis for both parties to do.
Yeah. And one of the things that another thing that we want to do when we start doing brainstorming, I love doing this, is going back to their goals and interests. What did you say were your goals and interests? What did the other person say their goals were and interests were? And we want to put them right up in front and center. So if your goal was, you know, to keep the kids in their school, and the other person's idea is to keep the kids in the school, well, you guys selling the house and having to move to different cities, it's not achieving that goal and interest. So we want to be able to look at those things, because that helps us kind of formulate a really good option or options for them to be considering. So having that front and center so that they know why they're there, they get out of that combative state and they can see, well, this works and that works. And I like to tell clients, if an option only works for you, the other side will never agree to it. Their lawyer will not allow them to agree to it, just like your lawyer won't allow you to agree to a bad deal either. So you're going to have to make sure that this is something that you can both find acceptable, not necessarily fair, acceptable. And that's a really big thing for people to understand. It's what can I live with? What is that thing that 3 years from now, when you wake up on a Sunday morning, you're not waking up panic going, why did I make that decision 3 years ago? Instead, you're waking up going, geez, what am I going to do today? I feel good. That's the way that's the way we want to leave our clients anyways.
They're saying, Carrie, 3 years from now, people aren't going to wake up and say the vacuum. I'm really mad about that vacuum still.
Well, hopefully not. Hopefully, you know, we've made Jonathan like dig deep into the heart of the vacuum. And, you know, maybe we have to divide the vacuum. You can have the motor, they get the hose. Neither one's useful.
We'll send it back and forth in the kids' backpacks. How's that?
Exactly. The treat it like the family dog, and it's gonna go wherever they go.
Or
You might
take
need it to
the
clean up the
King
messes.
Solomon approach and just take a sword and slice it in half, and one
Yeah.
person gets the left half of the mower, and the other person gets the right half.
Or
Exactly.
we do it like you do with children. One person cuts it, the other person gets first choice of which half they want.
Oh, I like it. Yeah.
I like that too. I
Like
think that's
cake.
perfect. That's excellent.
Why don't we go on to our next poll? This has been an amazing discussion, guys. I don't know if you've noticed, but I've been typing things as we go along.
I like that.
So I'm going to go on to our next poll. Which strategy do you think is most effective in overcoming challenges in option generation? A,
Oh.
mediation. B, emotional support from coaches. C, encourage flexibility. And D, other. Please specify. I'm sorry, we're taking a minute just to get the polls up and running.
No
And actually,
worries.
while that poll is getting up and running, I did want to maybe selfishly ask you guys, Jonathan, you brought up a really interesting point of, you know, what happens when it's one of the professionals that may be impeding this process? Because I've run into that myself. How do you deal with that? Have either of you dealt with that? And what are your thoughts and suggestions?
My suggestion is to run and hide as much as possible. No, yeah, I mean, that sort of situation comes up all the time. You know, lawyers and social workers and financial professionals can be very strong-minded, you know, intelligent, you know, lawyers, you know, take courses on how to argue and debate and make their points. So it can be a challenge. And that's where I think having neutrals can be really helpful, because they're not on one side or the other, and they're going to see the middle ground, and they can really help to resolve conflicts, not just between the parties, but also between professionals, and, you know, to be the voice of reason, be the voice of compromise, be the voice of the middle ground. When lawyers, you know, for example, are taking hard positions. But it could also be the lawyer stepping in and making sure that the neutrals are being balanced, right? If the lawyers notice that one of the neutrals is you know, being more favorable to one or the other client, then that might be a good opportunity to have a private conversation with that professional. Just say, hey, listen, I've noticed this and this. How do you think we can resolve that issue? We talked about this a little bit in our last session on empaths, but there's different ways of phrasing things that can be either received positively or negatively. People are much more likely to react strongly to a negative comment than a positive comment. And so when you're addressing this issue with a professional, it's really important to approach with positive language. Say, hey, I've noticed this issue. How do you think we can resolve it? Or, you know, I'd really appreciate if I could have a conversation with you about, you know, some of the issues that we've had in this case. Versus you need to step up and be a better person and stop being a jerk and don't do this and don't do that. That negative approach probably won't be well received from the other professional. They're going to get defensive, and when they get defensive, you kind of lost them, and they're going to double down on their position no matter how unreasonable it is. So try to unarm them with a more positive approach, and be kind and supportive, and you know, ultimately, as a neutral, you know, you can only do so much, and there are some people that are more difficult to work with than others. But But I think the neutrals have a very strong role to play in those kinds of situations. What do you think, Carrie? What are your thoughts?
You know what? I like it when, if we're in that situation, I like having a professional team meeting. And because I want to know the why. My big thing is why, like, why are we having
Great.
this issue? So, when it's a lawyer, like I've heard everything from, I'm not comfortable with this. Like, I think my client would be getting more in spousal support. I don't think we would ever be looking at it this way, especially when we have gender reversals where, maybe the wife is making more than the husband, or different factors. It's like, well, would we be looking at this way if the roles were reversed? So sometimes it's coming that I've had lawyers tell me, listen, I'm really worried that the behavior of my client, I'm going to get sued, or I'm going to get a complaint to the Law Society. Like, how do I deal with that? And sometimes just them telling us what their fear is, we can find a workaround where it's like, okay, I understand now where you're coming from and why this is happening. I think the why question just answers so much for us.
Absolutely. All right, let's thank you guys. That was really insightful. Let's get to the results of our poll. So what does our audience think about all of this? All right, so encouraging flexibility. That's great. That's the #1 pick from our audience. The next one is mediation. That's a really good option as well. And then the third one is emotional support from coaches. So all really great things. So why don't we talk a little bit about those strategies, guys?
Yeah. The solutions to the challenges, they're kind of interesting, that's for sure. And, always encouraging that openness, that flexibility. I think that's an important part. I think people have to understand that that old adage of, there's no stupid questions. Well, you can't come up with an option that's stupid. Like, all of the options have validity to them, no matter how crazy some of them might be. That's okay. Like I said earlier, some of the best stuff has come from the oddest options that we've generated, where all of a sudden it's like, wow, I never would have thought that way. I never would have gone down that road. So I think really is encouraging that and letting people know on top of that, they don't have to make the decision in that moment. I think that takes away a lot of the scaries that go with option generation and them feeling like they must make a decision in that moment.
And
Jonathan,
I think,
what's yours?
adding on to what you're saying, Carrie, all of which I agree with, but flexibility should be a more important buzzword in our field. And I've seen the trend towards more flexibility increasing over the last few years. Even courts they have lots of other options in terms of how to resolve disputes between parties. The whole new kind of DRO, I think that's what it's called, dispute resolution officer approach, is a new one. And the bonus, the massive bonus of collaborative and family mediation is you can do whatever the heck you want, right? You can set up the process however you want. There's so much flexibility in the process, and generating options is just one of the pieces of that. It's probably one of the most important pieces. Like, clients often come into, as Carrie said before, they often come into these meetings with very clear pre-existing beliefs. They've seen Matlock on TV, or they've seen their friend or family member go through court, and they think they know what it's like. They're waiting for their you can't handle the truth moment in court, where the other person caves and they get everything they want. And we know that that's really unrealistic. And we want to dissuade them of that opinion and try to help them understand that the beauty of these alternative dispute resolution processes is that we have a lot of flexibility. There's no cookie cutter approach. And whatever ideas you had about how you're going to resolve this, throw them in the garbage. Let's come up with new ones. And just doing that can help the clients trust you as a professional. It can help them trust the process more thoroughly, and just help them feel comfortable that they're in good hands. And then while that process is going on, you have, you know, the family professional dealing with the emotional issues that are creating barriers to option generation. You have Carrie, the financial person, who is throwing out all these great financial options that, you know, maybe the lawyers wouldn't suggest, because if they suggested it, their client would be like, hey, why aren't you lawyering up for me? Why are you taking the other person's side? So, you know, I think the neutrals have a very strong role to play in this. And ultimately, it is one of the best features of alternative dispute resolution. And because it's so popular in those settings and it's so successful, you know, I think that the family court system is now looking at increasing the amount of flexibility they have on how to resolve cases. And I think that's really going to benefit our clients in the long run, and just society in general, because you've got less people spending less money on, more people spending less money on a process that results in a happy outcome for them, or at least, as Carrie said, an acceptable outcome. Maybe they're not 100% happy with it, but they can live with it. And getting clients out of that mindset, like, I have to get things this way. Well, no, there's lots of different ways you can get it. I think where it really shines through is often with spousal support too, because if you go to court, you know, there's limited options on how the court's going to deal with spousal support. You come to collaborative or mediation, you know, the world is your oyster.
Absolutely. All right. So let's get to the fun part, the case studies and examples. This is always fun to me because I live this on a daily basis, but it's really interesting to see how other people would have approached something that maybe there's a way I haven't thought of yet.
Yeah, absolutely. You know, one of the things about option generation, it is not always about what you can do, but it's also about what you can't do. And so one of the things that I do realize sometimes, so we have things where people are going, I want to keep the house, I want to keep the house, I want to keep the house. And I'm having to go through it. I'm like going, yes, it's an option for you to keep the house, but the money doesn't support it. And it's a really tough thing to be telling people that their option isn't going to fly because of it. And I see that a lot where, you know, I've had matters recently where it's been a stay-at-home mom for a number of years and they want to stay in the house. You know, when they bought the house, you know, forever ago, maybe they paid $400,000 for it. There's maybe $100,000 left on the mortgage, sometimes less, sometimes it's fully paid off. But now that same house is worth $1.4 million. And they're going to have to buy out the other side. Well, being a stay-at-home parent and then not having a job or having a minimum wage job or going back to school to retrain, it doesn't always work. You know, the person who is paying support, your child support is going to come first, the needs of that child. So there may not be enough money left over for you to keep that house. Or maybe we're using the option of, well, your spouse would owe you spousal support, but maybe in order for you to keep the house, we're going to offset spousal support as a lump sum to allow them to afford to keep the house. So we can get really nice and creative doing those sorts of things. And we've done that on a lot of matters, a number of matters we have done that. I know other matters that I've worked on where we've gotten super creative but we've brought in other professions to help with creativity. So people that have their own business. I don't want to be a part of the business anymore. Buy me out of the business. Yeah, but if we do that, that might destroy the business. So how do we get you to stay the business? You don't have to be a part of the business, but how do we work that out? How do we work that into your separation agreement? How do we get a partnership agreement with your corporate lawyers? How do we put that together for you? So there's all of these things. It's not just black and white. We can get very creative in some of those things. How about you, Jonathan? What are some creative things you've had to do?
In the last poll, they talked about getting a coach to help with the emotions, and I think that's a really good option. And it doesn't necessarily have to be a coach, like a divorce coach. It could be a therapist, could be a reasonable family member, not the kind of family member that Carrie and I dealt with, who was hiding in the room and torpedoing our negotiations. but someone who's genuinely going to be supportive and help that person, reach an agreement. I think, another great strategy is we've said this many times, and I'll repeat it again because it's really important. Giving the clients time to consider the options is really, really helpful. Because sometimes there's an emotional barrier, and once they sleep off that emotions, it's kind of like getting really anxious is a bit like being drunk, right? You can't reason with a drunk person, and you also can't reason with someone who's super anxious. So how do you deal with that? Well, you let them sleep off the alcohol and they wake up the next morning, and then you can reason with them. And the same with anxiety, right? Like anxiety kind of builds up, and in meetings people can be very, very anxious, and a lot of that is about fear, and they don't want to make a decision because they're afraid of that decision. Well, give them 24 hours or 48 hours to consider it. But also sometimes it could be helpful to create some specific rules, some guardrails, so that they're following the process and not taking 3 months to decide. Say, okay, we're going to set up, give you an extra 48 hours to decide, and then we'll hear your decision by a certain time. I think those kinds of strategies can be really helpful.
Yep.
All right, guys, you guys have been amazing with your time. There is just one quick question, if you don't mind, before we go. I'm going to amend it a little bit because this one's a bit detailed. But how do you deal with an adult child who is exclusively on the side of one spouse?
Oh, that's interesting. See,
It's
for
kind of
me,
like that. What do we call them? The peanut gallery in the background.
The Greek chorus. See,
chorus.
That's when I think we need a strategy, and we all turn and look at Jonathan and go, "And?"
Yeah, so that would be a really important discussion to have at a professionals call, where you're getting the lawyers and the mediator or the financial person or the family professional to kind of strategize and problem solve together, generate options as a team, and then it might be something that you want to address with the clients in a separate meeting, maybe individually, to make sure that you're set up for success during your meetings, and just say, like, this situation is negatively impacting our negotiations. How do we minimize that impact while this is happening?
Thanks so much. And I see Shannon anxiously waiting. I'm sorry, Shannon. I just had to get that last
went over time.
in.
No, that's okay. We actually have just under 15 minutes before the next presentation, so lots of time. It was really great.
Me, I like to talk. I apologize.
No, it's all great stuff. We're learning lots. So thank you, Carrie and Jonathan, again for your presentation, and thank you so much for moderating, Michelle. And I can't believe we're already on the last presentation of the day coming up next at 4 o'clock. So that'll be ethics and strategy. Russ will be back on with our associates Golan and Stephanie, and then we also have Abby Adusi, who will be joining them on the panel as well. And good news, we'll have Carrie, Michelle, and Jonathan back tomorrow for a couple more presentations. So we have that to look forward to with day 2.
Great. Thank you so much for having me today. Lots of fun.
Yeah, thanks for having us.
See you tomorrow. And for everyone staying on, we'll just take about a 10-minute break now, and then we'll be logging back on for the next presentation. So you can stay on this link, and we'll be back soon. Thank you.
Thank you, everyone.
Thanks,
I
Shannon.
really
Thanks,
appreciate
Michelle. Thanks, Carrie.
Bye, guys.
Hello, hello.
How are you doing?
Doing great. What a great show so far.
God, so much information.
Yes. Yes. And the day is flying by. You called it.
Last presentation of the day, but I want to thank our audience and certainly our sponsors. I just did a check at the GoFundMe page 15 minutes ago. We've had over 15 individual donations ranging from $25 to $250. Like I said earlier, there's no right amount. Whatever you think is appropriate, every big or small, it's going to go towards a good fund and make a difference. The last time I checked, we're at $6,540. So super impressed with the audience participation today. So thank you everybody who's contributed so far.
Yeah, it's so great to see we're getting closer to our goal. So
Yeah.
yeah, one more day. Hopefully we make it.
And I think we're doing our early bird draw after this session. So that would be fun too.
Yeah, that's right. So stay tuned. One of you could be winning the early bird prize. And this presentation is going to be a great one as well. It was accredited by the LSO for 1 hour of professionalism content. So make sure you stick around for this one and for the early bird prize.
Yeah, certainly a dream team that you've assembled for this one. Golan, Steph, Abby Adusi, who's fantastic. It's going to be a great discussion.
Yeah, really looking forward to it.
I like your PowerPoint that you put in between presentations. It's pretty informative.
Thank you. Yeah, I'm loving the slideshow too. Something to watch in between sessions and lots of good information there to grab as well.
Do we have one of those thermometer funny gauges that we can put up and share?
Yeah, for sure. I'll make sure to do that, to share that right after this session.
Yeah. Hey, Steph, how are you?
I'm good. How is everybody?
Having a great day. Golan, how are you doing?
Oh, Colin, you're on mute.
Oh, you're right. Thank you for that. Hi, everyone. I hope everything's going well over there.
Yeah, we've had a great afternoon, great morning, lots of informative sessions all day.
Oh, it was.
Yeah,
Another day ahead of us tomorrow. Looking forward to that as well.
Excellent.
I see we have Abby joining us as well. I will go. Oh, hello, Abby.
Hi, I was told to make sure I would mute and had my video off until I was called. So
Okay, there you go. That's your cue.
We're calling.
there you go. So
Yes.
hello, everyone.
Amazing. Hi, nice
Welcome,
to
Hi,
see
Abby.
you.
Hi.
Daphne, what is our tech email? I just got a note saying our early bird registration for the collaborative practice training isn't functioning for somebody. So maybe you could put the tech support email in the email address and reach out to that person.
Yeah, for sure. So for any technical support, please reach out to my colleague, Nicole Raymond. Her email is mec@russellalexander.com, and I will pop that in the chat as well. There we go. Thanks, Shannon. So that's in the chat for your reference as well. So we
Awesome.
apologize about that discount code not working for the CP training, but we'll make sure to get that up and running, and we'll keep you posted.
Great. Excellent. Thank you for that, Daphne.
No worries. Okay, so today we are going to watch the session Ethics and Strategy in the Legal Profession, and we are joined by Abby Adusi. Abby is the founder of Abiola Adusi Professional Corporation. She completed her law degree in England in 1993, later trained as a solicitor after taking a break to have her family, and was called to the bar in Ontario in 2010 after relocating to Canada with her family in 2008. Abby is a trained collaborative lawyer and a trained mediator. She is dedicated to her clients and uses her vast knowledge, critical thinking, and problem-solving skills to assist her clients. Abby believes in giving back to the community and is the past president of the Peterborough Law Association. And she's passionate about her clients, and what matters to them matters to her. Thank you so much, Abby, for joining us today. Looking forward to the presentation. And we are also joined by two lawyers that work with Russ at his firm, Stephanie and Golan. Welcome. So happy to see you guys. We'll start off with Steph. Stephanie has been immersed in family law for over 6 years. Over the course of her legal career, she's gained experience managing a diverse caseload, including highly sensitive matters, negotiating practical solutions tailored to her clients' goals, and advocating for both inside and outside of the courtroom. Stephanie was called to the Bar of Ontario in 2022 and recently had a successful result from an ex parte motion published on Canley. What drives Stephanie's passion is the positive difference she can make assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. So thanks for joining us, Stephanie. And we also have Golan. Golan Urin is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements, as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. Thanks, Golan, for joining us again. And we also have Russell, and if you don't know who Russell is by now, you can find his bio on our website. And hopefully
Stop. I don't want any more. Stop.
How many times have you had said Russ's bio today?
Just got it memorized.
100%.
Yeah, I probably do. Okay, so without further ado, I'll pass it over to the pros to get started with the presentation.
Let's run our first poll and get our audience feedback. I love hearing from our audience. They've been participating and playing full out today. Thank you so much. Also, thank you for sending in your questions. I think one of our presentations, we had 39 questions come in, which is just great. So really appreciate everybody playing full out and participating today. It makes it a lot easier for us to understand where your head's at, how we can tailor our material to meet your needs. First question is, how often have you been asked to represent both sides of an agreement in a family matter? This is kind of an interesting question, but Abby, back in the day, right, 30 years ago, this was not uncommon.
Absolutely. And I think sometimes it depends on where you are.
Right.
If the community is not as much, not that many lawyers practicing, you find that happen quite a lot more than nowadays, of course.
But common sense would dictate. Our clients tell us, we've agreed on everything. Why do we need two lawyers, right? Just put it together for us. And it was commonplace back then. That was my experience. How about you, Golan?
Yeah, actually, just recently I had a guy that told me exactly these words. We already agreed on everything. Why do we need to take two different lawyers? And you have to go through the whole concept of why. And I'm sure that we're going to touch on the issues of conflict right away. But yeah, it's still happening. I think it's some of it is maybe lack of education or the perception of why are we making it more expensive than it should be. So that's one of the driving motivation for clients to try and do things together, the same way that we have a joint application for divorce in a sense, which is also kind of they figured if we have that, why can we not have a joint separation agreement? But that's
the famous simple divorce. I still haven't come across one, but I know they're out there somewhere. Now, Steph, you represent the next generation of legal talent. I'm sure you've never represented both sides.
Never, but surprisingly have been asked that. I actually remember back when we were, in the office all the time and I was, working at the front desk early in my sort of legal journey. We had two parties come in and it was separating spouses asking if they could just have the agreement drawn up and, having to go through that conversation about this. That's just not possible.
they probably wanted it done on the spot too, right?
Yeah,
Like that
quick
day.
and fast.
We should just put a drive-through window in our office and, we'll hand them the paperwork and then, give
What
them
I
a-
tend to say to them is that, which sometimes quietens the voice, is that, you have, as a lawyer, one has a duty of loyalty to one of them. So, so when you kind of explain that, how can I, almost speak from both sides of my mouth and be loyal to you and be loyal to you, especially given that you're separating, right? It's a much more difficult place to be. And then sometimes the light bulb just like, oh yeah, okay, yeah, that makes sense.
When somebody comes in to set aside an agreement, that's one of the first thing lawyers look for, right? Did both sides sign off? How was this thing executed? Dress, red flags. But this is what our audience thinks. Never 25%, rarely 41%, regularly 19%, very frequently 15%. So that's interesting. I'm wondering if the regularly and frequently would be from smaller communities or more seasoned counsel. But Abby, conflicts of interest, what do we want to be considering when dealing with these issues?
Conflict of interest. So like I said, the first thing that comes to my mind is kind of the duty to be loyal to one person. So you can't be loyal to one person. You can't be loyal to two people who have potential adverse positions. I'm going to assume that all of us and everybody participating knows that the first thing you do is you do your conflict check. So I'm not going to talk about that because that seems to be like a no-brainer for us. But once you've done your conflict check in your system and you've made sure that you haven't spoken to the other party, it's kind of my position and practice to constantly be aware of the potential for conflict to come into play as the matter progresses. So we have to be constantly aware of that because we do have to avoid conflict of interest at all costs. And yes, it may be what our clients want to say, oh, act for me, act for the both of us on this issue. We have to remember that we have a duty, professional duty, to not only act and be loyal to one person, we also have a duty of confidentiality. So when you're acting for both parties, you can't be, how do you keep one thing? You'll be keeping one thing away from the other. So it's important to ensure that we always make sure that we are checking through and making sure that we are aware of conflict and a potential conflict. Sometimes I've had in a matter where I've been asked to represent, someone that I know, and that created for me that I would be in a position of conflict, not only because I know the two parties, and it's just difficult to kind of step into that fray. So I do send them away. But if you find yourself in a position where it's something, you find yourself in that position where you're in a potential conflict of interest situation, you have to speak to both parties. Either step away. First of all, you have to disclose it to both parties. That's number one. Number two is, if you are going to continue to act for one or the other of them, you must get informed consent, and you must get that consent in writing and make it clear. Your consent must be very clear, very detailed, and have both of them sign it. It must be in writing. Sorry, Russell.
No, I was just going to add, knowing the person is difficult, right? If you're practicing in a small community, usually lawyers are fairly prominent. You know everybody in that community. You almost need to live somewhere different than you practice.
And just because I was thinking about this earlier on, it's even if one of them gives you consent to act, I would suggest that we continuously go back to that to make sure it's still okay. Because what tends to happen, and I've seen this happen, is when things don't go the way the other party wants it to go, suddenly, that conflict or that appearance of conflict comes into play, they tend to forget that they had signed that consent, granting you permission to act for, party A. So it's always, even with the consent in writing, it's still always a dubious area to step into, especially in family law. So for me, in my practice and personally, I would avoid it at all costs, because it really isn't worth it. And some people might say, well, whatever, because it's that ongoing duty if you find yourself in that position, and it's very easy for things to shift. And you will, yes, you have your consent. If there's a complaint, you have to then deal with it. And, do you want to open yourself up to that? And, that's kind of a decision that the lawyer has to take.
Even the way you deliver the information that there's a conflict. So oftentimes we'll have one spouse meet with one of our associates. A few days later, the other spouse comes in and we've already been retained. But we got to be very careful on how much information we disclose, because we still have that duty of confidentiality. So it's another thing you want to be mindful of. There's also the perception, right? When we do in-court hearings, oftentimes I'm friends with the other counsel. I know their children and their wife, and we'll banter a bit and maybe joke around, and the clients get quite upset about that. They're saying, why are you cozying up to that person? Are you not advocating for me? And so you've got to be really careful in terms of how clients are perceiving your representation too. Gola, do you want to jump in on this at all?
I was actually thinking of that, the last comment you made. It's really about understanding that professionalism has nothing to do with the personal relationship with the other counsel. It doesn't mean that you cannot be zealous with your advocacy when the time comes, but in fact, I believe that it makes a better advocate when you're able to have a good relationship with the other side, whether it's going back to the negotiating table or working arrangements for the client. In essence, it actually a better constellation when you are friendly with the other side. But yeah, obviously, from client's perspective, when they see you with the enemy type thing, then it doesn't the optics of it doesn't look good to them, and it's not the but I think that it goes with some explanation to the client to understand the adversarial system, and the fact that we are all members of the same association. We're still colleagues, we're still human beings, we still have a relationship outside of the work, and it doesn't mean that you selling your client just because you know the other side. And the other thing that we're thinking, what Abby was mentioning about familiarity with clients that may come in, maybe because they're friends in the community, maybe you go to church together. One of the things that I tends to do when it happens is just offer myself as a mediator, and that's the only extent that I will. So rather than just sending them away, it will say, because you both trust me as your friend, if you take me as a mediator, I'll be able to help. And then at the end of the day, you still have to be encouraged to get your own independent legal advice to, with respect to any drafting of an agreement that we may come up with. But the idea is that you rather than sending them away and showing them that I don't want to help you, even though you are my friends, I can still help you, but nevertheless, you're going to have your independent legal advice, because that's what the law requires, and you need to be aware of your own. You have to make your own informed decision, one way or another, even if you decide to decline it later on. That's my comments on this one.
That's an interesting take. Help them structure the settlement, but don't sign off on it. Go see your own lawyers. Steph, any thoughts on this?
Yeah, I would just add to that comment you made of a perception of bias. I find in family law, if, say you're assisting a client and their new partner is actively involved in the file, what happens down the line if those two parties get together and then again, you have a returning client. So just being mindful of any apprehension or any perception of bias in the future as well.
Yeah. Good point. So let's go back to our audience. Poll number 2, ethics and strategy. How often have you signed off on an agreement that you believe to be unfair in a family law case? I remember the late great Phil Epstein at one conference said he wouldn't want his name attached to anything that's unfair. He just wouldn't do it. But I know some of the lawyers will charge a premium. They'll say, okay, well, you're going to cover off my Law Pro deductible and charge a $10,000 premium and sign off. They're of the view clients are entitled to make bad agreements. Who are we to stand in their way? We tell them what the consequences are. We give them the advice, and they want to sign off on it. They're independent adults. Let them go ahead and do it. So those are sort of the bookmarks that I see of this discussion. But let's go to our poll results and see what our audience thinks. Never, 46%. Rarely, 48%. Almost straight down the middle. Regularly, 6%. So it's interesting. The regularly one, I guess that's the group of professionals that want to respect the client's autonomy and they can make their own decisions. So thank you for participating. That ties us in nicely to the next subject matter, signing off on unfair agreements. Golan, we've thrown you a lob ball. Let's see.
No, it actually, and I was trying to reflect on it because, the poll suggests rarely, never, and whatever. I think I fall into the category of it happened to me once in my career in 25 years.
In
But
when you're in high school or what?
No, the thing is, there is a degree of unfairness of agreements, right? I mean, unfair agreement could be anywhere from giving away the farm to something that, okay, I'm giving you a little more in the equalization just to end things nicely and amicably, or maybe you're not entitled to that extra bit of payments, but I'm still giving it to you because I'm a good person, whatever the reason may be. The first thing that comes to mind, again, depending on the degree of the unfairness that you perceive from the agreement, getting the information that you're supposed to, including the background information, support obligations, length of marriage, children, abusive relationship, etc. When you get all these factors in, then what comes to mind is these red flags that may cause you to suspect the scenario there, suspect the idea of why is it that person is actually willing or instructing you, hey, here's an agreement that I have here. It was drawn. I'm okay with it. This is what I want. Please help me complete this. I wanna sign it in front of you, right? And then you ask yourself, well, somebody did that for you. You may have been coerced. You may have been under influence that is maybe unfair. So these are the flags that comes up, and that you have to ask yourself the questions and maybe satisfy yourself better as to whether or not you want to enter that kind of a scenario. So that's the one thing that I think every lawyer has to be aware of, depending again on the degree of the unfairness that you see based on whatever is being presented to you as the final draft agreement that they don't want to negotiate any further. So that's one of the things. That's one of the topics that you have to really be careful about.
Steph, what would you do? What's your take on this?
As a new call, I don't want to ruin my reputation from day dot. It's very, very a very delicate balance between ensuring you are supporting your client's goals and interests while also protecting them. I lean more towards the Epstein approach. You want to make sure that your name is attached to something that you're proud of, that you find is just and fair. But then again, going back to what Golan mentioned, there's sort of a degree of what is unfair. Is it, very low scale? Is it massive? So just always something to be mindful of when going through agreements with your client, understanding what your client's objectives are, and just always turning back to that.
Great stuff. Abby, thoughts?
Yes. First of all, I wouldn't put my name to any such agreement, and I just wouldn't do it. It just kind of doesn't matter, the fees. I echo Stephanie's point on that one. I wouldn't put my name to it, and I wouldn't put my name to it for a couple of reasons. Number one, I know that Golan mentioned the degree of unfairness, but when I look at that topic in itself, I'm thinking what the court would deem to be unfair. So that means it's unfair. And having participated in undoing some of those agreements in my career successfully, I know what the names of the lawyers that have their name to it. I know how the names have been bantered around in court. I don't want that for myself. And when it's deemed unfair, you are likely to get it overturned. And then not only is your reputation ruined, or not ruined, but kind of reputation kind of sold somewhat, your name sold somewhat, then your client no longer has confidence in you, notwithstanding they forget these things. Like they said, I don't care, I want to sign it. And then that becomes an issue. This particular one of the ones that I've been involved in that comes to mind is where they both had lawyers, but it was clear that the equalization payment made to the lady I later represented was based on what the husband could afford, and those were in court materials at the end of the day. So you do not want your name attached to something that could call your reputation into question, because the very next day, or lo and behold, the very next afternoon, you might be standing in front of the judge that has just heard the matter about your the deal that you've put your name to. So yes, be careful. Do it if you feel confident, but for me, I would not do it.
Yeah, there's a lot to unpack there. I've set these agreements aside and cross-examined the counsel who signed off on it. He had a notified law pro, he had his own representative. It was a completely uncomfortable afternoon for him testifying. He testified longer about the agreement than he did spending time with the client. He spent I think that he spent 15 minutes with the client. He was in the witness box for an hour and a half. And it was just a terrible, terrible experience for him to go through. The agreement was finally set aside. But I guess, the analysis, is it objectively or subjectively unfair, right? We can apply the legal framework and know is it within the goalposts.
That's right.
But for a while, I was seeing these agreements where clients, usually the husband, would pay a premium, 25% or so. Could have been infidelity or whatever occurred. They wanted the thing done. They wanted to move on with their new girlfriend. They didn't want to litigate. And they willingly paid a big bump just to settle the case. So that's something you got to respect, those instructions at some point. You can't just walk away from every client who you disagree with. So I guess there's certainly a dichotomy there. Kind of leads us into our next subject, which is losing objectivity, mixing business with pleasure. We all know Law Society has reported on some lawyers who've slept with their clients. Really, I don't know how you can be objective when you're in a relationship with your client. It's frowned upon if you're acting for friends or family members, let alone somebody who's going through the divorce as well. So that's certainly, those decisions are reported. You can take a look at those, but it's certainly an easy way to ruin your reputation and your career. I see a lot of clients, a lot of lawyers who emote their clients' behavior and take it to court with them. And they believe their clients' statements, no matter what they are, and they actually get upset, like their clients have been getting upset. And I often say to them, you don't need to emote your client's behavior. You're supposed to be neutral and objective. Don't get angry at this case, right? You're losing your objectivity. And then representing family and friends, bad idea. Not only are you probably not going to get paid for it, or you're going to do it at a reduced amount, but again, you're probably not going to be objective. If you're representing a parent or a sister or a brother in a divorce proceeding, you may not be giving them the advice that they need to hear. You may not be giving them the bad news that lawyers should give their clients if their case is going badly. So that's what I'm seeing when counsel lose their objectivity. But Golan, what have you seen?
Well, one of the things on family and friends, you can also look at what the advice to lawyers not to represent themselves. It starts from that same emotional stance that you may lose that objectivity, and you would rather have an outside lawyer take care of your matter, even if you're doing a family law and that's all you do, or criminal law and that's all you do, and all of a sudden you are embroiled into a similar situation and you think you know everything. It may be better to step aside and let the outside counsel to deal with the matter. So definitely the losing of objectivity can come in different forms, whether it's the relationship with your clients, whether it's the clients that are not related, clients that are related, whether it's a family, friends, and definitely something to watch for and try to stay away from. That's the bottom line. You have to stay away from that.
Abby?
I totally agree with Golan. You have, stay away. You cannot be as vigilant as you would normally be. You're not able to assess the matter or the issues as you would normally be able to normally. And, the idea of having a relationship with a client is just not even part of what we should do in our rules of professionalism, and that there's a reason for that. Because you have no objectivity at all, like really, like none, is non-existent. So you don't have the capacity to do your job as well as you should be doing it. So you should not be doing that job. You can't be impartial. You can't see the fairness in it. And quite frankly, not because you don't want to, it's just because you can't because of that relationship. And the same goes for friends. We should try and stay away from acting for friends and family as much as possible, because who's ever had a sister or brother get divorced? Even when you're not involved, they want you on their side. They want you to say their bad behavior is okay. And you can't really do that successfully if you are a member of the family and representing them in their family matter. Best to stay away, refer them out, and assist them emotionally in that way as a support system rather than be their lawyer. It never ends well. You may lose your family in the end and they still not pay you, especially if the matter doesn't favor them. So that's what I would say to that. Stay away.
And depending on the relationship, you may even get called as a witness.
Yeah.
Then you're going to have to be disqualified as counsel at that point.
It
almost reminds me, I'm dating myself, of that movie War of the Roses, where the wife comes into Danny DeVito's office and tries to seduce him. And what a scene that was.
Yeah.
Steph, any thoughts on this before we move on?
Don't hate me, Russ, but I have no idea what movie you're talking about.
You didn't even know what Top Gun was when we started the firm.
Well, I knew what it was. I just hadn't
It took
seen
us
it
3
yet.
years to see Top Gun.
I knew it, I didn't watch it. No, my articling principal warned me of the same sort of thing before I was called. And sure enough, I'm not sure if the three of you experienced that, but as soon as friends, family members of friends, discover that you've been called, that you're officially a lawyer, I had people reach out and, what type of law are you practicing? Can I get that family and friends discount? And it's just one of those things that, your friends or your family members might not understand those rules of professionalism and those sort of duties that lawyers are obliged to follow. So it can be a maybe uncomfortable position or conversation to have, but one that needs to be had nonetheless.
Yeah. Again, lots of great questions coming in from the audience. Thank you. We're also going to have a poll for you in a few moments. One question that came in: if you are representing a husband and wife jointly in a real estate closing, then can you represent the wife in family matters? That's interesting. Usually, sometimes the divorce lawyers will do the real estate deal, but usually I would always get permission from both parties and the other counsel to do so. And I would give permission. It's more convenient. But what if you did the real estate deal first? What do you guys think of that? Going, can you then represent one of the
Well,
parties?
that's actually I'm thinking as the question comes in, and I'm like, I think the safest way would be to get a waiver from the other party in any event. And again, it depends on what went on during a transaction like that. Is that something that discloses sensitive information that may be used later on against the other party? So I think the cleanest way would be not to do it. The safest way, if you decide to do take it, I would say a waiver definitely is needed from the other side, consenting to your representing the other side in the matter. That's kind of what comes to my mind right away.
Maybe the issues involved too, right? Maybe a joint application for divorce that's just filing paperwork as opposed to something more substantive. Abby,
Right.
thoughts on this question?
I think I agree with Golan. I wouldn't as you were asking the question and as Golan was answering, I'm reminded of a matter that I was involved in. And so that I don't want to be like a Debbie Downer on all my questions and answers here. I would say in this one, perhaps it depends. Okay, but you must get consent. And the reason I say that is because I had a situation where this law firm had been representing the parties in real estate deals for many years, buy and sell, buy and sell, buy and sell. So they had a lot of information about both parties. And then when it came down to separation, they started acting for one of the parties. And my client's complaint, rightly so, is that they have so much information about me that they're holding in their back in the day where everything was in paper form that they have. And, are they using some of that information against him in terms of when they buy and sell, where the equity goes, which account the equity is, how the money is being dispersed for their constant real estate transactions that they were doing at the time? In that situation, it would have made sense for the law firm not to have acted and just stay well clean. If anybody needs any disclosure as it relates to the real estate transactions over the past years, just provide it and step away. But I think deciding to act from one party created an unnecessary wrinkle in the whole family matter. And the other thing that happened in that matter was they did not actually obtain my client's consent as to whether or not they could act for their ultimate client. So it became very messy. And, as we all know, family matters are not exactly neat and tidy at the best of times. Why would you want to add that extra layer? But if it's just a regular family, we bought and sold one property, probably lawyer never even met them until signing, and things like that, maybe one would consider it, but making sure that both parties do sign a consent that they can act for one or the other party.
Yeah, great tip. Thank you for that, Abby. All right, staff, 24-hour rule. What do we need to be thinking about here? Good
Yeah,
practice.
absolutely. I found that clients have a tone or an expectation of tone that they want their lawyers to get across in correspondence. And as counsel, it's our job to have those transparent conversations with our clients as to, what are the other alternatives? Can we look to approach the matter, the correspondence in a different way? What's the true message that you want to get across? And does responding in an adversarial tone hurt or hinder the possibility of getting, what the client wants to accomplish? At the end of the day, the lawyers will walk away from the file, but the parties might have to still continue to deal with one another, especially when there are children involved. So when I find adversarial letters come in, or my client wants to send one out, to have those conversations with your client and to remind them, if their goal is to reach an agreement or resolve an issue, but on the same sort of note, they want to pick apart the other party's actions, or they want to come to the table with like thick armor, just reminding them we have to think about how that might impact the temperature of a file. How will the other side respond to that? Because when the other lawyer, or if they're a self-represented party, when they receive that harsh or, aggressive correspondence, and that temperature just keeps rising, is that really going to help your client achieve their goal? So I find the 24-hour rule to be such, a great rule to utilize, because it's very, very easy to get upset and defensive when receiving a letter that's combative or includes claims that are contrary to your client's perception. And it can be increasingly difficult when you have opposing counsel who's, maybe just acting as a mouthpiece or, conveying whatever it is their client wants them to say. So as lawyers, we have to remember those rules of professional conduct, and it is our rule to be courteous and to be civil, and, not embarrass the profession, not use language that, makes you look, evil. So taking a moment to step away, work on another file, brainstorm with other associates or mentors, and then come back to that correspondence with a fresh perspective can often alleviate that urge or the natural reflex to respond defensively, or with an equally combative tone. I also find that stepping away and using that 24-hour rule, it allows my subconscious to work in the background. So, I can gain new ideas, new perspectives, strategies on how to respond. And those other alternative approaches, you can discuss those with your client, and really ensure that you're drafting a response that's going to be productive to their goals, and what they truly want to receive. One other thing that I've sort of added to this 24-hour rule, especially when receiving very nasty letters or correspondence from opposing parties or sometimes opposing counsel, is to be a buffer for my client. So before providing the letter to my client, I'll call them up, let them know that a letter's come in, go through with it, go through the letter with them over the phone, reminding them to see past the tone and focus on the substantial points, so that we can really narrow down what are the issues, get rid of all the fluff, get rid of all the anger, so it softens that kind of jolt reaction from my clients. I find that's really beneficial for, potentially getting a file on track and ensuring that temperatures continue to lower instead of rise.
And with email, it's so easy to send, just hit that send button, right?
Absolutely.
Every
So
time I
fast.
wait 24 hours or I ask my clerk to look at it, the next day I always change the letter, something in the letter. And sometimes I'll get a letter that's particularly nasty. I'll phone the other lawyer up and say, what's going on? And they'll say, yeah, I had to write it for my client. It's not for you, right? How to placate the client because that's the letter they were demanding. And you can usually tell when the letter's written for the lawyer's own client, not for you to respond in any meaningful manner. But Abby, what do you think of this 24-hour rule? Good practice?
Absolutely. And I think I agree with you. As you may recall back in the day, if I was asked by a client to send us such a letter, even after
you would phone me and say, this is coming over.
Yeah, exactly. Do you remember? I would phone and say, hey, Russ, letters coming, just so you know.
I'm instructed to
I'm
send
instructed
you a
to
letter.
do this. So
Yeah.
by the time the letter gets onto Russell's desk, he's not jumping up and down. That's how we used to do it back in the day in our community. But so I would do that, and now still I probably would still do that whether I know the lawyer or not. And what I find is that the lawyers would appreciate that call. Because you're not coming to them in an adversarial manner. Now, I guess as you progress and advance in years and in practice, you learn and you do better. Being a mediator, being a collaborative trained lawyer, I don't rise to those occasions as I used to when I was younger or only litigating. But we're all human. So if I get such a letter and I'm like maybe on a 3 p.m. on a Friday afternoon or something like that, I would do what Russell said he does. I would dictate it so that I get it out of my system. I wouldn't send it, but I'll dictate it because otherwise I'll be thinking about it all the time. But once I put it down, then I can walk away from it. Then come Monday morning or Sunday evening or whatever, and I go back to it, I'm like, yeah, I don't really feel like that anymore. Then you start over. But so that it doesn't eat me up over the weekend, or I get annoyed, or I'm like, what is it thinking? Whatever. I would just respond, put it down, and get it out of my system. And then wait the 24 hours or whatever to then deal with it. And if I'm going to send it to my client, I will preface that by a phone call to my client, to be fair, so that they don't receive this and, the ex in the background is getting some sort of reaction, or the kids are getting a backlash or whatever. So I'll phone them and say, this is happening. I have spoken to the other lawyer. Well, this is how we can deal with it. So I diffuse it before my client gets that letter. But I will share that letter, because I share anything that comes in, I share it with my client, because it's your matter at the end of the day. So those are my thoughts, Russell.
With AI, you can just cut and paste it, say, make this more professional, empathetic, and in compliance with the rules of professional conduct.
Well, there you go.
Letter for you, but
there you go.
It's also,
Even
though there's 56,000 lawyers in Ontario, it's an incredibly small community. So this is one file, one letter. You're likely going to be working with this lawyer for the next 25 years. Your letters are going to set the tone of that relationship. But Golan, what do you think?
Yeah, I was just thinking about that, because I think Stephanie was talking about clients being that the heating between the atmosphere is between the clients, and I'm thinking, think about those of us with short fuse and just wanting to stab, in cold blood the other lawyer just because they don't like his looks, or they don't like his glasses or whatnot. So the idea is, firstly, the rules of civil of professional ethics requires us to be civil. That's out of the question. It's not. It's a given. So the idea of the letter, and
lawyers could be civil and sarcastic and mean spirited all at the same time, right?
Right. That's the beauty of advocacy, right? You can say things and you can read between the lines. But the thing is that, and so two points here. The first one is the code of, it's for my client. C copy client tells you everything. So when you have a letter, a nasty letter, that at the bottom of it you see C copy client, I'm like, I don't ever write on my letter copy client. I don't need my other side to know what I'm communicating with my client and whatnot. You can assume that it's been approved or not. It's your choice. But I see that was an old-fashioned way of putting of showing that who am I copying, who's communicating on this email. So that's the first kind of clue that you get, apart from the fact that what you can do is, firstly, if it's personal attack, which is different than showing a disregard to your clients, a respect or anything of that sort. That's two different topics, right? Because a personal attack, you feel the need to answer right away. This is where your blood may boil, right? That's where the 24-hour rule is absolutely necessary for you to calm down, cool off, and then see again clearly whether you want to respond, whether you want to mild the tone of your response, and whether the law society needs to be informed because it was so outrageous. So that's you have various options that become available. I would rather you talk to other counsel before you go to the law society, because it's a matter that has to be resolved. To kind of bring to the attention of the other side that it's not appreciated and it's not the relationship you want to have with any lawyer. And this is just one more file. So that's one of the things. And then when a lawyer starts writing back something, it may cross the line to anything from being uncivil to sharp practice to anything of that sort. Once you start making claims and allegations against your client or against the other lawyer, this is where things get muddy. And this is where things that you want to avoid, in terms of you want to keep your composure, your professionalism, and stick to the merits of the case. One of the things that I wanna take another few seconds, if I may, Abby, I think Ross, even you and I had a discussion over what is it that the clients must be receiving from the other side's communication. My take on it was, I can rephrase whatever information I'm getting. So if I know that that a letter is coming in to intimidate my client and cause him to change his position from one end to another just because he's learning of this aggressive behavior of the other side. I don't see it as I need to send him exactly that with the tone and everything else that's been said in the letter, but rather I will make the reporting letter to my client. Here is the position of the other side, 1, 2, 3, 4, and take the nastiness out of that. You really take the edge out of that correspondence that came to you. I don't see that as an incompliance with any rules that requires my client to be informed with anything that happens in his matter, as long as I provide him with all the information. But I don't need to, load. Is already emotionally charged. Why do I stress him more with just because another lawyer wishes to take control over his mental state and cause him to change his position, etc. So that's the way that I deal with such extreme situations where I don't think that a client needs to hear it or to read it, verbatim, as opposed to rephrase the topics and the letters and just convey the information in the way that you feel is the right way to do. That's my comment on that one.
I want to be mindful over time. Let's get into when trouble comes, and it comes. Golan, I got you talking about this one. This seems to be your specialty tonight.
But you make it sound like I'm getting in trouble all the time.
No, not at all.
No, I'm just thinking, listen, if you've been around long enough and you appeared in court and you dealt with other lawyers and you dealt with clients, those who don't make mistakes. Those who do stuff and always busy, there's going to be some rubbing against another colleagues that may not be pleasant. One of the things that you can experience is complaints from firstly, you can experience that right at court with impression from judges, the way that they may be speaking with you, the attitude. And let's not forget, everybody's human, like we mentioned before, and some of us may get up on the wrong side of the bed. And one of the things to avoid, and I think that takes away from the nastiness or the bad attitude, is if you come prepared to court, that takes away that edge of there's no reason to be mad at you when you are really know the facts and and prepared. So you can stick to the merits, you can stick to the arguments that make sense. You don't have to fall into a discussion or what we call a pissing contest with a judge. It's never going to end up well. It's just going to I don't think it's going to serve your client well. That's the bottom line. It's not going to be there. And we spoke about reputation before. Well, this is your reputation. Your reputation is in court, and judges make a impression of you and may discuss it later on over lunch with other judges. And everybody likes to gossip. I think judges are just the same as everybody else. The extreme, and I've seen that before, is judges that made a referral to the law society to complain about another lawyer. That's another situation that may arise. So you may now be dealing with the law society with a complaint because it was referred by a judge. Obviously, it's giving the attention that a judge would expect it to receive. So you really have to. It doesn't mean that you have to capitulate on your arguments. It doesn't mean that you do not need to be zealous or make the strongest argument you can for your client. But it means that you do not need to fall into unnecessary argumentative discussions, whether somebody's disapproving of something you did or anything like that. You can always stick to your points, be respectful, get your point across, and everything is on the record. So when the time comes, if it ever needs to be reviewed or appealed or anything that you need to refer to, it's there black on white. That's my
That's a
suggestion.
great point. I would preserve the record. So judges have bad days too. And I've been taken over the coals a number of times. It's important to, if a judge is raising his or her voice, that you indicate that on the record, because if they order a transcript, they may not, if they get the audio, they'll hear it. If they order the transcript, that won't come across. If they're not allowing you to make proper submissions when it's your turn, you need to put that on the record as well. Basically, you're preserving the record in case the decision needs to be appealed. So not only what you're experiencing in terms of submissions, but your client's right to be heard, the judge's demeanor and decorum, you should repeat that back and mirror the judge. Just say, I hear that you're raising your voice over this particular issue, and the record will reflect that. And if necessary, the audio version of the transcript can be ordered as well. So I think that goes just to preserve the record. Poll is, have you ever faced a situation where you had to respond to a complaint from the Law Society of Ontario? And let's see what our audience poll results are for this one. It'll be interesting. Yes, 38%. No, 62%. Interesting divide. Well, Law Society complaints. What do we need to know, Steph? I hope you're not an expert on it, but certainly talk about this.
Not an expert, no, but something that you actually, speak about and encourage all of our associates to do is to normalize Law Society complaints. Especially working in family law, we're dealing with highly sensitive matters, people's lives, their children. And unfortunately, sometimes the outcome is not what the client had hoped for. And their instinct is to blame someone, to blame their lawyer, even if their lawyer had no control over it. So if you happen to receive a complaint, whether it be directly from the client or the Law Society, some things to remember is to always deal with it right away. You don't want to have to ask for an extension, or you don't want to push it to the side because it's scary to face. I'm sure it's a human reaction to want to avoid something, especially when it's daunting or terrifying, but you can actually get yourself in more trouble by not responding. And when you are preparing your response to a complaint, it's always best to be honest, respectful, and extremely detailed. Review your file, your notes, emphasize your legal strategy, and from day one of having a file, keep record of everything, of your discussions with the client, any instructions received, whether they be over the phone or in writing. If you had a telephone call with a client and they provided instructions over the phone, always follow up with an email outlining what you discussed. Ask them to confirm their instructions again in writing. Just making sure that you're doing your due diligence throughout the entirety of a file so that if something were to come up down the line, you have everything readily available. Another thing to remember, and it kind of goes back to, this duty to be civil and courteous, especially when emailing your clients or self-represented parties, other side, whoever it may be, is to be polite and respectful in your correspondence. If a complaint comes in, the Law Society will see your emails. They'll see your correspondence. So you can take an informative, position. You can take a strong position while still being respectful. And sometimes Law Society complaints don't come from your client, but from the other side. They may be acting out of spite. So always being respectful in your communication and how you carry yourself is important, because at the end of the day, you are representing the profession. And the last sort of tip or maybe recommendation I would say when responding to a Law Society complaint is to lean on your colleagues, your mentors, get an objective perspective on how your response is perceived by an outside party. The person handling and making the decision about your complaint, they're not going to have the knowledge or the details of the file. They're not going to know it as in depth as you do. So obtaining that objective perspective, having a colleague proofread your response can ensure that you're conveying a compelling response and you're being, as thorough as possible and leaving no holes open. So those are sort of my tips.
Great tips. When I got my first complaint 3-4 years out, I thought the world was going to end, right? Oh my God, what's happened? I went to law school, now I got this complaint. called up my articling principal. He goes, listen, if you're not getting 2-3 complaints a year, you're not busy enough. It's just the nature of doing family law. Eventually, you're holding tail this tiger, going to turn around and bite you, or the other lawyer eventually. So 30 seconds or less. Abby, reporting law pro claims. What do we need to keep in mind?
We need to keep in mind that we have to, if there is a potential, I'm going to echo what Stephanie said right there. Speak to a senior colleague or a senior lawyer and just check in whether this is something you should self-report. Because if there's a tendency to not self-report and it becomes a bigger deal, the consequences are very dire. First of all, you could lose your insurance coverage and where you can't practice anymore because without it, you can't practice as a lawyer, and we all cherish our certificates and the ability to practice. So self-report if necessary. Check in with a mentor, check in with a senior colleague and say, this is what I'm experiencing, what should I do? And self-report, do it immediately, because when you self-report, you have to tell Law Pro, when did you become aware and when did you report? So that gap in the timelines will become important as to where you're trying to hide, and you only reported when things have got out of hand. You could get into a disciplinary action with the Law Society as well, and you don't want that. If there's financial issues there, you could get into a financial liability, especially when your insurance now has become in question, or you lose your coverage. So there's a financial liability that you could expose yourself to. And also, your reputation. We've talked about that all along throughout this. Your reputation is something that, we all cherish. We all want to guard with everything that we have. So, and that becomes something nobody wants to be reported in the newspaper about how they've acted or conducted their file and failed to report when they noticed an error. Do I have more time to continue?
No, that was really good. But thank you. It's easy to report. They're on your side. If you're at all have any doubts, report it. And if there's an error, they'll mitigate the damage and hire a lawyer for you. So it's a good thing to report it. So what I'm trying to get away. Hire experienced counsel when trouble or law society knocks on your door. That was a great summary, by the way, Abby. You want somebody with experience, who's dispassionate, who knows the workings of the law society. You want to be able to cooperate with any requests the law society makes, but still protect your rights and your reputation, your career. So a lawyer can say, yes, I'm going to cooperate with, this person's going to cooperate with your request, but with the following caveats. And there may be disclosure issues, privacy issues, a whole bunch of issues that could come into play. Some great counsel that do work defending lawyers at Law Society tribunals: William Trudell, Gavin McKenzie, Peter Griffin, that Lasner Slate, Brian Greenspan. Just ask around. There's great lawyers there to assist if you ever need help dealing with any trouble that knocks on your door, and you think certainly to have that objective counsel is important. Final topic: role of mentors and colleagues. That's you, staff, and then we'll get a final send off from everybody, and then we'll get everybody towards that. We'll do the early bird draw and get everybody off to dinner and ready for tomorrow.
Absolutely. I would just say that establishing a network of mentors and colleagues who you can trust, who you can go to for advice, is super helpful, not only as a new call, but for lawyers at any stage of their career. I quickly discovered, we're always going to be learning. You're never going to know everything. You might not experience a certain legal issue until years into your career. You might have a new client personality that you find challenging to navigate. So having other lawyers you can turn to is super important, even if it's just for your personal sanity. It doesn't mean sole practitioners don't have that option as well. You can join groups, practice groups, social groups, network as much as possible. If you are in a firm, lean on your colleagues, establish those relationships. And don't count opposing counsel out. You might have an opposing counsel on the other side. And, once you're done with dealing with that matter, they can become a great resource, a great professional relationship in the future. So again, tying back to always being courteous and carrying yourself with grace, it's really going to help you expand your network and make those connections that will help propel your career.
Great stuff. Golan, Abby, any final thoughts or tips?
My
I
last
thought,
one.
I thought,
Oh, sorry. Go on,
sorry, Abby.
Abby, go
my,
ahead.
my quick 2 cents is just for generally speaking, for lawyer to draw encouragement from the last poll that 40% of them were somehow reported to the Law Society. You can imagine that only a fraction of it, if anything, is actually true in terms of malpractice of any kind. But 40%, that tells you if statistic plays a role in this group of 150 or 200 people that are watching us and participating, it tells you a lot about the frivolous complaints that coming through the Law Society, and much of it has to do with how do I get leverage to get my money because I did not get him the result that he wanted, or I don't like this lawyer on the other side, and this is what I'm going to do to him because he got his client what she wanted or he wanted, but I ended up with the short end of the stick. So just that's my comment on that topic. Mentorship, always a great thing, and people should always have somebody to go to and get advice on.
So I hear you saying, so Golan, there's solace. We're not alone out there. Everybody else is going through the same stuff. Abby?
Yes, absolutely. We're not alone. On the mentorship is just what I wanted to just make one last comment on. I totally agree wholeheartedly with everything that Stephanie has said about why you ought to have a mentor. I have mentors. I've had them since the day I started practicing in Canada, and you never get too old for it. But apart from the knowledge, apart from the networking opportunities, apart from the professional guidance you get, I find the emotional support very, very useful. We are all going through a lot of stress. So just the idea of having to speak to someone, especially in before, but in the light of COVID, speaking to someone about what you're going through over a cup of tea or something like that makes a lot of difference and helps with our emotional support. It helps you sometimes to build your confidence as well. Someone says to you, you're doing okay, and you're panicking and you're doing okay, boost your confidence. It's not knowledge transfer, but it's just that emotional support that we all lean on each other for. And I think it is a good thing.
Great tips. Thank you, Abby, Golan, Steph. Excellent presentation. And Shannon's back. That means we're going to wrap up day one.
Thank you so much, Stephanie, Abby, and Golan. Really great insights. I feel like a lot of the things that you mentioned too can apply beyond the legal profession too. So thank you so much for sharing. And thanks to all of our speakers today. We had a really great lineup and looking forward to another great day tomorrow. I did share in the chat, there's a link there that you can go to our website, see what's on the agenda for tomorrow, and register there if you haven't already. We are going to wrap up with the early bird draw in just a moment. But I also want to mention, we love to hear from our audience always. It allows us to get insight into your experience so that we can continue to improve, further develop our program. So there'll be a survey that pops up at the end of, or whenever you log off the call, and you can share your feedback there if you have a few moments. And also want to thank everyone for their generosity and support of the Denise House today. We have moved the dial up with our donations. So thank you so much to everyone who has donated and for everyone who has supported this event.
All right. And certainly thank you to the speakers today. Everybody was just spectacular, including the ones we have on our screen. We're going to talk a little bit about day two tomorrow, but do you want to go to, what do you want to do first, Shannon? You want to do the early bird or you want to talk about day two?
Let's do the early bird so we can get that done.
Daphne, are you controlling the wheel and figuring out who's going to be our prize winner?
We have Nicole on the back end working some magic. So I don't know if anyone has a drum roll for us while we get the name in, but we need some sort of theatrical drum roll. That would be great.
That was my drum roll. I don't know if you heard it or not.
Okay, so it looks like we have the name that just came in. So The winner of our early bird is Maham K. So we will follow up with you, Maham. Congratulations. We'll follow up with you for your prize. Thank you so much for registering, and thank you to everyone who has registered and participated today.
All right, and so we're back at it tomorrow morning, 9 a.m. Is that the plan?
Yes, so we are back at 9 a.m. tomorrow. We have Adam Cordover, who will be doing a presentation on all the ways to collaborate, examining different models of collaborative practice. And then we have a lineup of quite a few presentations throughout the day, all 1 hour after that. So we have risk factors in family violence with Michelle Mulchin, Jonathan Painter, and Amrit Malhotra. We'll come back after that and have family law financing with Tim Andrews of Bridgepoint Financial, one of our sponsors, Carrie Heinzel and Natalie Derbyshire. We'll then go to a presentation on embracing the 2S LGBTQ+ community in our family practice with Jane Huh and Sarah Rutledge Fisher. We'll make sure to give everyone a nice hour-long lunch break to eat and do whatever you need to do. Then we'll be back in the afternoon with Jason Kokowski and Melanie Russell for 2 presentations on certified business valuator reports and attribution of pre-tax corporate income. And then we'll finish off the show. I can't believe we're already halfway there already, but we'll wrap up with how new advances in AI are shaping the legal profession. Russ will be joined by Pamela Wickersham of Supio, Monica Goyle, Caravel Law, and then our very own Daphne Brooks, our Director of Marketing. So, and our lovely co-host today. So looking forward to hearing from you all tomorrow.
Wow, what a lineup. What a day. Great job, Daphne and Shannon. I know there's a lot of work that goes behind the scenes in putting this all together. Super excited about the money we're able to raise today for Denise House. I think we're over $5,600. So 60, what's the number? 60 something?
60, just over 6,300.
All right, so keep the donations coming in, big or small. Click the link, GoFundMe page, super easy to donate. You get a tax receipt, everybody wins. And I think that's it. So anything else we need to cover off?
No, looking forward to hosting everyone again tomorrow. Thanks, everyone.
Thank our audience and everybody watching live on YouTube. Everybody's played full out, answering the polls, sending in it's great questions. So I'm looking forward to seeing everybody tomorrow. Have a great night, everybody.
Bye, everyone.
Bye.